It is 9:11 a.m., November the 21st. The meeting of the Texas Appraisers Licensing and Certification Board Orientation and Training Session is now in session. A brief overview. You know, we've been talking about this for quite a while, and a lot of people have had input, other board members have had input about ideas of how to better inform board members, make board members more productive, more knowledgeable about the appraisal industry and about how we came to be. How did this board come to be? What's our job? What are we trying to accomplish? What's our big objective? And this is intended to be an open exchange of ideas and just questions about, you know, things you don't understand, particularly for new board members. I think it's a real, for me it was at any rate, just a kind of a cloud. You're finding your way around geographically, and then what can you do and what can't you do. And the whole open meetings process is something that, from my perspective, I had no background in. So with that said, Carrie and Doug put in a tremendous amount of time in putting this together. And so we have to give them our appreciation for doing all this background and putting this agenda together. And I don't know, are you going to do step by step, or is Carrie?
Do you want to just?
Oh, we're going to do a roll call.
Do the roll call, and then we can just go to the agenda item.
Okay, we'll do a verbal roll call. Walker Beard, board member.
Mark McAnally, board member.
Nancy Fuller, Office of the Attorney General.
Ellen Samuth, Office of the Attorney General, General Counsel for the board.
Clayton Black, board member.
Jenny Whitcliffe, board member.
Shannon McClendon, board member, public member.
Laurie Fontana, board member.
Patrick Carlson, board member.
Carrie Lewis, acting general counsel.
And Doug Oldmixon, I'm the commissioner for the board. And then
Tony Slagle, government affairs for the board.
Okay. Wonderful. I want to cover just a couple of administrative items and about the schedule, and then we'll dive right into the kind of the history of how we came to be, how the board came to be. So first of all, I want to tell you that at lunch, when we take a lunch break, so there's sandwich orders on the table, so please place one if you like by 10 o'clock or first time through. Look at that.
Sorry, I didn't mean to.
There's actually openers in the kitchen. There's coffee in the kitchen. There's water as well on the tables. Anytime you need a break, of course, the bathrooms are in the hallway opposite each other. Men's on this side, women's on the other side. But when our lunch arrives and we reach that point that we take a break, sometime during lunch, it won't be a part of it, will be adjourned from the meeting, but I want to share with you the prototype of the new website. Okay, so we've been working steadily for 18 months, really, on not just on the website. It was almost a whole year just to do the evaluation of what the website needed to be, what it was today, who uses it, all that kind of stuff, and then some organizational things. And we've been working on the design parameters for the last about 4 or 5 months, and we're fairly close to a point where we're going to be able to, hopefully, certainly before our February meeting, actually launch the board's website. And once the board's website is up and running, then we will turn our attention to the commission's website. So we'll do that over lunch, and that includes some rebranding things. The other thing I wanted to share with you, and I have Mark's permission to do this, is some bad news, and that is a situation that requires your best wishes and prayers if appropriate. Mark Murnack has been diagnosed with cancer. He has a particularly, for a young, healthy ex-Marine Air Force JAG type, highly unexpected event, but he has cancer in one of the glands connected to his liver. And so he has been, it's a fairly unusual, not just for his age, but unusual place for that to occur. And so he has been meeting with oncologists and trying to work out what his treatment options are and all that kind of stuff. And it's probable that he will go into, at least initially, an in-residence program, like at the Mayo Clinic or something like that, because it's an unusual thing. He's actually going to be in this morning to meet with his team and bring them up to speed and kind of set the ground rules going forward. But of course, he take whatever time he needs, and he has FMLA rights, and all those kinds of things. But he's a highly valued and productive member of your team, and so please keep him in your prayers, your thoughts as well.
Doug, is he going to stay an employee as long as he possibly can through that and take after FMLA, take like long-term disability or whatever else, so that he has the support of the agency?
He has both the short-term and long-term disability if necessary, and depends on the course of treatment. Probably some of it will be, test experimental, kinds of things. And of course, all of this really depends on whether or not the cancer is spread, and that's the big thing that is still an unknown. Is it highly localized or has it spread?
And so is Troy going to be acting as director?
Troy will be acting director.
Okay. I thought that's kind of what we heard
During
yesterday, but
Yeah.
And at this stage, we don't know stages,
Nothing.
like 1, 2, 3, 4, kind of a...
Nothing yet. I may take a break at some point or during one of the breaks and stop over and visit with him when he's having his team meeting. Okay? But I wanted to make you aware of that. Okay. So if you would, just go back with me in history, and I'll try to make this part short, not more than about 10 minutes to get us up to the founding of the board. But none of us are old enough to remember the Great Depression, but certainly many of our parents lived through that. In 1939, the very first real estate license registration scheme was created in the state of Texas. And that was partially in response to the creation of the Federal Housing Administration as one of the alphabet agencies during the Great Depression in providing insurance for mortgages that allowed more people to become homeowners. Because prior to that time, it was, as today we're like we flirt around 65%, 2/3, right in those numbers. But prior to the Great Depression, it was reversed. Less than 1/3 of Americans owned their own homes because there was no standard mortgage practice, if you will. You borrowed from a local bank on whatever terms you could get, high cash down, requirements, character, credit, and collateral. But what was the collateral worth? Whatever the bank said it was worth. There was not the folks who dealt in real estate had formed the Association of Realtors, the National Association of Realtors, what it came to be around the time of the First World War, just before the First World War. And they were the, quote, real estate dealers and the real estate experts. And so starting in 1939, in order to appraise property, set a value on property for purposes of lending, you had to have a real estate license, because those were the experts. Over time, of course, the creation after World War II of the VA with a guarantee fund versus insurance, and the development, which really accelerated in the late 70s and early 80s. Well, first of all, in the 50s with the creation of Fannie Mae, which was to create a secondary market, the first secondary market for VA and FHA loans only. It was just government guaranteed loans. That was the only secondary market there was. There really wasn't one in private loans until Freddie Mac was founded in the 1970s. So for non-guaranteed loans, commonly today called conventional loans, Congress deemed it necessary to create a secondary market to allow banks to move some of that risk off their balance sheet and into an structured investment market. And that was greatly aided by the creation of the securitization of loans. And the first time that was allowed was, I think, the 1981 TEFRA, whatever, that's a Budget Reconciliation Act at that time. And of course, that also included the deregulation of savings and loans, the kinds of investments that they could do, and everyone knows here in Texas, because we fell first and hardest. Every single savings and loan in the state failed. Some of them were consolidated into others, but essentially that industry was decimated, not because of the securitization of home loans, but the deregulation of the kinds of investments that they could make. And so that leads up through the great calamity of the 80s, and what was the reaction to that? In 1989 was Title 11 of FIREA was passed, and that required the certification of appraisers. One of the benefits, much like if you look toward Dodd-Frank and say, you know, what safeguards can we put in place so we don't do this again? So one of the safeguards was to set a standard for certification of appraisers. Up to that point, in the industry, appraisal had become a subspecialty, if you will, of real estate. It had, through professional associations, especially the Appraisal Institute, adopted voluntary standards, very, very high standards for the rules of how to appraise property, the ethical standards, all of those kinds of things. But it was the Appraisal Institute as a private professional association that set all of those standards and issued what's the right word for designations? Yes, designations, private designations. So you were a master of the Appraisal Institute, an MAI appraiser, or you were a SRA, and I forget what that stands for, something residential, and is in the middle there. Senior residential appraiser. Yeah. But you could earn these certifications through education and experience. That model was well developed, and when Title 11 was adopted or enacted, the federal government, rather than creating a whole new set of standards, essentially allowed many of the standards that were already in that professional organization to become the standards required by law. Okay? And they did that through the recognition, the official recognition of the Appraisal Foundation, which was a nonprofit kind of offshoot of the Institute at the time, and it was also a cooperative arrangement, if you will, kind of a trade group that consisted of a lot of professional associations. So there were lots. There was the ASFMRA and the AAA, and there's 5 or 6 major ones. and I have some handouts that I'll give you guys to kind of track through this in just a moment after we get right to the creation of the board. The foundation was acknowledged as the standard setter. Okay, and the Appraisal Institute was a participant, one of the sponsors, in fact, the primary sponsor of the association, of the foundation at that time. They, under the foundation, there were created two bodies, one called the Appraiser Qualifications Board, and the second called the Appraisal Standards Board. And so one dealt with education and experience. What education and experience should be required for the various levels? It was recognized, like any profession, that you come into it as a neophyte and then train your way under active mentorship, and then you achieve a journeyman level, if you will, and then proceed on to being able to do things independently and supervise others and sponsor and mentor others. So at what level was the what level of education was appropriate for each of those, and what level of experience was appropriate to move to the next level? And then the Appraiser Standards Board took on its mission, then officially became which was, they already existed at the time, but now this became a federally recognized, they were the standard setter. So what we call today, and it was called back then, the Uniform Standards of Professional Appraisal Practice, okay? USPAP. By the way, we will have 13 new copies of USPAP tomorrow to hand out.
Whoa.
So everybody, as Ms. McClendon has asked many times, why don't I have my own copy of USPAP? Everybody will have a copy of USPAP, and that's partly because the agency, they're generally like $75 a copy, but the Appraisal Standards Board has determined that volume equals profitability, and so for states, they've done two things. One is provided them for regulatory officials at $30, so we ordered enough for everybody.
Makes sense.
And then the other thing, or excuse me, $20. And then the other thing that they did is they said, and I don't, this is a policy thing for you guys, but they said essentially, if you want to, as a regulatory agency, provide these to every licensed and certified appraiser in your state, we will do that, but you have to buy in volume and send us a big mailing list of everybody who gets them, and you send one check for $30 a copy, and we'll ship them to everybody with a license.
Wow.
So that's a whole lot better than $75 a copy. Interesting new marketing thing for them, but they really do want to get it out there. It is the Bible. It's the guide for how to perform an appraisal. So those two things have been adopted officially in Title 11 of the Financial Institutions Reform and something else, Recovery Enforcement Act, FIREA. Okay. Title 11 also required every state to have a certification program that met the standards that AQB set. And they had to do that by, I think it was the middle of 1992, and then they extended it a couple times because federal rollouts don't always go exactly when you have to get 55 other players, working along. They don't always go exactly as planned. In anticipation of that, let me talk about one other structural item. Then they took all of the lending oversight agencies, okay? And so probably this would be a good time to pass these around, if you would. Let me send half of them each way.
Doug, remind me too, so in 1989, we had FIREA, and prior to that time, oh, did I get the right? These are
There's 2 pages.
Oh, there's 2 pages.
There's 2 pages,
I didn't
sorry.
get it. Okay.
There's 2 pages.
Did you get both?
So we had, prior to that, we were salesmen's or brokers' licenses to appraise in the state of Texas. And then when did licensure kick in then as a result of passing FIREA? Because that was all a part of the same.
Well, I'm going to talk about that. There was a 2-year period when
Oh, yeah.
appraiser certifications
Okay.
were issued by the commission.
Okay.
Okay? So we'll talk about that in just a second. But in Title 11, as you can see from this little org chart, all of the federal lending regulatory agencies, okay? So regulatory agencies over lenders at the federal level. So the Federal Reserve Board, the Office of the Comptroller of the Currency, Office of Thrift Supervision, which after Dodd-Frank no longer exists. It is now, its functions are rolled into OCC. And then FDIC, the Federal Deposit Insurance Corporation, and then the oversight body, the National Credit Union Administration for credit unions, were created. Representatives of all of those agencies met together as the Federal Financial Institution Examinations Council, FFIEC. Under FFIEC, so these are the folks that determine whether or not lenders are living up to the regulatory standards of the federal government for participation in the secondary market, federally chartered lending institutions, not necessarily the state chartered institutions. The states have regulatory bodies that oversee those, but to the extent even those that participate in the secondary market, there are standards that are adopted that are required for that participation and then adopted and enforced by the state banking regulators, if you will. Under the FFIEC was created a body called the Appraisal Subcommittee. And the Appraisal Subcommittee, they have 2 principal roles. One is to oversee the work of the foundation and fund the operations of the ASB and the AQB. And the way they do that is by collecting a fee, which from 1991 until 2011 was $25 per year per appraisal license or certification. So if you as an individual appraiser were licensed or certified in 5 states, you paid $25 per year 5 times because it's collected by the state in connection with your license or certification in that state and then remitted to the ASC. Now, what do you get for that money is the ASC is required to maintain what's called the National Appraiser Registry, the National Registry. And it is simply a list of all license and certification holders, some vital information about them, name, address, telephone numbers, all those good things, how to contact them, all of the states in which they are licensed, their license numbers in those states, or certification numbers, and whether they are in good standing. Okay? One additional thing, and it affects, of course, good standing, is that any disciplinary action that interrupts an appraiser's ability to practice, so a suspension, or certainly a revocation, but a suspension, unless fully probated, shows up. So that anyone who's dealing with an appraiser, especially lenders, can look at that and say, okay, there's a 3-month period that they can't work. So you get the registry, and then their other job to oversee and fund the work of the AQB, the foundation, and its 2 boards, the work of those 2 boards. So there's excess funds from it doesn't cost $25 per year per appraiser to maintain the registry. So they pay all their staff out of that and provide grants to AQB, through the foundation, to AQB and ASB to fund the regular review and maintenance and rewriting every 2 years of the uniform standards of professional appraisal practice, and then the review and updating of any new either experience or education qualifications done by the AQB. Okay. The last and most direct role for us is that they go out and visit all the states and review whether or not the state agency tasked with the duty to certify and regulate appraisers under these federal standards is being done up to those standards. And so every 2 years they come to visit us. They will be here the 3 days immediately prior to this board's February meeting for their biennial visit. And the last 2 visits, we've had a clean report with one exception, and that exception is that it is a requirement, it's a standard, that all complaints be resolved within 1 year of the time they were filed, unless they meet certain narrow exceptions. And we've had, and that's been the only black mark, if you will, on our record for the last 2 times that the ASC has been here, is that we've had a number of cases, continually dwindling, but still a number of cases that didn't meet the exception and hadn't been resolved within 1 year. I'm happy to tell you that you will hear on Friday, I would steal all their thunder, that we have 4 cases left to resolve before February. That's cases that were filed prior to March 1 of 2013. Okay, 4 cases left to go. So we have high expectations.
That's amazing.
That we will meet all the standards and get a clean report, completely clean report for the first time in our history. The ASC came for the first time in, I think it was 93 or 94 for their first visit, and every 2 years they've been back. And the number of findings, of course, in the early days as well, but we've worked through all of those. And now we anticipate the board's policy has been, to this point, to have, the way that ASB often works is they will say, we are implementing this new standard. There was a bunch of new standards in 2008, but they announced them halfway through 2006. And said, January 1 of 2008, these are the new standards. And this board historically has not waited for the deadline date, but has anticipated that and said, well, that's a good idea, we're going to adopt those standards and get those practices in place here before that actual requirement. One of the interesting things about FIREA, and I guess it's true generally across federal in areas of federal jurisdiction that involve the participation of all the states, is that you have the minimum standards are set at the federal level, and the state is allowed to have standards above and beyond that. We have very few that are, a quote, above and beyond the federal standard, because we have historically been a low regulatory state environment. And so there's very few things, mostly legislatively directed, but things like criminal background checks. They won't become, the fingerprint-based ones won't become mandatory until January 1 of 2015. We have non-fingerprint-based ones in effect and have had them in effect for about 5 years, I think, now.
Are you aware of any state that was so non-compliant that they took action to shut them down or not allow appraisals for federally related transactions or anything?
The FIREA that brings up the case. The answer is no, but there were a couple that were perilously close, and it was in the early days, and they were essentially just fighting federal regulation entirely. We were not one of them. But FIREA only gave the appraisal subcommittee one tool in their toolbox. When they come to visit, they write up a report and say the state is in, we have all these findings, and at the end they say they're in substantial compliance or they're not in substantial compliance. And they had to, if they said not in substantial compliance, the only hammer, they had one hammer in their toolbox, no wrenches, no any other pliers, screwdrivers, nothing, just one hammer, and that was they could decertify all federally related transactions in the state. Essentially shut down the FHA, VA, and conventional lending, non-portfolio lending, all secondary market lending in the state. Obviously, it's kind of like a nuclear bomb. That's the only thing you have. We don't have any artillery. We just have one nuclear bomb, and so when do you use it? Never. And so they actually never have decertified a state because the political ramification. Now they have threatened it, and that generally gets the attention of the legislature, and gets that agency, called on the carpet and fixed for whatever the issues are that would, rise to that level. Fast forward to 2011, July of 2011, and we, addressing that specifically, the ASC was given a whole range of tools in their toolbox. It's still there's only one kind of tool. Actually, there's two kinds of tools now. They can still decertify, but they also, the other tool they can use is they can withhold the recognition of the certification of particular appraisers. Now that's a curious tool to influence a state's policy-making behavior by failing to recognize industry members' certifications, particular ones. And I asked directly about that, and Jim Park, who's the head of ASC, the executive director up there, said, well, we would tie that to wherever the lack was. So, for example, if we had a program, which we did at one time, and it was allowed, and it's now no longer allowed, but let's say we still did it, we had provisional appraisers. We had provisional licenses. Now these are appraisers who have all of the education but insufficient experience, and they cannot. They had to tell us that they couldn't find a sponsor. There was no one who was willing to, because they lived out in Timbuktu, and or they simply couldn't find a sponsor. They were allowed to get provisional licenses and then actually work as regular appraisers while building up their experience to the level that they could shed the provisional title when they met the experience. Because the first amount of experience is generally achieved while being mentored or under the sponsorship of a certified appraiser with experience. But let's say we still had that. We refused to get rid of that program. Well, then they could say, we're not recognizing the licenses of any of those provisional appraisers. They cannot. We're not. No loan that they did an appraisal for can enter the secondary market. So that's how they would try to tie that to the offense. Again, it's a less egregious tool, but it doesn't have any limitations on it other than that idea that Jim gave to me, that the intent is to to only non-recognize the certifications of appraisers whose credentials were earned because of the non-conforming program or policy or whatever it was. That's how he said. It's not in the rule that way. Doesn't say that anywhere, other than that's what he said in front of a group of people, so we'll try to hold him to that.
Commissioner,
Yeah.
so we don't really have anything like that in the state of Texas that we can fathom sitting there, do we?
We do not. We have, I think we're down to 7. There were provisional appraisals, maybe even less than that today, and I apologize for not knowing that right off the top of my head. But when this board, by policy, repealed its rule allowing provisional licenses, we grandfathered those who were at the time, and then said that no provisional license could be renewed. So it's really, you got 2 years to get your experience, or you got to go find a sponsor. So, and I believe that was in 11, and we had some who renewed right before that. Actually, and we had applications that were pending at the time that we did not. Well, anyway, they were granted as late as July. So it was either 11 or 12, and so we'll very soon not have any in that category.
So are they not recognized currently on the National Register?
No, they are on the register.
They're okay. Okay, so that's going to be, if it continued, they would be not registered,
Right.
not recognized.
That's
But
right.
currently, they're okay. They are recognized. I see. Okay.
So they could not be renewed in that status. So we had several that renewed right away to get the full 2 years. Okay. Any questions about oh, let me say one other thing about the scope of the appraisal subcommittee, and that is, in the Dodd-Frank Act, they were given these new tools, and they were also given the authority to oversee the state regulation of appraisal management companies. And in fact, Dodd-Frank requires states by 2 years after the effective date of the final rules implementing Dodd-Frank. Now, anyone who follows the news knows that the rules to implement Dodd-Frank have been late in coming consistently, partially because the CFPB, Consumer Financial Protection Bureau, which was set up to administer those, went for a long time without a head, and they were, you know, it's a state agency standing up from scratch, a federal agency standing up from scratch, and so they haven't met really any of their deadlines with respect to a lot of the banking regulations. They do have some that are in that they're already doing enforcement on as well, but not in this area. Spoke with a representative of the CFPB when we were in D.C. in October, and asked specifically that question. In fact, we had a conference call shortly before that meeting, a conference call with CFPB, ASC, and several other federal agencies looking for input on what the final rules need to contain. The interim final rules were written by the Federal Reserve Board and published with very little input because they were interim. Well, they've been interim now for, it'll be 2 years this month. In fact, their 2-year anniversary is this month. So we've been under the interim final rules since they were published. And they're looking to come up with the final rules, publish them hopefully in December of this year, adopt them maybe in February or March, and then the 2-year clock starts. Now, prior to Dodd-Frank, 19 states had already adopted appraisal management company regulatory schemes, from very simple registrations to very robust regulatory structure. The Dodd-Frank bill has language that defines what an AMC is for federal purposes, and then also sets out some criteria. And this body, in anticipation of Dodd-Frank, was working on a draft bill to create, put the authority for that regulation where Dodd-Frank said it needed to be, with the Appraiser Regulatory Board in the state, and then implement that. We were fortunate; it was passed. In time for us to actually, right before the 11th session. And so there was time for a stakeholder group, including members of this body and convened by this body, a stakeholder group, to work through a draft bill, which was then the professional associations got sponsors for it. And then there was another stakeholder group that was called by the sponsors as well, and included many of the people who had worked on the bill, and some additional parties who had expressed interest during the legislative process, and worked through all of the various objections and balances and compromises, and achieved what was at the time and is still today recognized by the industry as the most comprehensive of the bills out there. It addresses things that many other states don't address. So that's where we are on appraisal management companies until, so when ASC comes, they'll look for the first time at our ASC, our AMC statutes and rules, but they don't yet have the authority to require anything, because the relevant provisions of Dodd-Frank and the final rules don't come into effect until 2 years after the final rules are adopted. So that's when they could come in and say, you do not meet. They could come in today and say, this is an area that we're concerned about. It doesn't appear to meet the requirements. You have time while we're waiting for the rules to come out. So we'll see. And when the rules are published, hopefully in the spring, we'll be in the middle of strategic planning, which we'll talk about a little later today, and we'll have a opportunity to review those rules in light of the final rules that CFPB puts out. 2 years, so 1989, the legislature, in anticipation of FIREA, they knew it was coming, created under the commission the Texas Real Estate Appraiser Committee. And for 2 years, that committee, and it was 9 members appointed by the commission, okay, not by the governor, but appointed by the commission, and it involved almost all licensed brokers who specialized in appraisal. That's what they did for a living. And so it was a very knowledgeable group, and they wrote the initial rules, if you will, for the commission to promulgate. Then after the bill was passed in 91, in the 91 session, this body was created, and that body was terminated. So June 30th of that year, that committee ceased to exist, and July 1 of 91, this board was created. And in July, the governor appointed, I think, 5 members, and by September had appointed all 9. But the 5 members were a quorum, and they met at the end of July, and then again in August, and promulgated emergency rules for the implementation of. And a lot of that was taking the work of the committee and the rules that had been promulgated by the commission, and moving those over. And then some additional things that were in FIREA were addressed then. And it's curious that there's a special sunset provision in our legislation, even today, in Chapter 1103, that says if the federal government ever stops requiring the federal certification, that recognition of appraisers, that the next legislative session, this body will undergo special sunset to determine whether we are still needed. Because our original purpose in that bill, it said, was to implement the requirements of FIREA. So essentially, if the FIREA scheme was ever repealed at the federal level, then this body would not automatically cease to exist. It would simply undergo sunset at the next regular session.
Kind of a poison pill. Huh?
Well, it's one of those springing powers, you know. Just okay. All through the 90s, this was a very small agency. We had from, I think when they first stood up, I think they had 5 people, 5 staff members. So nine board members, 4 public and 4 industry, all appointed by the governor, and 1 ex officio member, the executive secretary of the Veterans Land Board, or their designee. In 1999, I was the executive secretary of the Veterans Land Board and sat in the chair that Mark has sat in for the last 10 years. And so I had the great privilege of serving on this board for 4 years. During that time, it has always been historically a great struggle to get additional resources for a small licensing agency of only 6,000. We've been at 6,000 pretty consistently. 6,600, 6,800 I think was our high ever, and we dropped down to about 5,900 at one point. But we stay in the low 6,000 of all categories: trainees, state license holders, certified residential, and certified general. You can do any kind of commercial property. Certified residential can only do residential properties, and then license, and then of course the trainees that have to work under a certified mentor sponsor. There was a time when I was on the board in 2000. We were up to 7 staff members, actually 7 FTEs. We actually had 10 people working, but the investigators were all working part-time. This board, the industry members sat as 2 enforcement committees. So 2 enforcement committees made up of 2 industry members each. And they would come in the day before a meeting and sit with the investigators and go over there were 2 things that they did, is they would review the complaints that had come in and determine what level of investigation to task to the investigator. And then they would review all of the investigative reports and actually do conferences with respondents, the appraisers against whom complaints had been alleged, and have those informal conferences and negotiate at that time agreed orders. And then at the board meeting the next day, those 2 representative of those 2 members, so it was like half and half, that I would bring these. If Lori was one member and Mark was another member, Mark would maybe bring 3 cases and talk about them, and then both Lori and Mark would recuse themselves from the vote on that particular thing. That's how enforcement was managed in that heavily constrained environment. Our general counsel from the OAG would represent us at SOA. Frank, I can't remember Frank's last name, but Frank, he had several boards, and he spent a lot of time, going to SOA. We didn't have as many cases go to SOA.
Now.
I'm sorry?
Knapp? Frank Knapp?
Frank Knapp.
K-N-A-P-P?
Yeah. Yes.
Cobwebs.
Got through there. But he was the general counsel for the board, and he would, and they would task him, take these three to SOA. But all of the votes were held by the remaining 7 non-involved members. And then they would change when the second enforcement committee would come up. Then, of course, those on the first enforcement committee could vote on those. But that's how investigation enforcement was handled. All of our investigators were certified appraisers and have always been. But at that time, because they were part-time, they also had outside practices. When we hired our first attorney, and that was after me, after I had left and Mark had come, I think it was 2005, when they hired Troy for the first time, and they hired him. He had an outside practice, and he was a 3/4 time employee. I think he started out half-time, and then he went up to 3/4. In 2009, when I became the commissioner, as a result of becoming the administrator, that was one of the very first things that we had to deal with. It had been festering for a long time. There was certainly sufficient work internally to keep these folks busy, and it looked like we had the resources to do it as well. But there was a lot of pushback against giving up those outside practices, and so that had to get resolved, and we did that in the first quarter of that year.
How many employees did we have when we made that transition from, I guess I heard you say 5 part-time to some full-time and giving up their outside practice? How many employees did we have at that time?
At that time, we had, I think, 11 total.
How many of those were in the investigative attorney role? And I'm not going
8.
to check these, I'm just trying to
8.
gauge. Okay.
Including the person who's in Dion's role, okay, but the administrative support for that and legal assistance. So we had 4 investigators and just 1 attorney.
And for the new guys, how many do we have today?
Today we have 7 investigators and 2 attorneys, and of course the director is an attorney as well. So we essentially have 3 attorneys.
And when you made that comment about the 4 investigators and 1 attorney, was that the 2005 date or the 2009 date? 2005
that was 2005.
part-time.
Yeah, they were part-time. Oh, in answering Jamie's question, that was 2009, and then we had 3 other people that were, 4 other people total, that were in licensing, education, and the reception and communications that had been integrated into the work, integrated into the commission. So all the administrative support functions went to the commission. Their salaries are still paid by the board. We have 2 other major things happened in there. Late 2003, as a part of the budget cutting measures, an early retirement bonus was approved by the state of Texas, and both the commissioner and the assistant commissioner qualified and took it. So
2003.
yes, in September of 2003. And the bonus, although it was authorized by the legislature, it was funded by the agency. And so it essentially took about 1/3 of all of the HR funds that year, boom, to pay those guys to leave, to retire early. Lean, very lean time. In fact, the board at that time, I think, went to the governor's office and got an emergency loan. You can get up to $50,000 from the governor's discretionary fund, if you will, for those kinds of things, and we got it at that time, and then had to raise fees to pay it back, to be able to pay it back within the biennium.
I have a
Yes.
question. When we, was it 1991 or when the board was created, was it always a wholly owned subsidiary of Trek, or, so that was the 1991 timeline?
Correct. So
Okay.
previously it had been a committee under TREC, and then it was made an independent subdivision, okay, of the commission.
In
Independent
1991.
Right.
Okay, so all the guidelines and expense sharing agreements and whatever have been in place since 1991.
There was an MOU in 1991, and
Okay.
there's been a memorandum of understanding on what expenses are borne by the board and what expenses are borne by the commission ever since.
Gotcha.
Yeah, consistently over the years. And it is one of those things, especially in very, very lean times. But if you read through the strategic plans for all of those years, you'll see that there were many things that were provided. It was just at no cost. I mean, they couldn't afford rent, they couldn't afford computers, the board couldn't afford a lot. It was barely enough to pay. And part of that to pay the salaries and regular operating expenses. And part of that was because, and it is one of those normal things for Title 8 agencies, Article 8 licensing agencies, is that they bring in far more than they are appropriated to spend. They're revenue generators for the general revenue, for the most part. And so less than 50% of the revenue that came in was appropriated back to the agency. And so it was always, every session, certainly from 2003 on, there was, a request for at least let us hire another investigator, let us hire another attorney, all those kinds of things until 2011 when we gained our financial independence.
And at that time, or when did your position where you're the TREC and the TALC?
Okay. Through, in 2003, when Ren Lanier and Roger Barnes both retired, okay, that September 1st of that year, the memorandum of understanding was renegotiated at that time to allow the administrator to act as the commissioner. Okay? And then in 2005, that was codified in the statute. Okay?
And just to make a clarification, which
Please.
I think you did, but for those that don't know, we are an independent division. We are not a wholly owned subsidiary, and don't directly report with
Right.
TREC or anything like that.
Independent subdivision, no policy, the board has all full rulemaking authority within its jurisdiction, and the ability to set its operating policies and those kinds of things. And that's why there is a negotiated memorandum of understanding each year. And now that the board actually sets the budget, rather than the legislature setting the budget, that's additional authority that the board has to help direct those resources in the right places. Okay, what haven't I covered that you are curious about in the history of this body?
I have a question. Why did you do away with the board members participating in enforcement? I know that other agencies do that. Other licensing agents continue to have board members involved with that, and then just recuse themselves when they give the report of that. So why did this agency stop doing that?
I'm going to tell you my general understanding, but Mark could probably deal, since he was sitting on the board at the time that decision was made. But I think when in 2005, we got additional resources and freed up some resources after we had repaid the, raised fees and repaid the loan that we had to borrow to get rid of the two guys at the top, let them retire. And then we had that money, that salary money, if you will, to hire some additional folks. We added additional, we hired, I think for the first time in 2005, we hired a full-time investigator. And then we also took many of the, quote, part-time investigators to full-time as well. So we made up that gap. But we hadn't dealt with their outside practice thing. That it no longer became necessary, and whether advisable is a different story, but it no longer became necessary. I think it was a necessity previously.
A financial
that kind of drove it,
necessity.
yeah.
Right.
That kind of drove it.
But from a policy matter, that wasn't even considered.
Well,
that I'll let Mark drift
Right.
since I wasn't around.
Yeah, let me back us up a few steps. In the early years, that the board was formed, there were no complaints filed at all. In fact, it was such a new agency. For many, many years, it was just policy and rulemaking and just getting everything established. Right around 2005 was the point in time when it just seemed like the bottom fell out, and it was just, complaints were just being filed like nobody's business. The decision was that at that time was one of human resources, the ability. And at that point in time, Larry Kokel was the chair. Thank you. I almost said president, chair of the board. And looking in the statutes, he realized that the statute had set up the peer review committee, and he thought it would be better instead of having just 2 or 4 people on the board helping direct these investigations, that he called a meeting and asked for all certified USPAP instructors that were interested in serving in the peer committee to come in. The peer committee was established. That's where the people that work in the profession integrate with the regulatory folks as far as reviewing the cases, making recommendations, and so forth. And so that's where the profession meeting the regulatory body now meets. Instead of at the board level, they do it at the peer review committee level. And I think, wasn't it just not several meetings ago, we approved a panel of peer review. And how many
We do it
people
every
on there?
February.
How many people are on there now?
I think we have 13.
So you have 13 instead of just 4.
And so that every case now is seen by our investigators, and before they go into negotiations or whatever else, there's a peer review of that complaint first.
No, ma'am.
Not.
There are additional resources. So at that time, they were a substitute for the board members, although each of the peer review committees was chaired by a board member. So there was still that connection. And as the investigative staff gained experience and was beefed up, fewer and fewer cases over time have gone out to the peer committees. We always have the agreement that if any peer reviewer signs is that they will agree to review up to 4 cases in a year, 1 every 3 months. And we always send out 1 at least to begin that process. And then just depending on the workload of the individual and their temperament or whatever, some of them we have to pull back because they never do anything with them. And generally generally they don't apply again the next year, or if they do apply, we had a few, this past year that were non-recommended because we couldn't get anything back from them that we had sent out. Well, they were an obstacle rather than an assist, which is kind of what they volunteered to do, was to assist.
One other element on that I failed to bring up, though, is that at that point in time, the ASC had already come in here and had written us up about cases being over a year old, and they, at that time, only had the hammer, and they had the hammer in their hand already. And so the board had to say, the system that we're using now is not working. What else can we do to move these cases through quicker? And that's when we discovered, or came to the realization there is this peer review committee that we can use. I will say at the very beginning, the peer review committee was used extensively to get caught up.
Oh, no, absolutely. Absolutely. In fact, we revived it. In 2009, Mark actually headed up a special committee, special working group of the board to look at all the alternatives, including hiring. I mean, just shipping these out on contract to reviewers to review. We looked at all those alternatives, revived and reinvigorated the peer review committee, and shipped a bunch out. And they were very helpful in those in the first, well, in our recovery, a road to recovery. So we have, you know, there are really three parts to that. One is the amount of resource we had available, and then the expertise of the folks that we had, and then thirdly, the falling number of complaints. So it wasn't building up as fast as it had been before. And you see that in your materials. It shows, you know, over a decade, the number of complaints and the number of resolutions, and you can clearly see, you know, the trend in the falling off the number of complaints, and that has really helped. The last thing that helped and was kind of what the cherry on the top that really allowed us to get to the place we are today was the AMC legislation included 5 positions. And that allowed us to bring in another attorney, another legal assistant, and 2 more investigator, 3 more investigators. 1, 2, 3, 4, 5.
Can you
Yeah.
recap that then for the total?
Total of 5.
That this board has in investigators and attorneys to service both the appraiser side and the AMC side?
Sure. And I can, if you let me get my, I mean, I'll tell you what I know right off the top of my head, but I can get the chart too, just to make sure I got it exactly right. But we have 2 attorney positions, plus the director happens to be an attorney. So we have 3 attorneys. We have right now 6 full-time investigators. We had 7, but as I informed you guys, David Wilson left us to go to the Department of Transportation, and that was fine. It was a good career decision for him. And we're at a place where we don't need and really can't afford to renew that position anyway. So that's good. We have 6 appraiser investigators, and then we have 3 legal assistants, and then our head administrative assistant, Dion. So that's all on the regulatory side, and they handle anything that requires the application of judgment. And that's really how I divide the responsibilities, if you will. Anything that's administrative, you know, it needs to be 3 and it's 3, check, okay? All that stuff is done in TREC, okay, and by the commission, by folks that are paid by the board, but consolidated for supervisory purposes and all that, and efficiency in TREC. But anything that involves looking at and determining whether or not someone is complying with a rule or requirement where there's a judgment call involved, all of those things like the experience audits, those kinds of things. Do they have the right number of hours? Add them all up. If it's right, it's right. That's administrative. If there's a question about something, does it count? They ship it over to that regulatory side or enforcement side for them to look at. So they do all the experience audits, which are now 100% for all certifications, and they do all of the complaints, both by and against appraisers and by and against AMCs.
And then kind of back you up back to the
Please.
peer review committee. Are they compensated at all for their work?
If they would like, they earn a stipend of $75 per report that they do.
Can you elaborate on
Very
is there
few
a
of
policy,
them.
or is there?
It's in the agreement. It was a book policy set by this board.
Okay.
And many of them, that's their it's their pro bono work, if you will, and they just don't.
Where is that policy? Where are these policies kept?
They're in the agreements approved by the board
Where are those agreements kept?
on our system. I mean, I have a book of them. I can print them out anytime. Those agreements, in fact, they're on our website as well. The agreements for peer, for the application to be on a to become a peer investigative committee member, and then the agreement that they sign that has their compensation and their agreement to do for a year, and, you know, those kinds of things to tell us if they're competent or not. They get one and they go, I'm not competent to do this, they ship it back. You know, that doesn't count against them.
So it's not just in our policy, it's also, the policy is also reiterated in the agreement that they're signing.
Correct. That's where it's embodied. The
Well,
the decisions were made to put it into the agreement.
And so do
Right.
they, when they sign the agreement, does it have a checkbox, don't want the money, want the money? How do they do that?
No, because they can change their mind anytime. So
Okay.
if they send us banking information so we can wire the money to their account, and then make a claim, if they send their report back, and they just, all they have to do is either call or put it on a letter that says, send me my $75, and it's paid.
So we'll probably see those agreements in February meeting. 'Cause
We do.
Yeah.
We require them with the application to essentially sign the agreement ahead of time, and it comes with the application for your consideration at the board meeting.
Would you mind just getting me a copy of that policy?
I'm happy
Just
to.
have it.
Happy to.
And when you say you want a copy of the policy, you basically want a copy of the agreement.
I'll take both.
Was
If it's
the
embodied in
That's
the
what I'm
agreement,
asking.
Yes.
yeah, is it two separate documents, or is the whole policy embodied within the agreement alone?
Well, let me do two things. One is we'll look at the rule and see if there's any particular portion of that was changed at the time we revived them. I'm not positive that we did update the rule at the time. But the policies all surrounding that agreement are embodied in the agreement and the form. So the application says what their minimum requirements are, and then the agreement is their agreement to all of those things, including the compensation.
Yeah, that'd be great, and or both.
I'll get them printed off. Or you want to print them off the web?
Yeah, I'll print.
They're on the PIC page.
Yeah, no, I'll print.
Okay,
Thank you.
great.
How many copies?
And then our guest speaker has a.
Yes.
I would just give everybody
Has a
one.
time frame.
Yeah.
Any other questions on the history stuff? Is there anything, any gap in there that it's like, what happened between X, Y, and Z? It's been a very interesting road for such a young. I mean, we're only 22 years old as an agency, as an industry. It comes much longer, but probably one of the greatest challenges is that federal. And I'll just leave this with you for future thought. Is that we're in some ways we parallel some of the mortgage broker industry things. And there's been, at one point, the SAFE Act was passed, and it brought together these kind of disparate, the lending oversight federal agencies, and then they have other bodies that are cooperative bodies that set underwriting rules and things like that, that then the states implement and enforce. And they had the same, where the states could have higher, but, you know, generally they just went with the minimum kind of a thing. And under the SAFE Act, in preparation for the SAFE Act, or actually to acknowledge the simple fact that, you know, Rhode Island had 212, for example, mortgage brokers. You can hardly afford to have one person in a regulatory agency, much less have computers and systems and education. How do you check their education? Then they did background checks. How do you do all that with one or one and a half, or, you know, part of an umbrella agency kind of a thing? And so the states all got together and formed a co-op. There were about 10 to start with, and they pooled said, well, you know, we can't afford to have a computer system and a licensing system and all that, but we can send you $8,000. And we can fund this co-op, and they developed a common platform among the states. That model is actually being kicked around at the higher levels of this industry, including at the appropriate subcommittees in Congress, to use that as a model, because we have many of the same very diffuse, this body does this part and that body does this part. And I'll give you just one little example. At the Aero meeting, I posed a question at the Association of Appraiser Regulatory Officials in Washington, and we were meeting with ASC and AQB and the foundation and everybody comes to that meeting. That's kind of the national meeting every October, where we talk about all this stuff. And I posed the question to ASC because of the fingerprinting that was coming up, and I said, the rule that has been proposed, or the standard that AQB has proposed, asks for lots and lots of things that I don't think. I asked the question, where does the database exist to check this? Overseas, allegation of a breach of trust, including an adverse finding in an arbitration, domestic or overseas. There is no such thing. There's no database. People go to arbitration because it can be kept quiet. So I asked the question, I understand that you might have some concern about folks like that, but you set a standard that we can't comply with because there's no way to validate it. And so I asked ASC if they thought, how were they going to enforce that? And they said, well, we're not sure how AQB is interpreting it yet. And I said, well, can you find that out? It said, well, it's our job to enforce it, not to interpret it.
Clear.
So, and the direction was that the states should ask AQB. So we did. We asked them, and they haven't answered yet. But that kind of, who's on first and whose responsibility and where does that responsibility stop and where does it overlap and all that kind of stuff in this profession is rampant at the federal level. Of course, with CFPB not doing rules yet, there's still a lot of question marks hanging out there, and the interim final rules are not clear. They don't provide, sometimes they actually introduce more questions than answers in the equation, and so people are just kind of waiting. And that's a really tough environment. So some of the congressional committees are actually looking at a bill that would create the equivalent of a SAFE Act to allow the states to cooperate and do exactly what they did in the mortgage industry, which now all 55 jurisdictions participate in the same database. And there's huge economies of scale with that. So,
do you know what the fees have been historically to be a state licensed or certified appraiser, say today as compared to 1991?
No, I can only tell you that, and I don't know what the original fees were. I apologize. No.
Do you mind breaking for?
Oh, no, we need to. Yeah, absolutely. I think we need to break for.
Lose several.
Just call it a break, 5-minute break.
Okay, we're going to take a quick 5-minute break.
Thank you.
10:29, according to Mike. Okay, we're going to reconvene our meeting, and it is 10:37 a.m. And we'll move down to agenda item as soon as they get back. It's on this agenda item. We're showing it as 5. We're moving 5 up to 4, and then. Or at any rate.
Yeah, that's all I need to say.
And Nancy Fuller.
Thanks. I appreciate it. I appreciate your invitation to be here today. I've done a lot of training on the Open Meetings Act. I've been at the AG's office since 1999. I served for 8 years as chair of the opinion committee, and in that role, we did a lot of written legal opinions interpreting the Open Meetings Act, and we did training every year at the December Open Government Conference, and then updated the Attorney General's handbook on open meetings. So I've done a lot of training on open meetings. Much of it has been basic training, and I understand that many of you here, in fact, you may have seen my face on that video with the, the annoying violin music. That was, of course, provided by the Attorney General as a free resource so that board members could get their 1 hour of training on the Open Meetings Act. And I know some of you have done that. Some of you may have not. Some of you, even who have done that training, may not have completed those certificates that are required to be on file with your organization. I gave to Carrie a step-by-step thing for you to do if you need that certificate, and I'm going to urge you to have that because it would be embarrassing to you if you were to get a public information request for a copy of everyone's certificate. So even if you have done this training before but have not gone through the exercise of getting that certificate, I'm going to urge you to do that. And this, I tried it just yesterday. It works. You just follow those steps exactly, and you can get your certificate generated and get it to Carrie so it can be on file with your here with your organization.
And what's your name again?
Nancy Fuller, F-U-L-L-E-R.
Thank you.
And I'm in the Administrative Law Division right now. I've done legislative work, opinion committee, administrative. I've been kind of all over the agency since 1999. I've worked for 2 attorneys general in that time, which is pretty amazing, actually. So I'm going to, so that those of you who are new and need, there are statutory requirements about what kind of training you need within this 1 hour. So I'm going to touch on all those areas and cover those, but feel free to ask me questions. No question is too preliminary or too fundamental, or no dumb questions, as they say.
Do you want us to hold them to the end or during?
Well, I'll just leave that up to you. In a way, it's probably better to hold them to the end, otherwise we'll get slowed down significantly. But, you know, if you just have a burning question and you need to ask, I won't be offended by that. The obligation to hold public meetings where the public can see what's going on with public bodies precedes the Open Meetings Act. You can find cases, judicial cases back in the 1940s, which reveal that the way government business used to be done in some cases was maybe there was a 3-member board and maybe a couple of those board members worked in the same building. One person would get a question or an inquiry, take it down the hall, show it to the colleague. What do you think about this? You know, they'd make a decision and it would be done. But cases out of the Texas Supreme Court, even from the 1940s, say, that's not the way public bodies are to do business. The public has a right to see, and the public has a right to have things acted on by governmental bodies as a whole. You know, every member of the governmental body has a right to have their input and to contribute to the decision making. So even way back then, you know, this was sort of the general thinking, but there wasn't a lot of public witness and public involvement in decision making. Well, that all changed in the 1960s. And if you may or may not know, there's been a lot of interesting historical information today. I'm going to make reference to the Sharpstown stock fraud scandal, which was an era of scandal in Texas politics and reform that came out of that. In fact, as a result of the Sharpstown scandal, which is an interesting story, I'm not going to take time to tell you about it today, but it was basically some legislative shenanigans that went on. As a result of that, the Texas House of Legislatures was half brand new members after that. So that is shocking. Think about that. If that were to happen today, we would be stunned. Well, that's what happened in the 1960s. And out of that reform legislature came the Texas Public Information Act and also significant modifications to the Open Meetings Act. The original Open Meetings Act, I brought a copy of it. It's from the 60th legislature, 1967. It's 3 pages long. If you've looked at the Open Meetings Act today, it looks nothing like this. But this is what the original looked like in 1967. So the whole idea, when the Open Meetings Act was significantly modified and so forth, its passage and its augmentation really reflected the growing idea that the public should have an opportunity to be informed about and to witness governmental decision making. And of course that's an idea that we pretty much take for granted today. Enlarged greatly, passed in 1967 and enlarged greatly in 1973. So one of the most challenging aspects of, well, there are many challenging aspects of the Open Meetings Act, and one I think you already made reference to earlier. When you come out of private business, you do business a certain way. You get in a closed room, you talk to somebody, you try to build coalitions, et cetera, et cetera. That's not the way the Open Meetings Act works. It's a totally different way of approaching decision-making, group decision-making, than you might be used to in private business. And that's because it grows out of these democratic principles that the public has a right to know what its public bodies, elected or appointed, are doing. And one thing I always like to stress when I talk about this is that, you know, we're members of the public too. And you may have a child and you may care about what their school district is deciding. You may be a taxpayer, you probably are. You care about how your tax dollars are spent. So, you know, we actually are on both sides of this deal. Here, as a functioning board member, you're responsible to the public, but you too are a member of the public and appreciate the rights that you have to know how governmental decisions are being made. So I think it's good to remember that. So lots of challenges with this. I think the first is to realize it's just a totally different dynamic than the way decisions are made with private groups and private decision making. On a nuts and bolts level, there are all kinds of challenges, and I'm going to give you some examples of things that I have seen that are sort of recurring practical problems as we go along. And you may have other examples of things that you wonder how they are to work out. But let's talk about quorum, for example. One of the things that I have seen, and I didn't notice it with this group today, but I have a number of clients, as Ellen does. We go to a lot of board meetings. And with respect to this notion of quorum, you guys are 9 members, and of course a quorum is typically just a simple majority. So a quorum is 5 people. But it's happened to me more than once when the appointed meeting time has arrived, the room's filling up, the agenda is long, it's going to be a long day. Somebody invariably is stuck in traffic. Or it's a foggy, cloudy day like this, and somebody's plane is late. And often that person who's stuck in traffic or at the airport is the person whose presence would establish the quorum. And there's often an inclination to just kind of want to get things underway and get on with it. But the answer to that is always no. You cannot start the meeting without a quorum physically present in the room. And even if they've come, but they've gone to get coffee or they need to be physically present in the room, a quorum, before the meeting gets started. Another thing about quorum, when you are thinking about that, don't forget to consider the status of new members. When you have new members, a person has to be fully qualified to participate in the meeting, and that may mean taking an oath, that may mean signing something. The appointment needs to be official so that person can participate. You guys don't really have this problem, but there's a really famous case which is sort of silly sounding and embarrassing, but it makes the point. It had to do with a board that had 3 members. 2 members were in the bathroom discussing public business. There was a member of the public in there overhearing this, and that was considered a violation of the Open Meetings Act because these 2 members of a board of 3, and I will say a board of 3 is really a challenging way to get things done, but 2 members talking about public business, not in a public meeting, but in private, in this case in the restroom, was considered to be by a Texas court a violation of the Open Meetings Act. So, you know, be careful, and we're going to talk more about walking quorum and ways that you can, things that represent real liabilities and risks to you, and that's one of them. So when there are 5 of you together, talk about the college football season or the drought or whatever, but beware of talking about issues of public business if you're together at breakfast or wherever. And there are, of course, some exceptions and safe harbors to that. If you were to be in front of a legislative committee, for example, if you were to be at a purely social event where you're not really discussing public business or where any discussion of public business is just kind of something to the side and you're not voting. But in essence, if you are in the presence of a quorum of your board, you really should be talking about something other than the business that you have jurisdiction over. Another conundrum that I've seen that has to do with quorum, and you kind of made reference to this problem earlier when you were talking about your membership and members participating in disciplinary proceedings and then having to recuse themselves. An interesting question that arises, and I've actually been in the middle of this and had to do some research on it, had to do with the question of how few of your members can actually bind the body on a question. There are 9 of you, and ordinarily you would think, well, it takes 5 people, to make something happen. But I was in a situation where there was a 9-member board, and they needed to vote on it was a settlement agreement that had been long coming, very vigorously negotiated. So picture this, there were 9 members of the board, just like you guys. 2 people announced ahead of time that they could not attend the meeting. They would be absent from the meeting. So that left us with 7, no problem, right? We still have a quorum, no big deal. So we started the meeting and so forth. However, 7 of those people, of those 7, 2 of them had served on one of these disciplinary committees. And so, as is so typical for state agencies, if you work on some sort of negotiation and so forth, you're going to be recused from voting finally on that. So they were, by statute, barred by voting. So how many are we down to now? We got 5 people. That's very, very common to have those people recused. Okay, so of the 5 who were left, our chairman had served as an expert witness in some litigation that was related to this very same set of circumstances. A couple of years before, there'd been litigation. He was an expert witness. Now there was a complaint filed in a disciplinary matter. So because he had been an expert witness in that case and had been involved in litigation, he certainly was not comfortable and did the appropriate thing by saying, I cannot act on this. I'm recused from participating here. So we had 4 members who went into a closed session under the litigation exception to discuss this case, and they had to take a vote. They came out into public session, took a vote on the agreed settlement, and they voted 3-1 to approve the negotiated settlement. So of a board of 9 members, you had 3 who were qualified, or you had 4 who were qualified to vote. It was a 3-1 vote, and 3 members of that body bound the board in that decision. So that is a very counterintuitive sort of result. As I say, when the question came to me and the chairman was like, well, I can't vote and they can't be there, I had to hit the books and do some research on that. But so it's very counterintuitive, but that is the way it works, and it's really based on the principle that, the show has to go on, right? You can't just be dead in the water. So that was sort of an interesting quorum issue that is involved with this whole notion of, participants who then have to recuse themselves. Well, as you know, the purpose of the Act is to give the public access to and to increase knowledge of governmental decision-making. And one of the principal mechanisms that the Act uses to ensure that citizens have that opportunity to observe their government in action is advance public notice of meetings. And there are many, many kinds of issues that come up. Agenda preparation. What I see most often in terms of agenda issues is specificity. What is adequacy of notice? And because it does come up so often, we actually have some law on the books on that issue of what is adequate notice. Of course, that does not answer every question that will come up, but there is at least some legal guidance from Texas courts out there on that. And I'll give you some examples of that in a minute. Notice, of course, has to be posted for a certain amount of time. Because you are a statewide entity, you have to have your posting up for 7 days. But the statute actually says 7 days before the date of the meeting. And I will tell you that the Secretary of State interprets that to mean 7 full 24-hour periods that the notice is up there. If you call the SOS and try to, call them on a Friday afternoon for a meeting that's the next Friday morning, they're not going to lecture you and they're not going to refuse to post your notice, but they're going to let you do the math. But you have to hope that somebody doesn't challenge that, because you really need it to be up there for 7 days, according to the words of the statute, before the day of the meeting. I recently read, it's a fairly new 2012 case, an untimely notice case called Cooksey v. Texas. I've got these citations if anybody wants to look at them. That notice, in that case, the notice was untimely by 3 hours. And the court threw it out, said it was not good notice. So this is not a substantial compliance standard. It's a literal compliance standard on time of posting. Okay, let's talk about the content or the specificity of notice. As I said, there are some legal cases out there that give some guidance. In general, the principles are, one of the most important principles that's come out of the cases is, the more contentious something is, the more specific you need to be about notice. And the cases, the Cox Enterprise case is probably the granddaddy case on that. It actually came out of Austin, city of Austin, had to do with the firing or hiring, I can't remember, I think it might have been the hiring, of a school superintendent. And the agenda for the meeting basically just said, we're going to discuss personnel matters. Court took a look at that and said, that is not specific enough. And I don't know where the line is. I mean, if you're hiring first grade teachers, can you say personnel? But if you're hiring the head of your organization, the chief, operating officer of your organization, it's not enough just to say on your agenda, well, we'll probably be discussing personnel. Same kind of thing with a desegregation case. This was the same case. Desegregation case that had been ongoing for a number of years. It was of high interest in the community. The agenda said, we're going to discuss litigation. Not good enough, the court said. So if you have something, the higher interest, the more contentious it is, the longer it's been going on, it's a judgment call, no question. But the basic principle is, the more likely that the public's going to be interested in it, be specific in your posting of what you're going to be talking about at your meeting. The object is to apprise the public of the subjects that are going to be considered during the meeting. I'll give you an example that went the other way. It came out of San Antonio. The city wanted to condemn some pieces of property for a water project, the Applewhite Water Project. So the posting went up. We're going to be discussing parcels of land, in the southwest quarter of Bexar County, which may be connected to the Applewhite Water Project. They went ahead and went through with the condemnation. Some of the landowners challenged that notice of meeting, saying, well, I had no idea. My name wasn't on that notice, and there wasn't even a lot and block number of what parcels of land you were going to be talking about. The court looked at that and said, the Open Meetings Act is not service of process. You don't, no due process rights there. You don't get individual notice. Would the public have been on notice that something was going to happen with these parcels of land? So the court in that case said that was adequate notice. So, you can find cases out there that go both ways. If you're interested in the notice topic, there's a case called Friends of Canyon Lake versus Guadalupe Blanco River Authority. It's a very good case that summarizes other cases on notice. It's from the Austin Court of Appeals from 2002. And also that Cooksey case where the 3 hours was inadequate, that's a pretty good case too on adequacy of notice.
What was the one you just said on 2002?
Friends of Canyon Lake, Inc. versus Guadalupe Blanco River Authority. It's 96 Southwest 3rd, 519. It's just a really good summary of a lot of those notice cases that are out there. Okay, a frequently asked question with respect to what you can talk about at a meeting is when something comes up. Because you are a statewide entity and you have to do that posting for 7 days before the date of the meeting, sometimes things move fast, and some issue can pop up between the time of the posting and between the time of your meeting. And so I'll get that question on the phone. What do we do? Or it may just be that someone has left something off inadvertently, left something off the agenda. I actually had one client who wanted to give his board or commission a legislative update, and it was after this latest or during this latest legislative session. And on the agenda, he had put legislative update 82nd session. Well, guess what? It wasn't the 82nd. It was the 83rd. And so he just decided not to give the legislative update at that meeting because he had not given notice. It was a technicality. I told him I could probably go either way on it, but he took the safe course, which is always the better course, and decided to just skip over the legislative update because he had not given notice that he was going to give an update on the 83rd session legislative items. So if something comes up, if someone forgets to post, there is really no remedy within the Open Meetings Act. You're just kind of stuck. You're just going to have to put it on another meeting. So, that's just kind of the bad news there, but that is the way it works. Okay, what happens if there's a topic that's not on the notice that comes up during the meeting? Because, that can happen so easily. You're discussing and one thought leads to another, and so, that happens. And it can be a member of your own board, or it could be a member of the public sitting here who says, well, what about so-and-so? So the legislature did actually contemplate that could happen. And so what happens there is, if that happens, you are authorized by law to give a responsive statement of factual information to respond to the inquiry. We have a policy on that. That would be a factual statement, but no discussion of whether it's a good policy or not a good policy or whether you plan to change it. You can make a factual statement in response to an inquiry. You can give a statement about an existing policy that's responsive to that question. What a lot of boards or commissions do is actually refer that person, board member or member of the public, to a staff member to talk about that maybe at the conclusion of the meeting. You can also decide at that point to put that question on a future agenda, something you'll talk about at a meeting in the future. So there are some options when something comes up that was not anticipated, that did not appear on your agenda. So that's just kind of a good common sense rule, but it's enshrined in law that you have all those options. With respect to notice, and I'm sorry for clearing my throat. It's some kind of pollen that's gotten to me. I'm hoping I can, with my water bottle, get all the way through this meeting, but you may hear me clearing my throat, and I apologize in advance for that. I get questions of notice a lot with respect to subcommittees. You guys are a group of 9, but sometimes it's very helpful for a board to delegate a particular task or some sort of study or whatever to a subcommittee. So the question comes up, well, does the subcommittee have to post its meetings? And of course, the safe answer is, yeah, it's always better to do that. But in terms of what you must do or when you have to do that, if a subcommittee has been delegated any authority, any kind of final authority, then they really must, they are going to be acting for the governmental body, and then they must post their meeting, just like a regular meeting under the Open Meetings Act. Many subcommittees, however, are, though, advisory, truly advisory in nature. They're asked to study something, bring a recommendation to the larger board, and if it is truly an advisory committee and has no authority, no final responsibility, no ability to take any action, then you can be pretty safe. I got that question actually just this week or last week. We have a 3-member advisory committee to the board. I promise they're really only advisory. They can't do anything. Can they meet by telephone instead of getting together? And my answer was, if they are purely advisory, then they are not subject to the Open Meetings Act. And so, yes, they can meet by telephone because they're not governed by the rules and the laws in the OMA. So That is a common question that comes up about these subcommittees.
Nancy, can I ask you a
Uh-huh.
question on that?
Sure.
If it's your agency's policy to post open meetings notice for this subcommittee, we have many three-person committees, and so you're posting it voluntarily, taking the safe course of action, but they truly don't make any decisions. Is the fact that you're posting it and by history you have posted it, would that preclude you from allowing telephone?
I don't know. I don't think it would, because at the end of the day, it is not a meeting that is, given everything you've
Right.
told me, it is
Right.
not a meeting that is subject to the Open Meetings Act. Now, if you had an extremely contentious issue that people, I wouldn't recommend it if you were in that kind of situation. That is to say, a departure from your regular practice. But at the end of the day, if you are not subject to the act, you're not subject to the act. So you would have to weigh that, to see how important, who's going to really care, what's your risk, what risk are you running. But it is not illegal, if you're not subject to the act, to meet to talk by telephone.
When you say advisory, if the committee is vested with making a recommendation, they do this by telephone, they build consensus among themselves about that recommendation, would that fit under your advisory
Yes.
category? Okay.
Yes, when they're advisory, typically they do end up coming to some sort of consensus or coming to possibly dual recommendations, but they're bringing a recommendation to the board. They have no authority to implement it. They simply say, we've studied this, 2 people think this, she thinks that, or we all agree, this is our recommendation. Yes, that's an advisory committee.
And that's the way all of ours work. All we do is make recommendations to it's not one of the rubber stamp kind of committees that are set up and everything. So.
Yeah.
With the exception of the temporary suspension, they make a decision.
Enforcement committee.
Yeah, that's
Well,
the one
that's
exception.
not one of our committees.
Yes.
That's the temporary, our employment, our enforcement under temporary, so it's not one of our enforcement.
Not one of our normal standards.
So time and place of this advisory committee is then pretty loose. That is, if we're getting together for a meeting, if we're coming to a meeting tomorrow, and we all happen to be at the same hotel the same night, and those 3 committee members got off in the corner somewhere and talked it over to say, well, that's going to be okay to come forward with that recommendation then as well.
You could do that, but you raise an interesting point, which is public perception. And I'll give you a good example of that happened right here in Austin at Katz's Diner. I won't say who it was. It was a state body. It was a state board. You know, 2 more words and you know what it is. It was a state body that was having lunch at Katz's, and some of them were sitting at this table and some of them were sitting at this table. But there was this little person who was kind of running back and forth and taking paper over here and over there. And guess what? There were members of the public at that restaurant, and some members of the public who were pretty critical of that board, and it was, you know, kind of a political deal. Imagine that. And it was in the newspapers, and it was embarrassing, and they had to come up with a final agreement. They had to get some special training from the Attorney General's office. You know, the Travis County DA was after them, and it was a mess. So don't forget and don't underestimate public perception issues. So, you know, hovering over in the hotel, probably nobody would notice, but...
But they weren't discussing board issues.
Well, actually, that was the allegation. You know, these people at these 2 restaurants, and a staffer was running back and forth and delivering paper. So to the casual observer, it looked like they might be doing business. I don't know whether they were or not. Maybe they were, you know, trading their predictions on OU and Texas. I don't know what they were doing, but it looked bad. It looked really bad. And it made headlines, and it caused them to have to do a deal with the DA, or the county attorney, I think it was actually, not the district attorney. So nobody wants that. You don't want those kind of headlines, and you certainly don't want those kind of sanctions. And so I'm glad you asked that question, because it does raise that other issue of there are things that are legal and illegal, and there are things that are problems because they are public perception.
Right.
So.
And part of what our committees have done historically is do post it because they do want the transparency and they do want the public input. That's part of
Yeah.
a very helpful part of the process.
Well, that is a safer course for sure. Okay, so that's quorum issues and notice issues, things like that. Open and closed sessions, of course, open meetings are the rule and closed meetings are the exception. Members of the public have the right to attend your meetings. That means they have the right to observe and the right to listen. They have the right to audio record, to tape record. You can make rules with respect to, they can't just have a microphone in front of all your faces. I mean, you could ask them to be in the corner or whatever. You can make reasonable rules about that. The public does not have the right to speak. There's no right in the Open Meetings Act for the public to speak at an open meeting. Many governmental bodies do allow for public comment, but there again, you have the right to, within your discretion, make reasonable rules. You are required to treat people equally. If it's a view you like, you can't give them 10 minutes and then give someone who's opposed to you 2 minutes to speak. So you have to treat people even-handedly. I can tell you from experience, it does kind of have a chilling effect because when you meet in this kind of context with no members of the public time after time after time, the first time you have 10 people sitting over there and a camera aimed at you, you're going to pay attention and you're going to speak a little differently. You're going to be not quite as casual as you are in other meetings, but that is the right of the public to attend, to observe, to tape record, to video record. But no right to speak and no right to set items on the agenda by the public. The Act does not offer that. One other thing, all votes, I'm sure you know this, all votes and final decisions must be taken in open session. There are lots of questions about closed session. It's really tricky and you have to really pay attention, and that's where your general counsel, your AG representative can kind of help you stay on track. Because it is, we're all human, and you get in closed session, you can only go into closed session under a specific authorization of either the Open Meetings Act or some other law. For you guys, it's probably almost exclusively going to be the Open Meetings Act. I brought a couple of samples of the medical board, for example, has authority to go into closed session to deliberate anything relating to license applications and disciplinary actions in executive session, but that's a specific provision of the Occupations Code specific to the medical board. So there are some things like that out there, but unless you have a specific, and your general counsel will know whether you do or not, then you have to just stick to the provisions of the Open Meetings Act itself, and you have to find an exception to go into closed session. You are not authorized to go into a closed session just because something is embarrassing or difficult. I had to go over to talk to when it was the Texas Youth Commission. They just couldn't believe that they couldn't go into executive session to talk about these young people who had gotten into terrible circumstances one way or another. Well, there are ways that you can protect people's identity and not talk about their actual specific name. But if you don't have an exception, a legal exception to go into a closed meeting, you can't just say, well, this is just really sensitive information or, humiliating or something. You must find a specific statutory provision that allows you to go into the closed meeting. Probably the most commonly used ones are the attorney consultation exception, and then for some entities, the ones that have to do with real estate transactions, if you're buying or selling property, that sort of thing, and also personnel. Probably attorney consultation and personnel are the two that are used most frequently. You can go into closed session under the attorney consultation exception to seek advice about pending or contemplated litigation, and it's important for you all to know that within the definition of litigation is administrative actions. That's considered to be litigation for that exception. Also to preserve the confidentiality of communications that would be protected by the attorney-client privilege. And that exception, I should mention, you probably know that one of the record-keeping requirements of the OMA is that when you go into a closed session, you must keep either a tape recording or a certified agenda of what goes on during that closed session. The one exception to that is this attorney-client exception that where you go into closed session. You do not have to keep that when you're talking to your attorney. However, you have to keep in mind that that is not just a free-for-all. If you go into that closed meeting under that exception, you really have to keep your remarks tailored to those kinds of things. Advice or advice of your counsel about pending or contemplated litigation or settlement, or attorney-client advice. So it's not a time to say, let's say, for example, there's a suit on a contract. You're in that closed session. Okay, counsel, what's going to happen if, that's fine, that's fair game, but not, well, why did we ever do this contract? Next time, let's don't do that kind of thing. That's policy that's related to that contract. It's related to the same general topic, but it is not tailored to that exception, which is your permission to be in that closed meeting in the first place. Does that make sense? I mean, do you see that distinction? So it's not really a time to be broadly talking. You're there for a very specific purpose. One other thing about closed session, I'm going to emphasize this again. Straw polls, voting is not okay. However, I have read a couple of cases that say it's all right to express how you intend to vote when you go back out into that open session. Now, I'm not inviting everybody to start that practice, because it's not okay to take a vote. And there are cases out there, and more people are using the Open Meetings Act as a way to bring challenges to actions of boards that they don't like. And one of the best cases I've read on this recently, it is also a Third Court of Appeals case. It was the Enron accountants, and the Board of Public Accountancy was trying to take away some of their licenses or discipline some of these accountants who had worked on the Enron matter. And of course, the allegation was that they knew what was going on, and they had obligations to take actions that they did not take. It's a really useful case because it emphasizes the dangers. Here it was alleged that the members of the Board of Public Accountancy had decided everything in closed session already, and so when they came out into open session, they just, they took the vote, and they must have had everything decided already. So that was the allegation. And the Third Court looks at that very closely, looks at all the evidence on that. And I like this case because it's a case of where the board actually got it right. I think it's a really pretty useful outline of how your board can act properly to demonstrate that you did not make a contentious decision in a closed session. And so I recommend it to you. It's called Texas State Board of Public Accountancy versus Bass. And it's at 366 Southwest 3rd, and it is a 2012 case from the Third Court of Appeals.
I don't think you gave the full sign.
It's 366 Southwest 3rd, 751. Yeah, I left off the page number. Sorry. Just have fun with the whole volume of 366. Okay, let's see. Oh, here's another question about closed sessions that sometimes comes up. Who can attend a closed session? Who can go in? There was an interesting, when I was on the opinion committee, we had a question about, I think this, I hope nobody's offended by this, it was from Galveston. So I'm not trying to bash Galveston. All these cities have their challenges under the Open Meetings Act. But in Galveston, I think it was a city council that was meeting. No, it was a school board. It was a school board that was meeting, and the way that they wanted to do the meeting was they wanted to go into closed session on personnel because there was apparently some allegations toward the superintendent. So that's proper, right? You have a personnel exception. They went into closed meeting. Here was the problem. One of the board members would leave the closed meeting, go out to the group assembled at the open meeting and say, does anybody here have something they want to say about the superintendent? Come on in to the closed meeting. So basically what they were doing was holding the open open meeting, except it was a closed meeting, and they were just inviting whoever wanted to come in one at a time to come in and talk about the superintendent. I guess I can see from the smiles on your faces that you know that that was not okay. So who can attend a closed session? Board members have the right. Board members are the ones who have a right to attend the closed session. No one else really has a right to be there. You have the discretion to bring in staff members who can assist you one way and another, who can help you conduct your closed session. Some groups have a policy, some school boards, for example, have a policy that they always want their superintendent to be in that closed meeting because that's someone, who's going to be able to aid them in their decision making. Counties will call in the county auditor. City may call in the city secretary. You can bring people in to assist you in your deliberations in a closed session, but it has to be someone whose presence is necessary to the matter under discussion, and it has to be someone whose presence will not defeat the reason that you are in closed session. And I think there's some case out there where it's a real estate transaction and they wanted to bring in, it was about real estate negotiations. Well, why are you in that closed session? To protect the entity's bargaining position in a negotiation. So you do not bring in the other side to the closed meeting to talk about the real estate transaction, because that is the example of defeating the purpose that you have been given that exception to go into closed session. Let's see. Okay, this is a question that does not have a legal answer, but it came up fairly recently. I was assisting a board in a very contentious disciplinary matter. It had been a big deal locally in one particular Texas city. And the professionals in that city were kind of all at war with one another. And one of the board members was from that city, and he had been lobbied hard by both sides. And so as a result of that, he felt like he should recuse himself from voting on that matter, which I think was appropriate under the circumstances and so forth. However, when the board was about to go into closed session to talk about this litigation matter, he asked me if it would be okay for him to come into the closed session. Well, as I say, there's not a hard and fast legal rule on that. He has a right to be in the closed session, right? Because he's a member. However, he has voluntarily recused himself. Well, why? To avoid the appearance of being involved in something. He did not plan to vote. So could he come into the closed session? I asked him not to, which was kind of risky, you're sticking your... No, sir, I don't think you should. But I didn't think he should be in the closed session. If he recused himself, meaning he didn't want to be a part of, why be there? Just for curiosity? So it's an interesting question. I didn't quite know what to do with it, but I thought it would be better for him not to be there. What do you think?
Well, I actually had the same issue.
Really?
For a board. And like you, I suggested that since this member was not, that he was recusing himself, there was really no reason to be in closed session. He didn't care.
And furthermore, the public cannot see what's going on
Right.
in public session, in a private session, a closed session, and so all the more reason, not to. If you're going to recuse yourself, just recuse yourself for all purposes. No voting, no participation, no discussion, and there again, the perception problem of, on the record, I'm recusing, but I want to be in the private meeting. It just didn't seem to add up. So,
in fact, it will make it worse because my experience with boards is they're all suspicious of closed sessions anyway.
yeah, sure.
I would raise the point, though, given that board members are given the right to go into these meetings, as you mentioned before, there have been opportunities or times where it is necessary to come into a board meeting, not for discussion purposes, not just to listen in because you're nosy-rosy or whatever else, although you have the right to do that, and you do need to weigh the public perception very heavily. There's no doubt, but to make sure that within the closed session that is conducted in a manner that it's supposed to be, that other things aren't being discussed. And we've had that issue in our meetings. So there are times that I would beg to differ that there are times that it is better for the public to have certain board members within there, even if they have recused themselves.
Well, there's no firm answer on it, and I think you'd have to look at every situation and ask, what would be the purpose? If you could establish an important purpose, it could be that the person wanted to recuse themselves from all participation, but maybe they have some piece of information that needs to be shared. So I'm not saying it's a hard and fast
rule. I just want
rule.
to make sure that our attorneys heard that it's not a hard and fast rule.
It is not a hard and fast rule. There's no legal principle that really guides it. I think it's, again, a weighing of all the circumstances, in a particular situation. A word on the certified agenda. Sometimes questions come up about that. It's kind of an odd term. It's not a natural term that we hear anywhere else. This is what's kept, the record that is kept in a closed meeting if you're not keeping a tape recording. It is highly confidential. A court can review it in camera if there's litigation. In other words, under seal, the court can look at it itself. But what is it? What does that mean, to have a certified agenda? It basically means that there is, if you look to the statute, it's very few requirements. You basically have to have a statement of the subject matter of each deliberation, a record of any further action taken, and the presider's announcement at the beginning and the end of the meeting, indicating the date and the time of the meeting. I know of only one case on this. It's an unreported court case, San Miguel versus City of Laredo. I've got a number for it, like a Westlaw number for it. But that court, with an allegation that, it had not been done properly, just looked right at the statute and said, they did this, they did what the bare minimum requirements. So in other words, what this tells you is your certified agenda, if you're doing it in written form, does not have to say, he said this, well, so-and-so disagreed with that. I mean, you're not keeping minutes. It's not minutes. You have to have the subject matter of each deliberation. And then you have to have the presider's certificate certifying that the agenda is a true and correct record of the proceedings. And that's why it's called a certified agenda. It's certified by the presider to be accurate and correct as to what went on during that closed meeting. The Act contains civil and criminal penalties. The civil penalties that are out there that are most oftenly used are invalidation of some action that a board or commission has taken, an injunction. Someone can go get an injunction to stop you from doing something if they think you're about to do something that violates the Open Meetings Act. And then also mandamus. Go get a court to order you to do something that you're obligated to do under the Open Meetings Act. The most common one, of course, is invalidation. And the best example I know of this is a Texas state board that met and decided to fire its executive director. And their posting was inadequate. Their meeting was an illegal meeting or not properly held under the Open Meetings Act because their agenda was deficient. So things rocked along. They decided they would ratify that action, do it again later. They messed it up the second time. At a third meeting, which was a properly held meeting under the Open Meetings Act, they decided to fire their executive director. Guess what? It was 17 months later, and the termination was effective, but the board was on the hook for salary and benefits for 17 months, the entire time that this person had not been legally terminated because of a violation of the Open Meetings Act. So that's a, kind of a cautionary tale about the import of the act, how embarrassing would that be, and so on and so forth. So it's important to get it right. At this point, let's see, I think I'm going to stop. There's some interesting litigation that took place. I'll just boil this down to a nutshell. The Rongra case that started out in Alpine, Texas, has been sort of the most interesting litigation of late about the Open Meetings Act. It basically was a challenge, a First Amendment challenge to the Open Meetings Act and a challenge to the criminal provisions. And it went to, it was in federal court. It went to the Fifth Circuit twice. It went to a panel. Then it went on an en banc hearing. And the Fifth Circuit upheld the act. Appeal was taken to the United States Supreme Court, and in March of 2013, the Supreme Court of the United States denied the petition for writ of certiorari and said the Fifth Circuit got it right. The act does not deny people their First Amendment rights to say anything, anytime, anywhere. And the Fifth Circuit case, which is the law of the case now, stands as the principle that the TOMA is, Texas Open Meetings Act is constitutional, that it works to prevent, or that it works to prevent negative secondary effects of closed meetings, which the court said prevent transparency, encourage fraud and corruption, and foster mistrust of government. So our court system all the way to the top has, beat back that challenge to the Open Meetings Act. However, the Texas Municipal League, among others, argued in that case that the Open Meetings Act is a bar to well-intentioned officials who want to be able to talk to one another in between meetings. And here we are, we find ourselves in this age of rapidly developing technology, tweeting, texting, all this stuff. And we can't talk to each other until we get together, in a meeting. I mean, maybe one of us can talk to another one, but what happens if that second one goes to member number 3 and 4, and then one of them goes to member number 5? At what point do you have a quorum involved in emailing or texting or tweeting? And let me just say that this Alpine case all started among some city council members who were emailing each other about the hiring of some consultant. So even though that was not the issue that was directly addressed, it was more of a constitutional challenge, that was the set of facts that got that whole thing going. So certainly...
And wasn't that even, they were just asking about putting it on the agenda?
I don't remember that detail. I thought there was one woman who was actually saying she endorsed some contractor or whatever, but it may have involved agenda issues too. But it basically public business, issues of public business, and email.
Didn't the city of Austin get their wrist slapped over that too?
Actually,
walking emails?
recently,
Yeah.
yes, recently, yes. I've got some, articles about that, and there were never really any admissions, and I think a deal was kind of cut, and so on and so forth. But there again, you've got the headlines, and just that mistrust in government. And that's just, you don't want that. You certainly don't want to be the governmental agency that is, in the headlines in that way. Yes, you're right. That did happen, even more recently. So anyway, back to this TML argument and others' arguments that you're kind of constricted, as officials in being able to talk to one another. Well, in the 83rd session, there are really probably 2 items that you need to know about that were passed during the 83rd session. And there are problems associated with both of them, and many questions will remain to be worked out. But what is now the law is that it is not considered a meeting under the Open Meetings Act if members communicate with each other via an electronic bulletin board that is available in real time to the public. I don't know of anybody who has done this yet. I know there are people talking about it. I know the Department of Information Resources is looking at the technology, to make this happen. It's out there. I think it will inevitably cause some problems. Think of all the problems of emails that people never thought somebody else was going to see. It's going to require discretion. It may require, agencies creating their own policies. But it is the law that you can communicate with one another via an electronic bulletin board that's available to the public in real time, that is accessible. If you take something down, it's still going to be accessible, for X amount of time and all of that. So there are a lot of details with respect to it, but it is a pretty innovative idea, and it's out there to help communications and modern technology, be available to you, but also to preserve the public's right to observe what their governments are doing. So that's new, and also the other thing that's really new and that everybody's talking about, and again has not quite figured out how to use, but it's coming and it's the future, and it involves a lot of technological questions, and hopefully will save agencies money once you get past the front end costs, is Senate Bill 984 by Senator Ellis, which would allow governmental bodies to, generally, to meet by video conference. There are certain ones that can now, but you have to have special statutory provisions to be able to do that. There were actually two bills, a Senate bill and a House bill, and they, by the way, have a few differences that have not yet been reconciled, and so there'll be some AG opinions on that to come down the pike. But basically, it's a move toward the future to opening up much broader, greater use of video conferencing meetings. You still have to have a place where your presider is and where the public can come in to the meeting. The public has to have a microphone and a camera so that they can participate to the extent they could in some other type of meeting. There are many unanswered questions. One of the bills, I think, mistakenly left in words to the effect that you got to have a place where a quorum is gathered. Well, what's the point? You know? But anyway, that's why I say these have not been reconciled, because one of them has that and one of them does not. One of them does not require that. So I can't tell you.
The presiding officer, right?
Yeah. Mm-hmm. So I can't tell you how that's all going to shake out, but I am telling you that is the future. We're definitely going that way, and it's intended to allow greater participation so that if you've got, your leg is more badly damaged, but you're in a location and you could participate in the meeting, you can still do that. But your visage has to be seen, you have to be able to be heard, because the idea is that the public needs to be able to see that you are actually talking and speaking, and that you're not like rolling your eyes or like doing this, like, oh, that guy, none of that, So you got to be able to be seen and heard, and so a lot of technological details to be worked out on that, but that is definitely the way of the future. Okay, there were a lot of other proposals, none of which I think were so significant that we need to talk about them here, but basically that's it. This is an act that it's here to stay. The legislature, the courts, the Texas Supreme Court is very much an advocate of this act. We now know the United States Supreme Court doesn't think the Texas Open Meetings Act, which is one of the most robust in the nation, is a hamper to people's First Amendment rights, to public officials' First Amendment rights. There will be new questions. It amazes me the kinds of questions that keep coming up. You'd think that by now all the questions about the OMA have been answered, but especially with this new legislation, there'll be more questions. But it's an area to take seriously, and it does represent a certain amount of risk. So I advise you to listen to your legal counsel and to be cautious and to take the safe course, which it sounds like you are doing already. So I'll take questions if anybody has any.
Go ahead.
I assume this would be a good time to ask this question. Could you just elaborate a little bit about abstaining from voting? Like in our board meeting tomorrow, it's my understanding we can do that, but how does that work?
Well, you just you announce that you're abstaining. You're not required by law to explain why that is. I suppose it could be, if you've got a quorum, abstentions usually come up because someone personally feels like there's some sense of conflict of interest, or it could be that you feel like you don't have enough information. Particularly when you're a new board member, I have a board right now that I'm working with, and they've got a difficult personnel decision to make. Well, the evaluation tool went out, and 2 members said, I just came on the board. I don't feel like, so they abstained from participating in that. That seemed very appropriate because they would have really been acting on hearsay as much as anything else. So, you want to limit that to the extent possible, but there will be times when you either are not well enough informed or you feel, for whatever reason, some sort of conflict of interest. Let's say one of your fellow colleagues, someone you know well, is before this board in a disciplinary matter, that would be appropriate for you to abstain.
Okay, now that wouldn't affect, let's say we had a quorum, or like your example you were giving earlier a few minutes ago about a board of 9, and 2 are going to be gone, so it's 7, and then to recuse themselves?
Well, 2 were on that committee, the
So-
discipline committee, so they had to
Right.
go off.
But technically, there was a quorum of 7.
Yes.
Right, so in this case, let's say the same scenario, there's 7,
Mm-hmm.
and even though there was 9, but there's 7, and then let's say 4 people abstained. I mean, you still got the quorum of 7, right?
Mhm.
So
If you
that's
have
what you
a,
look at.
yes, if you the quorum is important because you can't start a meeting without a quorum. So if you have a quorum there present, you can engage in the meeting. But when it comes to voting on a matter, it's a matter of who is there and who is eligible to vote and willing to vote. And I guess eligible means someone who's not abstaining. So yeah.
Okay, so
Well,
you can
but-
abstain.
I need to interrupt here on the Robert's Rules part of this, which is not the open meetings. Your abstention works, and you guys can correct me if I'm wrong, but your abstention works as a yay vote, so it doesn't exclude you from the quorum. The quorum is still there, so when they're doing an actual, and it happened at our last meeting, where 3 of us abstained, what it actually does is not count as a no. So we go with the majority on that as a yes.
Okay,
So your vote is a yes, but you're saying, I'm not voting yes, I'm abstaining, and you don't have to say why whatsoever. If you have a conflict, it's important, I think it's important to say, hey, this is my law partner, and I don't think I ought to do this because the public likes to hear those things. On the other hand, if I feel like staff may have not done enough research or whatever else, I don't want to call them out in the middle of the meeting, so I may just abstain, but it goes as a yes vote. And y'all can correct me, but I can pull it out of Robert's Rules.
Well, yeah, and Robert's Rules, of course, is that's a different body. Some groups use it, some don't, so.
But even under the Open Meetings Act, it doesn't exclude the quorum.
Right. No.
And even if it doesn't, those that do vote, even if it doesn't go as a yes, if it goes as a no, the fact that you abstain goes as a yes.
That's right.
Okay.
And let me also say.
I know it's very interesting. That's why you would want to go for a no. Right.
Okay.
Yeah, because there is confusion. I don't know if anybody here has it. I've run into it with boards, though, as to what constitutes a quorum or when you can vote. A quorum is simply a majority of the members of the board. It's not a majority of the voting members of the board. I don't know if that helps clarify any of this or not.
Did you have a question, Austin?
Just one distinction that has come up that I think is important, and you started going there, but then went off on something else. And that when can you talk about personnel matters in a closed session versus when they have to be in an open session?
Okay. The Open Meetings Act does have a provision that when you intend to go into a closed session to discuss personnel, that person, first of all, one distinction is you're not authorized to go in to talk about a class of personnel or a group. It's an individual person. But if that individual person who is the subject of the closed meeting deliberation requests that deliberation be held in an open meeting, they have the right to request that, and you have to follow that request and honor that request. So you may intend to go into closed session, and that is a good question, because particularly if that comes up at the last minute, everyone thinks they're going to be going into a closed session to discuss this, matter, and then that person asks that it be held in the open. That changes the character of things, and it changes people's comfort level about what they're willing to say, and so that can be a pretty tense situation.
It can get pretty ugly too.
It can get tense and it can get ugly, and so it's something real. I'm glad you brought it up because you don't want to be blindsided by that. So anytime you have a contentious personnel issue, you plan to go into closed session, just remember there's a possibility that person could ask that the discussion be held in the public.
And
So
you have to honor that?
you have to honor that. Yes, they have the right to ask for that.
And it is important to recognize too, because they have the right to do that, that they may be using that intentionally.
Absolutely.
So that you won't come out and say some of the things that you otherwise would have said. So you got to stay strong. You may want to word it different, but you got to stay strong on what you would have otherwise said, because
It's a tool that can be used against you. Yeah, I agree. Anything else? Well, Carrie has your specific instructions on going to the AG's website, and you go to the Open Government section and Open Government Training and click this, click that. I think this set of instructions is specific enough that will get you from point A to point B where you need to be with your with your issued certificate.
And that counts for you coming?
Yes, this
Yes,
counts for today.
yes,
Thank you
absolutely.
very much.
So, Mr. Chair, is this something that you are requesting that all the board members do?
I think has everybody done this?
Well, that's one,
No.
I think I have, but I'm not positive.
We do not have certificates on file for everyone. So Tony has a list of who we
Yeah.
have and who we don't. And if we don't have one, then just go in, fill this out, today's session counts, and send it in to us.
Which leads me to my
This will be
second
my first
question,
one
is
in
if we
10
did it
years.
3 or 4 years ago, do we need to redo it?
You do not. At the time this bill was passed, General Abbott was really pushing this bill for training for members, and it was hard enough just to get the basic bill passed. You know, I think there was an original intention for it to be renewed, but that is not part of the bill. And so as long as officials have 1 hour on open meetings and 1 hour on open records, unless you have designated, somebody as your representative there, you're good to go once you've had it.
But there's no reason for you not to have done.
Yeah, you could update it. You could, I mean, you could show, I don't see any harm in that. But no, you only have to have one certificate on file.
Can I ask you a question from this last legislative session
Sure.
dealing with, I guess it's Information Act more than open meetings, but it's still there. Of the rumored bill that was out there, that even if your equipment that you're using is personal, it's my personal iPhone, it's my personal phone, it's not the state's, that I'm asking Jamie about something, that's discoverable under the Public Information Act now, that it's not just a state-issued device.
Correct.
Okay.
And that was the position that was taken by the Attorney General's office in rulings before this legislative session, but it was enacted in law this session. So yes.
I think that's important for, the whole public to know, because, I've got so many friends of mine that carry around 2 phones. This is my personal and this is my work, and then and it's like, you can keep on paying those bills, but.
Yeah.
No protection.
Right. Just do all your work on your work phone.
Right.
If you do nothing but personal stuff on your personal phone, then you don't have anything to give up. But if you're doing work issues, public issues on your personal device, it's actually subject to the Public Information Act.
It is?
Yes, it is.
Are you checking our email even? Like, from the emails that we got from?
Yes, it would be subject to the Public Information Act. I mean, you're not really risking very much there. It's not
Because
that
that's
all
already
your
open.
personal.
It'll
that-
already be on our
It
email.
all, right.
Yeah.
But if you come back and forwarded it to me, the same email, and say, this is BS or something like that, then that's.
Potentially
That's
discoverable.
Yeah,
Well,
absolutely.
nothing
Well,
to
okay.
say anything
Well,
like that.
let me just show you as an example here, and maybe this will help me out. See, on my mail system, I have the agency folder, then I have my personal folder. So if they wanted this by open record, they're only allowed to go into the office
That's correct.
folder.
That's correct.
They can't
Unless-
mill around in my Gmail. They
That's
can-
exactly right.
Okay.
Someone would ask you, do you have anything that's subject to this request? And your personal stuff's not going to be subject to
Yeah,
that.
but the 67 GLO emails I have right
Yeah.
now would be.
Yes.
But if you
Absolutely.
have something in your personal folder, or you've done any texting on this phone, or that phone, not mine, then that's subject to it.
That's about
Even
public
though-
business.
even
Put it
though
in the
you
wrong
call it
folder.
personal.
Yeah, you put it in the wrong folder. If it's about public business, then yes, it's subject to. But you're the one who's going to be turning this stuff over.
Yeah.
So we presume you're an honest man.
There you go.
Nancy, thank you very
Look
much.
at
We
this.
really appreciate it.
You're very
Yeah,
welcome.
thank you for coming.
Glad to be here. Enjoyed it.
Thank you.
Nice to
Thank
meet
you,
all of
Nancy.
you.
Thank you.
Thanks, Nancy.
You're welcome, Ellen. See you later.
You know where the elevator is.
Yes, I do.
You want a
Thank
break
you.
for lunch?
Sure. Okay, the time is 11:46. We're going to take a break for lunch, probably 30 minutes, but we'll just play it by ear.
Okay.
Okay, we're back on?
We're back on.
I don't think so either. I think you're right.
Mr. Beard?
All right, it is 12:28, and our training session is reconvened. And we are on agenda item what?
4, because we skipped
4.
4 to
So, and this one will be very brief unless you determine that from discussion you want to, make it longer. Because I believe all of you have been through the individual orientation, So after we get notice from the governor's office that a new member has been appointed, then on your behalf, I contact them and congratulate them and ask them, you know, make sure you get your open records and your open meetings training done. And then, you know, when we need to get your photo for the wall. And, you know, here's what the board meeting schedule is. And then before you come for the first meeting, we'd like to have an opportunity to meet with you for maybe a couple of hours, if possible, to have a brief orientation. So that's what we do to help out on that behalf. There has not been. I kind of look back through the history of the agency, and I know the members of the board have talked about this maybe having a more formal. And just looking at there hasn't been anything previously done. At least two aspects to this that have been discussed. One is having a more formal orientation, kind of like this day. So if we had 2 new members appointed in March of next year, then schedule a day like this. So generally the appointments come out every 2 years. They're 2-year terms. And generally we have at least 2 members rolling off at the end of each 2-year period. And so we'll get 2 brand new members. And if we biennially, after that, had a session like this, then the whole board would have the opportunity every 2 years to go through a reorientation, if you will, if that's something that you guys might like to see. I think tying it into the new members so that there's a longer orientation and an opportunity to get to know them as well might be helpful. And maybe it doesn't have to be a whole day. Maybe it can just be half a day or something before the meeting that follows their appointment. That's a possibility. And then I know there has been some discussion about more formal, mentoring, a mentoring program of some kind, where more experienced board members are assigned or designated or volunteer to take a new member kind of under their wing and show them the ropes, if you will. Spend more time individually with them to answer questions and talk about the business of the board and answer questions that we're just not going to get to in that short 2-hour individual orientation. So that's what we've done and what we've looked at and what you guys have talked about. And I don't have any more information to impart to you about that. It's up to you if you want to discuss any other procedural aspects of all that.
Can I make a couple of comments? Number one, I appreciate you actually assembling the orientation, because I do think it's helpful, and I know I am not alone in being a voice that said, man, is there some way for me to get up to speed faster? Because with a quarterly meeting, as a new member, even though I got my orientation and everybody was willing to help, I still felt incredibly lost, because I came in the midst of a whole lot of working product, and I just didn't feel comfortable. That might have been my own shortcoming, my own right to know who to, how to, what to talk about. And so I appreciate it. I would say I think it's a good idea to leave something formalized in place. I would say that I would bet you wouldn't get great attendance if you did it every 2 years, especially those board members that would then be going to their 3rd or 4th training, so that maybe the discussion of dividing that training up a bit so that the first 2 hours could be new member orientation and open meetings, those things that other people had already covered. But then I do think it's also important in an early process to get in a less formalized setting than our formal board meeting, to get around the table, because I think, just like I've heard going on at our lunch break, in our formalized board setting meetings, even when we have a quick lunch break, there's so much that has to be done. Everybody's returning phone calls and dealing with their own personal business, that there's no interaction. But I witnessed a lot of you all getting to know something about one another that I think just simply increases that confidence to pick up the phone and say, I don't understand this. You know, so maybe some of us struggle more with that than others. I struggle a little bit sometimes with jumping into something that I don't even know how to articulate the question well enough. But if I got some familiarity with you, then I don't feel quite so hesitant to do that. So hats off to taking up the charge of trying to put this together, because I know it's a lot. And again, I would hope that it wouldn't end here, but also that it wouldn't have to be this in-depth 5 years from now, but that we could kind of create some kind of a tool that's left in the box for ongoing use by the board. I think it's helpful.
I agree. I kind of like the idea of the mentorship thing too. And I think that if you're the mentor, you got to be up to speed and get yourself up current again for how am I going to tell this person what the nitty-gritty part of the puzzle is if you're not really feeling comfortable. So it'd make you go back and do a refresher course yourself if you're going to be a mentor. So I think that's a good idea. I don't know how we would go about implementing that process, or who you identify is going to match up with someone individually, but I'm sure we can figure that out. But I like the idea of an ongoing session, particularly, like you say, every 2 years.
Might be nice to put together a little short working group of any volunteers that want to kind of try to formalize an informal workshop idea, because I think there's more than training that's going on here. And Jamie, I appreciate the idea of having new members come at 9 o'clock in the morning for the
History.
and the open meeting, and that way I can still sleep in a little bit. And y'all aren't new members anymore after that, so you guys can enjoy sleeping a little longer or whatever else. But
4 hours.
That's a great idea.
Houston at 6 o'clock.
That's a great idea.
But
which
you know,
did not do.
you know, talking about that though, I think a meeting of the full board like this is beneficial. And I just walked in, so I don't know what was discussed prior. But when you're saying at least every 2 years, is because USPAP changes every 2 years, and also you know, the AQB is really working on, and it's going to take into effect in 2015. And I'll be the first to admit, I have a trainee, and I don't know what the new requirements are going to be. I just told him it's going to be a lot tougher, so you better finish up in 14. And so he told me he would. I think he has one more course left, and then that'll be it. So.
Very good.
So
Cha-ching, we can check that one out.
If we presented that training, yeah.
So I thought,
Okay, do we have like a working calendar, Commissioner, that, so, I guess I'm going to call myself out, because I know when I first came on, I was the one that was questioning, do we have a working calendar of the budget and how it works, and when I'm going to get to see the first preliminary draft and whatnot? Is there an official, like, working calendar for this agency? I know we have our board meetings set on a semi-official calendar.
And then anything else that's officially required, yes, I keep it on the AMS calendar tool.
Right.
So yes.
So
the answer.
somehow, I mean, is what we're doing today formal enough to somehow get the 2-year orientation on the quote official calendar?
One suggestion I would have is a lot of the items that came for this agenda meeting came from the executive committee. Remember, we had back in August, that was one of the items, and maybe that's something that gets on the tickler for the executive committee when the time comes up, like I said, on the working calendar, that, okay, we need to come up with, for this 2 years, what are the items that we think would be good for this type of forum?
And that's what I'm asking, is there some official action that needs to be taken by the board to ultimately have that be effective if the board feels strongly that every couple of years we ought to have some kind of a session like this?
I don't think you need, and correct me if you think I'm wrong, Shannon, I don't think you need to have an official action. This would just be something that could be on an agenda item for the executive committee or the full board at some point. But if you do want to do some official action, it would not be today, because today we don't have any action items, but it could be something you'd say, okay, let's put that on the board. But for something like this, it's more of a planning thing. It's not really a policy. If you want to make it an official policy, you could. I don't think
We're not
you
looking to
have
make it
to.
complicated, I just know it's a rotational board, and so
Mhm.
if, while for the next 2 years, we'll probably remember, but
Right.
if there is some kind of mechanism that gets it on
Yeah.
a more permanent setup.
And it could go on the calendar.
Well,
I mean,
no, absolutely. And if it is at a point where, you can take action on things, an agenda item about establishing that policy, and even if it's just directing staff to say, make sure that after the governor's appointments, before the next meeting, that it comes up, that it's on the agenda to set a date for a orientation like this, where the first half, I like Ms. McClendon's idea that, the history, how many times you need to hear the history. So you get the history and the open records training out of the way, and then lunch, and then you guys come together and have workshop stuff in the afternoon on things that are going on at the time.
Real-time things.
Yeah, real-time stuff.
You can do that. You don't have to wait for new member orientation for that. There are some boards who have an annual retreat or an annual workshop where they do exactly that.
Formula One, once you get a booth set up.
No doubt, I mean, that
So
conceptually.
it's really at the board's pleasure.
Right,
Okay.
I think it would be a good idea to memorialize it like we're talking about at some level, because we're rolling off. I didn't want to kind of give away a little surprise I was doing that won't be ready until the next board meeting. Excuse me, talking with hazelnuts in my mouth. But I'm putting together a notebook for all the information that I think that each board member should be able to have. It would include our act, the statute, that kind of thing. We were kind of given one of that, similar to that when we first started. Exactly. And along with these policies that we don't know where they're written or how they're written, like you were saying you wanted to know about the peer review policy or the policy on this, well, we don't find out until sometime 3 years later that there's a policy on something we didn't know. So I think trying to consolidate all that into a package, and I think having, even annually, I don't think is a bad idea to get together and say, we don't need this one anymore. We should add this to the idea or whatever.
Where to park.
Where to park? Man, where to park?
We were fixing to round up Clayton and bring him on into the garage with us.
Well, I just called Tony for the first meeting and went, "Where am I?" He directed me.
Well, you
Those
they
of you that
tell
don't
you
know
where
the
to
inside
park.
joke,
You have to find it.
our new AMC committee member didn't know where to park, and so every hour we were having to take a break so he could go feed the meeting.
Well, and after he put $3 in there, there's no way he was going to move to the garage,
That's
right?
Too committed.
I'm committed to this spot.
I was going to say, for $20, he can park in a state lot. That's the cost of a ticket,
I was gonna say, how's that?
$20.
I thought they towed you.
Not if, well,
Yeah.
if you park in a reserve spot, but if it's a white bumper, that's just public, I mean, that's free for all. Anybody can park there.
And they
Well,
just
with a
take it.
sticker.
With a
Yeah.
sticker, yeah.
Yeah, you have
But I
to.
think that there must be
Get a
someone,
$20 fee.
I know with
You get
our
a ticket.
agency.
You get a ticket, yeah.
That's
You-
okay.
It's probably under orientation process.
But it's only $8 at the garage.
Can you guys
Yeah.
not park in
we're-
the state law, but you get permission?
We don't know.
Is there no one in human resources can get permission temporarily for,
Oh, no.
oh no?
We've been through this so many.
See,
Because I know with the
Wow.
AG's office, if we have a person in human resources, and if we're going to have a visitor, whether
Yes.
they're a state visitor or just a member of the public, we can give them the information on the vehicle, and they can park on the roof of the Colorado E.
For a
Well,
Jeep.
cool, we'll call you in.
For temporary, no, you're absolutely right. But we were looking for something as a board member or
And
as
more
a commission member. They come 4, 5, 6, 7,
Right.
8 times a year, and it's like, no, there are no stickers for those people. You cannot get any kind of prearranged permission.
But you can do it prearranged for a day or two, can't you?
I can't get 9 in one
He
day.
doesn't have the, he doesn't have the
Not
spots.
for a board member. And we don't have them. Well, other than if you want to park in the garage over there, up on top. They might be able to get in there.
Yeah, that's what we get them into in E, on the roof.
Okay.
Yeah, but, yeah.
Well, 4, but we've already done 5.
Is that running?
So we can go to 6.
Oh, okay,
Yes.
never mind.
So, okay.
Okay, so,
All right.
Yeah.
So when we
Open
get
mic.
down to agenda item 13, if you want us, or I can make a note of it now, but 13 is when we'll recap any items that y'all want to be put on a future agenda.
that is tomorrow's agenda, item number 13? Is that what you said?
No. Today, no, nothing from today that's not already on the agenda for tomorrow can go on the agenda for tomorrow.
But new business? Or how do you get it on the agenda? Or do we have to put it on our quarterly meeting agenda? Is that what you're not?
Yes,
Take action.
yes, for taking action. We're not taking action today.
I know, but I mean, how do you get it on there? Just under new business for
Yeah,
tomorrow?
yeah, it would just be under new business.
Okay.
But not for tomorrow, because it hasn't been
But not for
posted. It'd have to be,
tomorrow.
it'd have to
It'll
be
be
for the
for
February.
February.
Okay,
Yeah.
okay.
I'll make a note of this.
I got it as well.
And so that's for having this meeting. Did we want to talk about a mentorship component to that too, or anybody have a
That's
thought
probably a good
process?
executive, unless there's some.
No, I think executive committee is great.
Okay, that's good. We'll just
Much
have that,
out
let the
there.
executive committee come up with the recommendations for the mentorship and the,
I guess all you'd really want is the opportunity for the board members to volunteer for that service, right? I guess you wouldn't want to obligate somebody to something they
But
might.
now you're getting into the details that might work for your executive committee instead of,
I just wanted to be sure if there was any board comment before we got there, and then had to rehash it. If you had any general concerns, you could flesh them
I'd
out.
rather wait till the open meeting and y'all have a recommendation.
all right.
Okay. Mr. Chair?
So, are we done with that agenda item number, now we're down to agenda item 6,
Agenda item 6.
discussion regarding conducting efficient meetings / Robert's Rules of Order.
So this is simply a reminder of two things, really, and then really it's a discussion, that however you want to take it. So I have given you well, first of all, the statute specifically says that the board operates under Robert's rules. Okay? And to the extent that, and Robert's rules, lots of people have copies of edition number 10 there.
You had a handout that you gave us?
I did. I'm going to tell you, it's a memo dated May 9th from Carrie.
It's at
That was the
back
next
of
thing
that
I was going to
pack.
talk about. So the first reminder is that, did you not get a packet?
No, I didn't know there was a
I'm
packet.
sorry. I put one right here for you. Put one there. Sorry.
It's the same one.
The only thing I got from you,
He handed out something,
This.
what I saw,
Okay.
it says
And this.
external, internal
Here it is.
assessment, and it's at the back of that.
Yeah, it's at the back of that.
So I didn't get that either.
It's at the back. It's the last document in the packet that I just gave you.
It's not a statement.
They're not stapled. Sorry. I'll give you this. This was,
I mean, you may have made a general statement
Yeah,
about it in the
sorry.
beginning, and I wouldn't have
Sorry.
heard it. Thank you.
but the other stuff was kind of backup material if you want more data about the history and ASC and the foundation and all that stuff. That's all in there. And the education requirements that AQB sets for licensees. That's backup material for that first session, or first agenda item. So one is that the board operates per statute by Robert's rules. Robert's rules are meant to facilitate getting stuff done in meetings. Okay? It's meant to provide some kind of order. It's got Robert's rules of order. Provide some structure by which you can anticipate, things will be done. It is not a straitjacket. Okay? very often you will hear a chair of many different kinds of bodies say, is there any objection to? And then state some, changing the order of the agenda, or adopting some kind of a motion on a procedural thing, or something that's a regular order of business, accepting a report, a recommendation that is, it's been talked about ad nauseum for a long time. And you'll hear chair say something like that. Is there any, objection to changing the rule, adopting the report, whatever it is? Hearing none, so ordered. Okay? There was no, quote, motion made, no second, no discussion, all that kind of stuff. All that is anticipated in Robert's rules, that you can vary from this very formal, we cannot say anything about any particular subject matter until somebody has made a motion. Okay? Well, it anticipates in Robert's rules that you can have a limited discussion to help frame a motion. So if somebody makes a report with a recommendation in it, like one of the committees, but you're still not ready, you particularly would like to make a motion to move this along, but you're not ready at this point because you have some questions about that report, the recommendation. You can ask for a point of information, or even without being so formal, Mr. Chair, can I ask a question? And so that begins that transfer of information to help you build up sufficient information to frame your motion. And Ms. McClendon, I think, did that at the last meeting, asked specifically for that. Some latitude on having a discussion to help frame a motion. And it's perfectly acceptable to do that. It's kind of one of those, without objection, if everybody else is equally unsure where we're headed on this item, then to get enough background to help frame the motion. It is the chair's role to facilitate the meeting. There's often you will see things like a chair calls for a motion. Okay, calls for a motion, and no motion is made. Especially in like a simple, and I don't, this is not a, well, from our experience, there are many of the, we have rules that are being proposed, and we have rules that have been out there and they've been adopted, and so we anticipate kind of the motion of just moving that business along. And so we provide a draft, a recommended, a proposed motion, which is not the motion that you need to make, but it is provided to assist the board in getting its business done. If no one actually makes the motion, the chair can make a motion. Okay? They very often do not. And almost, if they're facilitating, because that's their primary role, they, by principle, refrain from making motions. Okay? They're not prohibited from making motions, but they are. Their primary role is to remain objective and let discussion and debate foster that kind of stuff. And so if there is a pro and a con, to alternate, calling on folks who have comments, those kinds of things, to try to get through the discussion. Try to remain neutral. Try to remain neutral. I was going to say one other thing about that.
Go ahead.
Okay. The one exception is that if the chair, it's not a hard and fast rule, but there's not a named exception recognized in Robert's rules for it. But if the chair wants to engage in the debate, wants to engage in the debate, they generally should surrender the chair in order to engage in the debate. Turn the gavel over to someone else for a time, and then, because if they feel very, very strongly about something and it doesn't appear that that the point that they want to make is coming out in the discussion, but they want to engage in the debate, generally they would surrender the chair. in order to engage in the debate. Same thing with voting. Generally, the chair refrains from voting as a courtesy to maintain that image. I'm here as the facilitator and and I'm impartial. Okay? The recognized exceptions to that are if it's a consensus matter. Okay? That's certainly, all in favor say aye. There's 7 ayes and no nays. The chair doesn't need to vote. Or they say, I want the record to reflect that I voted aye. They can do that. Or they have it's not an obligation, but it is part of their facilitative role. If there's a deadlock on the vote, if it's 4-4, generally the chair, they don't have to, okay, but generally they will then vote to break the stalemate, if you will. So raising motions, you guys know how to do that. Second, and then have a discussion. It is always best to have, and I know we do this sometimes where someone will say, I think this, so forth, so on, and then someone will say, so moved. It's like, okay, all the terms of what you just said are implicit in that motion. And quite often somebody will say, can we restate the motion so we know what it is we're discussing or voting on, or if somebody wants to second, just to make sure that the person was talking for 2 minutes and it was followed by so moved. It's like, well, what did you just exactly move? That's perfectly acceptable to ask for that. What was one other thing I was going to talk about with respect to motions? I apologize.
But so moved is
Lost my
okay.
thought.
Yes, it is okay.
It is okay. And then someone will, if someone calls to restate the motion, then the person will clarify what it was that you thought what we think the content of that motion is. Okay? If it's very clear, somebody says, well, I think we should do this, and somebody says, so moved, you don't need to restate it. We know what that motion was. As long as we get a second, then we can move along.
Now, wait a second. I had
Sorry.
asked to speak about more than 5 minutes ago, maybe less than 10, and you said, one more thing, I just want to have one more thing. And you continued to go on to a point that I wanted to address before.
Absolutely.
So I'd like to,
Please.
instead of trying to teach all of Robert's rules at one time, I think if we take these pieces by piece, it's helpful. I was hoping that y'all were going to bring somebody in to teach Robert's rules. It was the glean that I got from this, and in the future meetings, it might be something that I can help at the executive committee meeting for some thoughts and that kind of thing. That people that will come in and do this for free, people that will do it as favors or what calls for more efficiency. But you had mentioned that the Robert rules are very flexible, and I just want you to know that General Robert would be rolling in his grave if he thought that that had ever been said about his rules. In fact, they're one of the most rigid sets of rules there ever are. It's by our body that we can choose to make them flexible, and that there are responses that we can do. But as far as saying that Robert's rules are kind of a fluid kind of thing, there's an answer, and people specialize this and get paid to do this in big association meetings that I have unfortunately had the pleasure, which I say in air quotes, to sit through for people to call back and forth. And you see them at the United Nations and all the other kinds of meetings. And it is for the efficiency of the meeting. I would disagree that we can have certain amount of discussion on a motion that hasn't been made, depending on what that discussion is. If it's a clarification for more information, I think that's right. But if it's to start debating your point, which happens a lot in our board member meetings, then the chair should call for a motion and then a second, and then we can discuss. Because a lot of times it may be one or two people that feel a certain way. And if you don't have a motion on the table, then we don't even have to waste our time with hearing with what's going on with that. And I think that is another example of Robert's Rules set of efficiencies that we should pay attention to.
Absolutely.
And in fact, the chair should not make a motion. He can certainly vote at a tie. He can vote anytime he removes himself or herself from the hat of the position or gavel or whatever else. But it is more often than not to move along the meeting so we can go. He can say, do I hear a motion for XYZ whatever? And then Clayton say, so moved, is there a second, let's go. I mean, he may not say, and he shouldn't say, I move to do something, but for him to say, do I hear a motion for all those in favor of, is exactly, so those are.
Can I bring up one thing, and I see this quite often, and it seems like it comes up on a complaint that we're hearing, and this is just the way that I was taught, whether it's really Robert's Rules of Order or not, but every motion that is made should have no more than 2 amendments. And one thing that gets real faulty that we all kind of get lost in the weeds on is we make an amendment, then somebody says, well, I want to amend this too.
Right.
Actually, according to Robert's Rules of Order, you can do that, but a motion should never have more than 2 amendments. And then after you made the second amendment, then the chair should call for a vote on the second amendment, then the first amendment, and then the motion as amended by the amendments. So that it goes on record clearly how the board deliberated and how they voted all the way back to the beginning of their motion. Another thing that I was, and we did this at the school land board meeting, and that's why I was looking through that. You know, we are starting to take a lot of the agreed orders and packaging them together and voting on that. Mm-hmm. You can actually, if staff knows that and is prepared to present it to us, we can do that as a consent item or a unanimous consent, and they can package all these up, present it to us, and say these cases here have all followed the matrix. They've all made the agreements. There's no outstanding issues that are associated. The other party has signed off on these, and we would, move that you accept these by unanimous consent. And then
Can you do that on agreed orders and stuff?
Yeah, and they
I know you can do it on minutes and
no,
things
you
like
can
that.
do it on agreed orders. It's actually called an agreed order. It's a consent agenda. Is what it's
Consent
called.
agenda is what it is, yeah.
So can you do that with, like, there's a lot of amendments to forms that are just routine in nature, items number 12 through 16, and take those all under one motion?
Yes, you can, and the general rule about that is if the chair anticipates that there is no, or a member can make a motion to approve 5, take these together.
Well, I do that all the time. Well, I won't say just I do. I know that you do and that kind of thing. But what he's saying is when the agenda comes out and gets
Correct.
posted, that it already comes up as a consent.
Agreed.
And then if any of us have the issue, then
Correct.
we can pull it.
Exactly right. But what that
How do you know, though, going in?
that's right. So what that requires.
No, that's why it's called a consent agenda. It's because if it's
I
not.
understand it. I mean, I understand it, and I use it a lot in a lot of other board meetings. I'm just saying, maybe I'm seeing it through the wrong set of eyes. When it's dealing with discipline, for some reason, and that's going against my crop. When it's dealing with people's ultimate licensing issue, I wondered if that still had that level of ability to be what seems like a lot less formal.
Just because it's
you're-
moved like that, does it mean there's no more discussion on it?
No,
No.
y'all are missing the point here. On the consent agenda, what it is it looks just like our agenda normally does. Only and it could be just exactly what Walker said. It could be on other items that you don't anticipate any discussion on. That you just go through. Okay, we're now on this one. We're now on, and you feel like I do that every time on these proposed whatever forms. It is exactly the same as Shannon moving for agenda items 20 through 24 to be voted on. by the recommendation of the staff is what I'm going to move to approve, and you say, wait, I'm okay with 20 through 24 except for number 22, and it says consent agenda.
No, and I understand how
I'm
it
just
works.
saying, if you let me finish for just a second, a lot of state agencies that deal with licensures do that. They have only, their list is a lot longer than that.
Got it.
And you actually do that already without the formal, you do it in practice, as you said before. And especially with the agreed orders, when Troy stands up and says, I have A through J and skip over K and then L through P, because K, there's somebody who wants to talk about it, or we didn't get it back, or there's some issue on it, where he knows that ahead of time, and he makes that, that's what the staff recommendation is, and then somebody so moved, or can make the motion to do that. But to actually create, and it's a really good practice that I see happening, it's an efficiency item. I see it happening a lot at city councils that have extensive kinds of agendas, where it is anticipated this is routine business. It meets all of the criteria for approval that the body has instructed the staff, has set as a policy. So just for example, if you said any agreed order where there's not someone here who wants to address it, and it meets all of the criteria of the person is represented by counsel, and it meets all the criteria under the penalty matrix, okay, can go on a consent agenda. You tell us that's the policy you want, and we can create a consent agenda, and then all the ones who meet that criteria will go in there. And if they weren't represented by counsel, that's something you want to take a special look at, or they're here to talk about it, it won't be on the consent agenda, it'll get pulled.
Go ahead.
As a point to Janie's comment, I have a little bit of with that. If I knew that all 9 board members were taking their time to look at every one of those cases and didn't have any questions, I wouldn't feel bad about it. But I know for a fact that they're not, to the point to where I think Jamie and I as appraisers would not want to just allow something to go by and consent to a vote without really knowing what you're consenting to and voting on.
Well, you can pull it.
You can pull it out.
Montana, that's what they're saying. And again, my real primary question, and it's been answered clearly, is that it's not statutorily required that we consider them on an individualized basis. That it's not some part of the rule or the law or something to that effect. And if it's not, so be it. I see, and again, I'm all about efficiency. I like running meetings. I think that's helpful in terms of getting people to continue to come and give us input. I'd only tell you, and again, just observation from personal experience, that the first 3 meetings that you are here as a new board member, unless you are wired different than I am, and especially if there's a consent agenda, or it's going to be easy to just go with the vote. And maybe that's the way it's supposed to be, and maybe my view of that is just strange. I just know how I felt. I felt very hesitant, with no atmosphere for someone to engage the conversation. I would never pull something off of the consent agenda the first 2 or 3 meetings that I attended here. Maybe that's the way it's supposed to be. I don't know. I express that as that's the reason I worry about. It's too easy in my experience of using consent agendas and I love them for the purpose that they're intended, which is to move things along. It's very easy for things to get wrapped up in them that maybe needed public comment or questions. And for that matter, even the public, when it's on a consent agenda, I see a hesitancy on their part to even know how to address that. So the public's out there, it shows up on a consent agenda, it gets called out, and the public's sitting there, unless they're a brave soul, they don't know how to engage in that conversation.
Well, then, I'll ask this, when we take it under one motion, aren't we doing the same thing? Should we be looking at each of these individually then?
Sure we are.
You're just saying, leave it on the agenda the way it is, and if you want to take 17 through 25, say so, and if anybody objects, they can say, I want to talk about 18, and then we'll leave that out and move on with the other ones, and so.
I'm not even lobbying for leaving it on the agenda
Yeah.
the same way. I'm simply expressing a concern. I'm
Yeah.
not
I think
saying
we
it
did
has
that
to-
last meeting.
Yeah, we've done that. We've sort of set that up already, and
I'm
So,
not lobbying
we're
for
good.
leaving it the old way.
We're
I'm
good.
fine with it
Yeah.
being on the consent agenda. I'm just telling you why I wanted to tell you that it gave me a little bit of angst.
Well, and let me address some of the angst that may be out there, is you can bet that I read everything here, and I think I have at least another board meeting available. And there's gonna be you as another one, and you've got another year left of board meetings as far as I know. If we have something to pull, we can show the newer board members, as the commissioner just mentioned, that it's not gonna ever be a full new board. So they're gonna see us pull cases. And they may not feel comfortable the very first time, but they probably wouldn't have felt very comfortable in the very first time anyway to have pulled something.
Right.
I thought it was quite smart for y'all to want to sit down there and watch us for that first meeting. No one had thought of that before. Even if you had an issue, I don't know if you would have felt comfortable to say anything. Believe it or not, on my first meeting I didn't. It's a scary thought. But back to the point that Mark was making, if you recall, at one point the commissioner was signing all the agreed orders, and we had taken up to vote to see if he could sign all the agreed orders, and we wouldn't have seen them anyway. It would have just been, do we agree? It would have been more than just even a consent. We would have consented, but and we still have that authority within the statute. It gives us the authority to grant to him the ability to sign the orders and us just go fella, run with it. And not saying that shouldn't come up again on our agenda for that to be there, but for those kinds of things to see what the public sees, then go to our statute and say, look, it didn't even have to have us pull anything or think about anything. It could be the commissioner himself as the administrator or whatever the other title is, executive director, to just okay agreed orders. We're making an assumption that an intelligent person signed his name to something he agreed to, and that our staff thinks that it is a fair punishment or whatever the case is. So I'm still back at what Mark is saying about proposed consent agenda items, and those can include minutes. You know, the way I'm seeing the minutes had one comma on this minute. Now that we've kind of gotten a flow of the way it's going, it seems silly that's not on the consent. If somebody wants to pull it, they can pull it.
And
All
I
right.
disagree. Just because I engaged in some conversation, I don't want you to think I don't want you to do it. I'm fine with running a meeting officially.
So Robert's rules, any more clarification on Robert's rules and running an effective meeting? I think it's good that you're clarifying that the point, that you try to get a motion up front, but if you don't have that and you want to have some clarification, and then somebody present a motion, and then you can talk about that motion, whether you like or don't like, or you're just.
Something real quickly here,
Yeah.
and I also wanted some clarification there, because in previous meetings where I've used Robert's Rules of Orders, it was kind of backward. It's almost like it was new business. I mean, we were doing it wrong, but it was, new business, and okay, well, if you got some new business, bring it up, and there would be discussion, and then there would be, someone make a motion,
Yeah.
a second, and a vote. But we do it. We're doing it. There's a motion and a second, then we discuss it.
And then
right?
you discuss
Is
it.
there?
I think that's the technically
There's
correct
the-
way to do it.
So this is the correct way.
Yeah.
Well, I think they were doing some clarity conversation, so that if you don't have enough information to even be able to style a vote, every once in a while, I know you'll hear me say, okay, for the sake of discussion, I'll move that. And it might not even be the way I vote, but I'm just trying to get us to a motion.
Jack sometimes she's reeling, throwing the bait out there.
So the motion has to be made, seconded, then we discuss it.
Well, and the way I've always viewed it, and again, so I guess a great form to show you I'm either really stupid or somebody taught me wrong, but the way I always viewed it was, you get the presentation of the agenda item, and
Okay.
you get whatever presentation you're going to get from staff, and then there's this window of time that if you need additional information as a board from those people out there, that's the time you gather it until you can get enough information to engage the debate at the table. So that at the time the motion's made, it's kind of when the way I always viewed it, it's kind of when you're putting the wall down between you and whatever information might be coming to you, and that the debate then gets centered to the table to keep the rest of the world from engaging. That's the way that's my common sense approach to it. And so now you all can correct me if I'm wrong.
No, I think that visual image is kind of right, and I'll deal with Mr. Black's thing in a minute, but the one that actually is named in Robert's rules that it's a point of information. So the presentation is finished, and there's a lull. Right? Because the presenter isn't making a motion, right? It's up to somebody up here to make a motion. But as a board
And
member,
the chair is waiting for a motion.
right?
or
As a
something.
board member, it's like I'm not ready to make a motion. I need some questions answered, and so it is allowed for in Robert's rules, and it has those
A
kinds
little
of
discussion.
names. Yeah.
One thing I like about Jamie's analogy, because it also takes into account public comment, right? Staff makes a recommendation, that's information coming in to the table. 2 people have signed up to speak on it. That's, to me, information coming in. Once you've gotten all that information, and you may have other questions, but that's a time where, yeah, now it's time to you've got your information, make the motion, and then have the discussion this way. If there's additional questions that come from that discussion, you can always ask staff, you can always ask the public speakers. So I think that works.
Okay, another question. If somebody makes a motion and no one seconds it, is the discussion stopped and it dies because there's no second, or do you have to have a second before you can open it up for discussion?
Motion dies for
Yes.
lack of a second.
Motion
Sit
just
there and
dies.
Wait for someone else to make a different style motion to
That's
get
what I thought.
into the discussion.
Okay.
Which brings me around to another thing. Because again, it's all about comfort level. And so we all come from very diverse backgrounds. Even Robert's Rules is interpreted out in the real world a bunch of different ways depending on what, where you're coming from. If someone were to come to our agency as a board member and they have no background in Robert's Rules, do we have a resource? I mean, is there a class they can take if they want to, rather than have a board member spend a year being nervous about whether they should even make a motion? Because we get some public members that have never served anywhere. And if we don't, I would suggest that, I didn't even know it exists, but maybe we ought to look into that.
We certainly, staff can research that. I know there are classes for people who want to be parliamentarians.
And see, I'm not looking for, there's gotta
I've
be
unfortunately had to sit through some of those.
Robert's
but
Rules for Dummies or something,
There is a
There
Robert's
is.
Rules for
You can buy
Dummies.
a book.
There is.
Okay, well, I mean, even if that's the
We have
resource
one.
we say to them, hey, I know you may not be comfortable, or you've expressed that you're not comfortable. And maybe that's a mentor thing, I don't know.
Well, that goes to, while you're bringing that up, this kind of goes to the same packet thing that I've been talking about, that we need to spend, and our budget guys here, we need to spend some resources on making sure our board members are up to speed. I think it's important that our staff takes the required training and all that other stuff, but we need to spend resources, if it's Robert's Rules for Dummies or whatever else, instead of going out and buy our own or whatever else. And I don't think it's going to be a significant line item, but it might take away from somebody's bonus they get as a state employee. That I just bring that up for the next budget cycle, since we've just passed the budget.
Probably the most common thing that you see, and I'll throw it out there. The most common thing you see that is not accounted for, again, it is. There are many places where Robert's Rule, there's a very set rule, and then it says, unless local practice varies. That's the kind of flexibility and implementation I'm talking about. But if you want the formal, yeah, everyone has a formal rule in there, for the kinds of things most of the things that are going to come up. But the one that most commonly that I hear and I see used, and if it's acceptable to the body, I don't see any reason to I've never called it out. Okay, I've never called it out and said, that's a point of order, or that there's no such thing.
But I don't think you can anyway.
I don't think I can either.
Okay,
Or
just,
to just, tap somebody else and say, there's no such thing. Point of order, there's no such thing. But that,
You aren't supposed to do that either,
Well, but
okay.
And his training
including
session.
to the chair.
Well, I guess the parliamentarian in me is that's a problem. In any case, it's this: the friendly amendment.
Uh-huh,
Okay, the friendly amendment.
crazy.
We do it. People do it all the time. You know, I'd like to move that instead of $500, we donate $750. Okay, well, that's an amendment to the motion. You got to vote on the amendment first, and then you vote on the amended motion.
Well, then you gotta get a second to the amendment.
That's right. You got to go when you offer that amendment, you have to have second and a debate and a vote, and then you go back to the original motion. However, if the body is used to it and it's acceptable to the body, that it is anticipated by the exact kind of language in Robert's rules that said, if you have a local custom that's different, that's acceptable to the organization, that's what you do. So if nobody else, if no board member raises the issue and says there's no such thing in Robert's rules, then you know there's a way around all that too. You can suspend the rules. You know, there's lots of different things. You can adopt it as a custom because we do it. We do it. There are those kinds of things. So I just throw that out. I'm not asking that anyone change anything that they do, but just as an example of a local custom that is accommodated, but you don't find it in, there's no such thing as a friendly amendment. You can look for that term all you want, and it's not in Robert's rules.
Well, that's going back to what I stated earlier, and that's why I think we need to take a little bit more of a rigid approach to motions and amendments, because I've over time watched the board get lost, or some of the board members get lost because they say, well, he amended it, now what are we doing? What does that mean? All that. And if you followed Robert's Rule of Order, like you said, an amendment is debatable. But when you get to the Second Amendment, it's not debatable anymore. You have to vote on it, and then you work your way backward. And if the board gets all confused over that, then let the motion die and start all over again. But sometimes we just...
But I think you've got to have the strength of the voice who's willing to say so. And I think all of us, to some degree, are a little hesitant to say, you know, Mr. Chair, point of order, I'm sorry, but I think you have to do it this way. And
Yeah.
quite frankly, any of us sitting in that chair seat need that help sometimes, because when you're trying to moderate, sometimes you get lost in the mix, and somebody at the board level's got to say, I'm out, back up, I'm not sure we can do it that way, and then from there we'll figure it out, because surely our council at some level will step up and say, the proper way is, if we need that much help. But
Because we're constantly amending motions and saying, well, instead of $500, let's make it this or something, you know, or it seems like there is always some little change to the motion. And so restating it, I didn't know you had to restate it and vote on it and then vote on the motion as amended.
Well, and this comes up most often is when we're dealing with somebody that's had a complaint filed on them, and we're trying to do a penalty or something, or courses or whatever.
Yeah.
Well, I'm piggybacking kind of a little bit on what Jamie had said too about the story of when you hear the story and then we can start debating. It's still kind of informal, but it's been practice or whatever. I think this might be the perfect time, and I don't think it's something that's an actionable item. If it is, I'm confident you will let me know, Carrie. That would not go on this meeting or the next meeting, but the next one. I feel very firmly about not having staff introduce cases. I think that's general counsel's position, and unfortunately you're acting general counsel for a million things, and deputy and whatever else. I think having an advocate lay out what the case is, which was what we didn't do. I think staff giving a report on their stuff is one thing, but I have never seen it done like this agency has done, where staff gets to give their position in a litigated case first, instead of and it doesn't have to be general counsel. It could be somebody you say that you would like to do it, but somebody who hasn't been involved with the case, because you haven't, right? You don't know what's been going on. It could be you know, your deputy, because I know you have so many of those people below you that have been hired so far. But that's another thing that's caused me angst, is that you already have some of the newer board members or the board members that aren't familiar with the administrative law, that they think that when they're hearing from staff, attorneys in a litigated case, that that's the way the board thinks at first, that that's the board staff doing that. And I've had a conversation with some of the board members on that, and it's not the case when you hear staff. It's a totally different, they are a different party than we are. So, and when you think about it, you think, well, we're a party to this case. It's the, you know, the Texas Appraisal Licensing and Certification Board as a party. It's our staff is a party to that case, not us. So, it's my 2 cents.
Okay, so if I might address that, a couple of issues.
And I know that's always been done that way, so I...
Well, no,
Right.
actually, it can be, usually, it's the director of the SES who's presenting it, and not necessarily the attorney who litigated it. But 2 things. If by presenting you mean, this is what the administrative law judge recommended, and, you know, there's 2 parties here today, one from SES and one from the respondent that want to speak on it. I think that's fine if that's what you mean, but if you're saying general counsel introduces the case and makes a recommendation on the case.
Absolutely not.
Okay, so
No.
it's just saying
but when
this
I say
is what.
introduce, what staff typically does is they give us the set of facts as they believe they see the set of
Right.
facts. And in fact, I've seen them on many times and recently that will say, as a fact, this has happened, when they don't say, it is our position that this is what has happened. Whereas if the general counsel, because even the director of SES still is the boss of those
Right.
litigators.
Right.
General counsel comes in and says, okay, here's party A, here's party B, here could be party C3, whatever
Right.
else. Get everybody back on page for what we're looking at. That went through the whole process, actually went to SOA. We have a proposal for decision from SOA. Make us hear those words over and over again to get us at that case. Because those are the most critical, to me, those are some of the most critical things that we do as board members, is either take away a license or revoke or whatever else. I mean, that's serious business.
Right. And I don't have a problem with that as long as you're not saying that staff can't be an advocate.
I want staff to be an advocate,
Okay.
and then I want you to go, and we've got so-and-so from staff to give the position of this, and I want so-and-so,
You know.
Mr. Ted
Right,
is going to come
representing
up
the
and do
respondent.
it. And
that's
staff
fine.
gets
That's
5
not a
minutes,
problem.
and the other person
Exactly.
gets 5 minutes.
As long as they each
and-
get to speak, that's
Right.
That's a fine way to
Absolutely.
do it. You can do that.
And does that extend to the sense of propriety about that? Does that also extend to the agreed orders or no?
I think for agreed orders, nobody needs to be talking unless someone pulls it out.
If we had a consent agenda
And then
thing,
it should
yeah.
be the person that, well, even if, like you said, even if it's not a consent agenda and we all were moving to approve it anyway, it's the person that has the discussion that would be the one who would be framing what the question is instead of general counsel. That's the way I see agreed orders, because there wasn't a litigated case.
Right. And one other thing that I will say, and I used to do this when I was director of SES and TREC, I would have the attorney there who tried the case, I would introduce the case, basic general terms, and say, the attorney who tried the case is here if you have questions. Because there may be a time when there's no one here for the respondent.
Right.
But you may have questions.
Absolutely.
Okay.
And vice versa. There may be times we don't even need to hear. There are times that we don't need to hear oral argument. We can hear the case from you, and we all may only have questions for each other on what the proposal for the decision says. We may not need to hear Troy go on and on about the way he feels about something. And I just use him tongue-in-cheek right now, in case Cindy's watching. But anyway, I mean, and truly I'm thinking of a lot of agencies that SOA uses, and general counsel sets it up, and a lot of times they just don't even grant oral argument. It's just like, we don't need oral argument. It's
Right.
Most of the times they don't, but we hope that the judge did a good enough effort putting them both together.
Oh, is that who that is?
And you're right, if say no one's here from the respondent side, y'all are comfortable, you don't have to have any arguments. You don't have to have one side describe it, the other side's not there, unless you have questions.
And I may have 6 questions for you on a procedural thing. Now, why did the judge say this when I think the statute says this? But that would be to the general counsel, not necessarily, but it would in my mind.
And I would hope you would do that in executive session first.
Of course, because you would make me. You would pull me in executive session and say, does anybody have any questions about this case before we get out
Right,
there?
because that's a very good closed
So we
session
did.
question.
Yeah.
So, okay. And I don't think that's something that needs any kind of board action. It's just something that we can change in the presentation. I don't think that
I didn't think so, that's why I brought it up.
crossing the line. So,
There's a lot of procedural things that it's a good idea and kind of, and if there's no objection, it's a good idea, we'll implement it. It's procedural.
Any further discussion about Robert's Rules of Order? We have a special guest, Avis Wukesh.
Yeah.
Like those boots. Thank you.
yeah, but do they have leopard skin?
That's
No, they got
really
state sealed.
No, that's pretty good. That's pretty
The,
good.
It says Texas Reloaders on there. Wow.
Correct.
The chair.
Would you like to sit here? You sure? I don't mind moving.
Is that presidential boots?
Yeah.
Yes. Those are the presidential boots.
Yeah. Are you going to join us?
Do you mind?
No, well, that's great. That's great.
Could I ask you a question? that
Uh-oh.
I thought of during something you said.
It's up to the chair.
At the beginning, Mr. Chairman, may I say something?
You bet.
Thank you.
How long
At the
have you
beginning,
been here?
I don't know, long enough to know.
That's what I'm Were you here during lunch?
No, I got here after lunch. At the commission meetings, in the beginning of the meeting, every time, I announce that people who wish to speak on any subject matter have a quantity of time that they are limited to, which in our meeting is 3 minutes. And I remind them of that every time someone comes to the podium. And I don't believe, this is my question, that it's staff's job, because you said, and then you should limit their time that they speak. You remember? You said the attorney should say something like that. I believe it's his job to limit the time that people speak. Is that correct?
Okay, yeah, I think we do.
Well, and he does do
But,
that.
but to make it clear, before, after we've pledged and done all the procedural things, the very first thing, as I say, everyone will be limited to 3 minutes, unless your staff reporting on a particular agenda item.
And then you allow staff that may be a party to a case have more time
Yes,
than
and the
another?
attorney representing a party to have a little more time.
Okay.
But
Make it
if
equal.
just somebody
Cases, that's what-
somebody just
cases
wants to
are
come
really
up and
different.
talk and blah, 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 and I also ask them if there's more than one person who wants to talk, I've got more than one card, 3 minutes. I'd really appreciate it if you would not repeat each other.
Walker's
And then I
pretty
do
good
this,
about
and then I
that.
do this. Now, I had a board where the
Walker
chair
lets his
had a
thing go
timer.
off
Yeah, he's got a timer.
He's got a timer that
Oh, yeah.
It
charges.
does, it
Or
beeps.
the chair had a timer, and that timer would go off.
It beeps.
Whatever.
You know,
But I
it's-
just make a
it's-
point of, like, I'm watching you. That's what I'm trying to say.
I think the only time Walker really doesn't push it too much if it's like an association person that's offering information to us. It's not like that we've asked
fudged
for
a little, but I
something.
just wanted to go back to the point that it's not staff that does that, it's the chairman.
It is.
Great.
All right.
All
And our
right.
general counsel knew that. I don't consider her staff anyway. I consider the board general counsel.
Agenda item numbers, we're done with Robert's Rules. Agenda item 7, discussion regarding placing items on board agendas and staff reports.
Okay. This was an item that was suggested by the executive committee at their last meeting. That would be a good idea to be on this. And this item also, I'll let you know, is on the agenda for tomorrow if there's any action that the board wants to take on this item, anything specific. they can do that tomorrow. Okay, but I just want to go over a few basic things and then basically, again, open it up for the general discussion. As we were talking about, there's a rule that says the meetings are conducted in accordance with Robert's Rule of Order. Robert's Rules of Order is specific, very specific in certain parts, but like use path, it covers a lot of different types of situations. So in some instances, and setting board agendas is one of them, it's a little less clear. Generally, you won't find anything specifically in Robert's Rules of Order that says the chair sets the agenda. The chair is responsible for working to have a working agenda or to present an agenda. Depending on the type of meeting, obviously it won't apply to a state meeting, but you know, the committee or the board or whatever you have can vote at the very beginning. The chair say, here's my working agenda, and then they'll say, okay, we're voting not to change this agenda. In other words, they don't want anything added to that agenda. The other thing is that once an agenda is set by whatever terms, it with or without member input, 2/3 of a vote or a majority of the members are required to change an item on that agenda. And just keep that in the back of your
Are you
head.
reading something so we can follow along?
This is just my little outlines. So anyway, that's all I was going to say about that. But there is some.
Well, no, I want to keep talking because first I can't find it, and I know it's in here, but I went already have studied my notebook, but I can't find it in the agenda item for tomorrow. Do you know where it is?
The other backup materials.
It was, there was two agendas sent out. The first one was sent the day before. The next one, it was reposted, and it's got 2 additional items on it.
It does, and so that's not what came with the notebook, and I do remember that.
Yeah.
So this is one of the 2?
Yes.
Okay.
Yes. Okay.
And where does that go on our agenda?
27.
Yeah, 27. It's
During
at
new
the end.
business?
Yes,
Okay.
it's new business.
Okay.
It's new business. But what I want to say is, as much as we're constrained, or not constrained, or we follow Robert's Rules of Order, we are constrained by the Open Meetings Act. And there are certain things about the Open Meetings Act and that I want to point out, and then I want to talk about what board practices have been, and then we'll open up for discussion. But I do want to point out a couple of things that I think that it's important under the Open Meetings Act. The Open Meetings Act, you know, as Nancy Fuller was saying earlier, you are restricted from having a walking quorum, or from saying, I want this, I want this, I want this. Now, there is case law out there that says just consulting or requesting, talking about placing an item on the agenda is not a violation of the Open Meetings Act. But there is a line that can be crossed. If you go into, I would like to see an item on the agenda for secession from the United States. You know, I want that on this agenda. And okay, well, actually, let me save that example.
I liked it.
All right, I'll do that. I'll do that.
This is
Okay.
being recorded. Be careful.
Okay, and so we do that, and then the board members are talking. The only reason I don't want to use that one, I'll use that one second, because it's not in our jurisdiction. Let's say something in our jurisdiction. I want an item on the agenda to restrict sponsors who have ever had a complaint filed against them, just filed against them, from being a sponsor. And okay, that's probably good. I want an item on the agenda from having a sponsor who's ever had a complaint filed against them from sponsoring trainees, because I don't think that it X, Y, Z. Okay, you're getting into a debate there. That could be crossing the line. So it's an interesting debate. One of the things, and I had looked this up. Actually, it's from the Texas Municipal League that Nancy referenced. But the Alpine case that started the whole thing that went up to the Supreme Court as to whether or not the Open Meetings Act was constitutional. The underlying facts of that case was that The record in that case showed that the board members discussed only what they needed to put on the agenda for future meetings. I'm sorry, that's the Harris County. But the Alpine case was a case in Alpine, Texas, where one member emailed 3 other members about what they wanted on a board agenda. Maybe they went into a little more detail. I don't really have the text of that here. One of those members replied by email to the member that sent it, said, yes, this is a good idea. I want this on there. City of Alpine prosecutor, county, whoever did it, decided that was a violation of the Open Meetings Act. And that's what started this whole chain of events. Now, in that particular underlying case, the charges were dropped. They didn't go through with the civil penalties on that case. But then the civil suit was filed that went on about the constitutionality. It's like, we have a right to talk about this kind of stuff. So the caution there is, even if you do it right, okay, you still might have to defend yourself in a lawsuit. I'm not saying that to scare you, to discourage you. I'm just making you aware of the possibilities out there if you start daisy chaining it. In the emails. Now, where's my...
Can I interrupt, or are you still on a string here?
I've got one more thing to say, and then you can interrupt me.
Well, I wouldn't be interrupting them, but...
Right.
I was going to say that, Shannon, but I refrained. Could be.
Okay. So the other thing with the Open Meetings Act and the intersection of board agendas is there is an opinion out there that the AG had, and the question was whether a criminal violation of the Open Meeting Acts occur when a person urges individual members of the Commissioners Court to place an item on the Commissioner's agenda or to vote a certain one, but I'm just concentrating on an agenda. If a person is acting, not a board member, a person is acting independently to urge members of a commission or board to put something on an agenda, not a violation, okay? If they're doing it at the behest of a board member, then that's going to be deemed skirting the intent of the Open Meetings Act. So you can't say, you know, I'm going to get my good friend over here to call everybody and say, put this on the agenda, put this on the agenda, put this on the agenda. Okay. So having said all that, I'll talk about current board practices, what we do, what we can do, what we have done, what do you want to do, type of thing, knowing we're going to have this discussion if anybody wants to take actions on it, but I'll let you make your point now before we go
It's
there.
not really as much of, I guess it is a point, but it sounds like it's in contradiction to what you're saying, and so I'd like for some clarity.
Okay.
I have been trained for more than 20 years on the difference between procedural and substantive. And when you talked about putting something on an agenda, and I say, and I want that on the agenda because I really don't think anybody ought to wear red jackets, then that has now become substantive. It's no longer procedural. When I say, I want what people can wear on the agenda, dress code,
Right.
then that's procedure, and I should be able to talk to anybody.
Sure.
Okay, I just want to make sure I understand.
No.
But if
And
I said,
that's the difference.
Clayton, I want it on there because I don't think anybody should be able to wear red jackets, then that becomes substantive.
Right.
Okay.
Yeah.
Can I ask a question? Maybe this is way too simple, but why would I, as a board member, need to be talking to another board member about what I want on the agenda? Shouldn't I just call Walker and say I want something on the agenda?
Well, you're going to her
Exactly.
point.
That is a perfect segue to my next point.
I'm sorry, was that too simple?
No,
That's her point.
And that is.
Black and white.
Current
and then we'll
practice.
get back to my succession example because I'll show you how that works too. But exactly, the best way, if you want something on the agenda, is pick up the phone and call whoever the chair is, the chair of the board, the chair of the subcommittee, and say, I think we need to have this on the agenda. Okay? No problem. And that has been done, and generally no problem. Where the issue comes up is if it's something, for whatever reason, that chair of the committee or the board decides, no, I don't really think I want to put that on the agenda. Either it's not ripe yet, it's not in our jurisdiction, it's not this, so go back to the secession issue, okay? you call up Jamie and say, I want on our next enforcement committee agenda a discussion on succeeding from Texas because I'm tired of these federal regulations and we'll just get out of the nation and we don't have to deal with them anymore. Okay? And Jamie goes, yeah, I don't think we have jurisdiction over that. I don't really see how that's a relevant matter for, I'm not putting that on the agenda. But you strongly believe that you're a state agency and this is a state and we can have that on the agenda because it's something of importance to all members of the state of Texas, okay? What do? She doesn't want to put it on the agenda. She has ultimate say on the agenda. Right now, you have a mechanism which clearly would not violate the Open Meetings Act, and you don't even have to worry about getting that, and that is at your next board meeting, when we get to future agenda items, you suggest that same thing. Now, Walker may say, yeah, I'm not putting that on the agenda, you know, and you say, no, I think it is, and I'm making a motion. I'm making a motion right here that we put this on our next agenda. Then there's a vote.
Second.
And a second.
Discussion, vote.
Discussion, vote.
And 2/3 carries.
No.
Majority.
Just majority.
Just majority.
Right. That's
Yeah,
the
because Robert's
mechanism
rule
of
said 2/3 or majority, but we've always done majority.
Oh, okay.
Majority would work.
Okay.
Okay?
Change an existing agenda is 2/3. That's what you said.
Right,
Yeah.
right.
But in the practice of this agency,
Right.
we have never taken a vote on whether something's getting on an agenda or not.
And,
Since, go ahead.
right, no, you're right.
And there has been something I've raised for Jamie to put on an agenda, a request, and she said she thought it was more appropriate for the budget committee. And I chose not to bring that up, because I can bring it up in the budget committee, but I chose not to ask for a vote, because in that instance, it would have only taken 2 people to get it on the agenda,
Right,
because there were only 3 on the committee.
the
right,
subcommittee.
right. And again, what is that? That's communication.
And the idea is that we're a working group. We really want to hear from
Exactly.
each other. The governor put us as different individuals
Right.
with different interests and different background and education and
And
whatever.
my caution was, it's because of the interplay with the Open Meetings Act. That really is the one caution and item that you have to consider when doing this. But I think between Shannon and I, we made kind of clear what the parameters are. Now, many times at the board meeting, someone will say, I want this on the agenda, and Walker says, okay. Well, that's basically consent. There was no objection, as Doug said earlier, there was no objection, so that's consent. Goes on, it's going to go on the next agenda. It's only if Walker or somebody else says, oh, I don't know, you know, then you're going to have a motion and go through that whole process.
I think the confusion came somewhere along the way when it was a much less formal setting. And in other words, I fully agree with Ms. Montana when she says, all I would do would be call Walker. And unless you reach some kind of a brick wall when you call him, then probably it's headed there anyway.
Right.
But I think in the past, we've been fairly loose, and so conversation has been assumed to be on an agenda. And what I hear us saying today is, as long as, if you want to be sure that something that you haven't gotten Walker's approval through a phone conversation is going to get on an agenda, you just need to be sure you've got it at your quarterly board meeting and make a motion for such.
Yes.
And then you can be assured that.
Well, you don't even have to make a motion. You can just say, when he brings it up, you can just raise it as a point, and then you only have to bring it up as a motion if he goes,
No.
oh,
Yeah.
there's
No
so
way.
Shannon.
Or somebody else would do.
Or somebody else does,
Right.
right?
So, yeah. And that's basically all I wanted to say. Just kind of to clarify all of that.
That's it.
Another part of Agenda Item 7 is discussion regarding placing items on board agendas and staff reports. I
Right.
forgot what we were going to do.
I
with
was
that.
just going to run through for the new members the staff report, see if, and the existing member, oh God, I gotta find what this is, and see if anybody had any specific questions on the reports. And this really is also a time where you could say, you know, we don't need to see that all the time, maybe once a year, or if there's anything in the way that the staff reports are presented that you think could be done differently, just like the procedures that we talked about. This is procedural things, just informational and procedural. So, yes, ma'am.
staff report, Mr. Chair, from enforcement whenever they give us the complaints. And you know how I am about the matrix. I've got the matrix now. Now I can't tell what level that complaint falls under because I don't have all the information, given to me. So I've asked several times, can you tell me, is this the first time that the complaint's ever had? Is this his second time around? Is this his third time around? I can't figure that out with the information that we have. So is there any way that y'all know of that we can report to the board? Complaint number 1, Mr. Smith, this is his first complaint. He's in level 1A.
Now, you're talking about not in staff
In the
reports,
matrix.
but in the agreed orders.
I was going to say you're in the agreed orders.
Yeah,
Yes.
okay.
But the staff has given us the report of those agreed orders.
Well,
And
what
I've
we're
asked them.
receiving currently in terms of information in the package is essentially the agreed order.
And that's all we have.
And that's
And I
all.
cannot tell from there if that's his first occurrence, second occurrence, third occurrence.
Yeah, some of them are $5,000 and some of them are
Now, I will tell you
$250.
this, just from my experience, having read these, if they have had prior discipline, they're going to list it in that agreed report, in that agreed order. They're going to say, when they're giving the reasonings for the agreement, sometimes they'll say he had in the facts, he had a prior discipline on January 1st, 2007.
As a.
But
an
it's not a
appraiser-
guarantee.
but
Right,
that's-
because isn't that, excuse me.
As an appraiser, I think I can sort of kind of reason that out a little bit, and I read those like a novel. I like to read them. But as a new board member and or a member that's not an appraiser, they're not going to have, I'm trying to have that ability to take this matrix, take this information, line it up and go, boom, I agree. Boom, I agree. Or, oh no, that case said 14 hours of USPAP. Didn't know we had a 14-hour USPAP class. There's a 15 and a 7. Would you know that? You wouldn't know that. It's that clear, it's clearing it up. And I think for me, when I first started, and even now as an appraiser member, knowing just right up front, first occurrence, second occurrence, third occurrence, so I'm not having to look through that.
Yeah.
A synopsis of each case. Bam, bam, bam. Well, if there's 15, you want to have a little grid that says case 1, some kind of a synoptic
So can I jump
caption
in?
Go
of the.
ahead.
Just something to clarify what occurrence it is.
So let me jump in on that. Part of the concept of the agreed order is, in one of the problems I had in enforcement was this rumor that was going around that they were being forced to sign this particular form or we're not going to agree to an order. And staff came back and said, that's not true. This is used as a form for us to use, but we can cross out and write on anything else. Speaking as an attorney, when we do a settlement, and you'll see this a lot, where you say, BP says, we are not admitting any liability whatsoever, but we'll go ahead and pay you $3 billion in cleanup along the way, or $300 billion. So as part of that agreed order, it might be that the respondent was not willing to have that listed in that agreed order if he was willing to take an extra class. Like if staff felt like that was a give and a take, and I'm not even saying, I'm saying what you were saying.
Right.
I'm just talking about, you may feel like that you have the right to know that, and I think from a confidential basis, you could know that as a board member, and the confidentiality of what staff had in their hands, I think you can have that. But as a board up there having it projected of whatever it is, it's now you're becoming an opinion maker after the fact of everything that's been negotiated between them that we'll never get to find, or hopefully we don't have to get to the fine detail.
But we are, the only reason they're submitting that agreed order to us is for us to say, yes, that's okay with us.
It is in a sense, but it's really being submitted, it doesn't have to be submitted to us. He could be the only one, and I'm pointing at the commissioner.
If you
If
you
we
were to
delegated it to
delegate
him,
that authority.
We could, and then he would be the one doing it. I think what we were looking at before the enforcement committee and others got this formatting, some consistency going on, is that we were seeing real inconsistencies. And I'm not saying that there aren't inconsistencies what we're seeing, but for me, I have a lot more trust in that the staff is hearing the message that we're sending as board members, but there's still a level of confidentiality that respondent has, and you can as a board member go in and look at that stuff, but all of us can't get it in a piece of paper for us all to be handed out.
Would that be a better way to do that? Would that maybe look like me asking that specific question on an item that I have in question instead of giving it to me?
Yes.
You could, the other thing that you could do is, as general counsel, I could say, for all the agreed orders that you have here, staff, give me a synopsis that says, like you were saying, what level where does this fall on the level? Understanding that they're not trying it, they came to an agreement.
Right.
So it's not going to be as clean and easy as a PFD, where they said this, and this, and the judge goes, bam, it's on that level. Okay? The problem with putting that on the fly sheet is it's gonna put a chilling factor on people in the future doing agreed orders. But in executive session, we can talk about agreed orders. That's part of a ongoing litigation because it's not completed yet, hasn't been agreed to by the board. The general counsel could have a list and say, I just want to know what level where this fell out, and you could say what level. Do you think that would be all right to say?
Yeah,
Discipline, because it's understanding how they arrived at it and are they following the matrix. I think that's a legitimate question of counsel.
when it's
keeping in
obvious
mind
to
that you
me.
don't have to follow the
Right.
matrix. It's a
And in agreed order.
guideline only.
So what could have happened is, say this is level 3, and is the answer you have gotten. It's a level 3, and you feel like there's a level 1 punishment that he got. That's just crazy. I mean, it's his third offense, is what I'm trying to say. Well, it could have been that the first offense that he got, he didn't know what he was doing. He came in, he was scared to death and just signed it, and he really believes he didn't do it, which we've heard people did that, okay? The second offense may be that we fired 3 people because they were causing issues and making up that. That hadn't happened. I'm just saying that could have been a mitigating circumstance that if by finding out one fact along these agreed orders, then you have to know what the other side is, that there is something that made staff. The question I think that we usually ask is, do these fall in line with what we've been doing in the past? And if they say yes, then we assume that there's a trust. If you want to scrub each of those, then
See,
you're gonna.
I'm going to ask the chair to open up item 11 at the same time because we're really getting into the orders type discussion.
That's what I was going to say, because we do that in orders.
Yeah.
I mean,
Well, in
the
final
PFDs.
orders, it's really an agreed final order, so
Right, yeah.
but we can have 2 items.
All right,
open.
open the discussion regarding final orders at the same time.
Well, I've got final orders, lucky me, and I'm not sure how much I tailored it to dovetailing with this discussion we're having on basically offense level or
Staff reports. So I think we started with staff
and
reports.
it's not even staff reports that I think is being
Agreed
discussed
orders,
now.
yeah.
It's more like agreed orders.
That's why I
versus-
want to open this up and we'll go back to staff
Okay.
reports.
We'll have order here now, Lori. No sidebars.
Oh, we were just waiting for you to get ready. We didn't know that you were ready.
I am ready.
All right.
Okay. This is extremely informal, and let me just start out by saying that it's probably woefully deficient because I didn't have enough time to put in enough time to it. However, if anybody has any questions, please interrupt me, because otherwise I'll just keep talking and you won't have any answers. I don't know how basic this needs to be and how basic it doesn't need to be. I don't know who knows what. So, everything we do is governed by and large by the Administrative Procedure Act, which is part of the Texas Government Code. I don't know if you want to know that. The bigger question is, what are final orders? There are cases out there, books, statutes, treatises, so don't expect me to answer all the questions, because I can't. Does everybody understand what I'm getting real basic, what a contested case hearing is at SOA? Everybody understands that? Great. Everybody knows that after a contested case hearing at SOA, the ALJ generates a PFD, a proposal for decision. I know you're laughing, Jamie. I said this is going to be very basic.
That's good.
The proposal for decision, folks, is just that. It is a proposal. It is not in any way, shape, or form an order. So the board basically can do whatever it wants to do with it within certain limits. Basically, the PFD is going to summarize the testimony. It's going to summarize what happened. It's going to summarize the ALJ's analysis or discussion of all the testimony and everything. And then the ALJ is going to specify findings of fact and conclusions of law. And this is where it gets sticky for the board, because the board looks at the PFD and there's all of a sudden all these, this isn't really what happened, or I don't really like this fact. I think the fact ought to be, A, B, and C, not D, E, and F. I want to change it. And then I want to change the conclusion of law because it's all wrong, because the facts are wrong. Well, you know what? Too bad. You can change findings of fact to a point. All this is, again, not generated, it's ruled by the Administrative Procedure Act and your own rules. And your own rules mirror, for the most part, the Administrative Procedure Act when it comes to what you can do with findings and facts and conclusions of law. And it's every board I've ever worked with has these issues. And the issue most of the time is changing the findings of fact. I've had one board that wanted to change in one PFD no less than 7 findings of fact. I don't care how many ultimate findings of fact there were, 7 is too many. And let's talk about why it's difficult to change a finding of fact. In the first place, the findings of fact are found by the ALJ, who happens to be the trier of fact, just like a judge is in a courtroom. You can't second guess the trier of fact. If a judge in a courtroom finds certain things occurred, or the jury finds certain things occurred, they occurred. The only remedy is an appeal, if that's even going to be a remedy. But basically, in general, the trier of fact, the person who hears the case and rules, has the authority and the power to make the findings of fact. But the findings of fact are more than just this occurred, that occurred, and this occurred. It's a comment on the weight of the evidence and the credibility of the witnesses. If the ALJ says A, B, and C occurred and you want to change that, what you're also saying is, why are you shaking your head now?
Yeah, I'm just wondering why we would ever want to do that.
You'd be surprised. You'd be surprised. Some testimony is controverted. You've got person A saying this happened. You've got person B and C saying that happened. So what happened? The trier of fact determines it. But the board may not like that answer. The board may say, oh, no, I totally disagree. We heard this from person A, this from person B, this from person C. I think the ALJ got it all wrong. You can't do that. You can do that, kind of. I always tell my boards, you can change maybe 1 finding of fact, maybe even 2 findings of fact. Don't even think about 7. Because you're changing then the weight of all the evidence as well as the finding that such and such occurred. And it's the trier of fact that determines how much weight to give to each piece of evidence that that trier has heard. From that flow the findings of fact, and from those flow the conclusions of law. So it's actually easier. Am I confusing everybody? Or even anybody? Okay. That's why it's easier to change a conclusion of law. The conclusion of law depends on the finding of fact. But many times the ALJs will misinterpret a particular board's rules. A board is authorized to give an ALJ before a hearing a written set of their policies. And the ALJ has to give deference to those policies. Well, the ALJ may misinterpret them. The ALJ may understand a particular rule of a board, but misapply it to a particular fact that he's got, thereby coming up with what the board would consider basically a wrong conclusion, an erroneous conclusion of law. If the board believes that the ALJ has misinterpreted or misapplied its own policies and rules, it's a lot easier to change that than to say, no, ALJ, you got these facts all wrong, after an ALJ has sat for 2 days listening to a whole bunch of witnesses. Does that make any sense? Mm-hmm. So it's easier to change conclusions of law. Do I put the same limitation on how many conclusions of law can be changed versus how many findings of fact? I've never had a board that wanted to change 7 conclusions of law like I have with the 7 fact findings. But in general, it's easier to change conclusions of law. I have had boards change as many as 3, possibly 4 conclusions of law. Am I happy with that? No. But it's more doable than changing findings of fact in those numbers. The APA, the Administrative Procedure Act, actually gives you guidance, as do your own rules, and I've got handouts should anybody want them, telling you when you can change a conclusion of law or a finding of fact. And basically there are 3 ways to do it. And again, it's what I've already said. The ALJ did not properly apply or interpret the applicable law, agency rules, or written policies that were provided to the ALJ, or didn't properly apply or interpret prior administrative decisions. The second reason, a prior administrative decision on which the ALJ ruled or relied on is incorrect and should be changed, or there's a technical error in a finding of fact. Maybe the finding of fact said this happened in 1811 instead of 1911 or 2011. That would be a technical change, and that's perfectly fine. I mean, technical things like that are okay. These are contained not only in the Administrative Procedure Act, they're contained in your rules, 157.17, 5G specifically. So basically, if you want to change a finding of fact or a conclusion of law, you have to justify it. You have to justify, A, that it's still supported by substantial evidence in the administrative record, not in what you think happened with the case, but in the actual administrative record before the ALJ, admitted evidence, admitted testimony, admitted exhibits. That constitutes the record. That's where you have to find your substantial evidence to support any change. And for every single change the board makes, it has to give in writing a reason for that change and the legal basis for the change. The board would have to explain a rational connection between, for example, the stated policy and the change they want to make in a fact finding or a conclusion of law. And it can't be something real general like, well, this is supported by substantial evidence with nothing else. It can't just be a conclusion like that. You have to give something substantive in order to change it. The legal basis is basically the source from which the board's policy is derived, where they get the legal wherewithal to say, hey, this is what the conclusion of law ought to be. Now, there's one hybrid, and it's really not a hybrid, but a lot of the ALJs treat it like a conclusion of law, and that is the recommended sanction. Most ALJs call the recommended sanction a rule of, a conclusion of law. I don't think it's a conclusion of law. I don't think it's a finding of fact. I think it's a recommended sanction. But even if they don't call it a conclusion of law, and I've actually seen one PFD where they called it, they listed it in the finding of fact and the conclusions of law. The exact same thing. The recommended sanction is covering bases.
Yep.
Absolutely. The problem is you still have to justify it. Even though it's not a finding of fact or a conclusion of law, you still have to justify it, especially if the ALJ calls it a finding of fact or conclusion of law. But even if it's just the recommended sanction, because it's there, you have to justify it. The board has final say in what the sanction is. So you would think, well, I'm the board, I don't really have to say anything. But you do. You know, if you're going to increase a sanction that an ALJ has suggested, especially if you're going to revoke where the ALJ said, oh, no, I recommend no discipline, you need to have a reason why. Chances are this person is going to go to court. If you're recommending a revo and the ALJ is recommending nothing. Now, I don't think this board, I haven't seen a lot of court action from this board in terms of a suit for judicial review based on a sanction. Excuse me, but I've seen it, God knows, in other boards. And so you have to specifically justify the change even for the sanction. Whether it's, no, the ALJ misapplied our matrix, or no, these are mitigating circumstances, and so I think that the ALJ was too harsh with this person, or vice versa. These are aggravating circumstances, and I think that would justify the board giving this sanction instead of such a low one.
Yeah, and one other thing to keep in mind with that is consistency with former decisions.
Right.
That's a big one too, and that is a valid reason. And the standard of reasoning that you have to give for changing a sanction does not reach quite the same specific levels that you do for changing a conclusion law or finding of fact.
Right, and no, I don't think anything reaches the level of findings of fact, because then you're directly changing what the trier of fact has found. And that's just incredibly difficult to do legally. It's legally difficult to do. It's really easy for board members to come up with it.
One thing I'll add in terms of ALJs putting the recommendations and conclusions of law, over the years I've spoken with the head of licensing over at SOA regarding both agencies, TREC and TALCB, about our strong belief, in fact we even wrote a letter at one point, that sanctions should be under recommendation, not under conclusion law or not under finding of fact, because there are some judges that do it one way and some judges that do another. Internally, I know they are seeking consistency, and I think that they are trying to...
I think they're trying to address
it and have the recommended sanctions be under recommendation.
Right, you're absolutely right. I know that they have been, this has been discussed with the chief ALJ, but I don't think it's come to pass with all the ALJs yet. I still see PFDs that have a recommended sanction as either a finding of fact or a conclusion of law. And it just makes it more difficult. Not very much more difficult, but it's still problematic because it really is neither. It's just a recommendation.
I have a question.
I'm sorry?
I have a question.
Yeah.
If we decide to change the sanction, as we have, they'll come up and they'll say, well, they suspended him for a year. He can't do anything for a year, and we'll say, well, that seems, we'll go in and we'll tweak it somehow. Are we setting a precedence there to say, I mean, if we're going in after he's been before our investigators and he's taken these, and he wasn't successful there, he goes to a SOA judge and they come back with a recommendation after all is said and done, and then we come up with and yet another decision, it seems like we're setting ourselves up for a, well, you did it for this guy, why don't you do it for this guy scenario?
I guess that is always a concern of every single board. And the only way that the whole world would know what the board has done in this case and that case is because everybody talks.
Well, it might be the same attorney.
Well, I was going to say, it's a very small community of attorneys
Yeah.
that usually work with people of each profession.
Yeah.
And so, attorneys talk, licensees talk, but I don't think that it's a hard and fast precedent by any stretch. Again, the board has to justify the change, whether it's a change to a fact finding, although clearly that wouldn't be a precedent, The only precedent would be changing conclusions of law, possibly, depending on what the facts are, or the recommended sanction. But because the board is also charged with looking at each case on an individual basis, I don't know why the board would say, yeah, you know, you're right, this is a precedent, this is what we did in the last case, so we are bound to do it in your case. No, we're bound to look at it because we're bound to try to be consistent. But if we can't be consistent, we have to justify why we're making the change. And when we do that, you're explaining any inconsistency that may arise. And it will probably turn out not to be inconsistent because ultimately it's a different set of underlying facts.
Well, most of the time when we are looking at these PFDs, it's because the party's appealing to the board anyway.
It's because, well, I didn't hear you, Mark.
Because the party is appealing to the board to look and reconsider that PFD anyway.
Right. Unless you guys, right.
Because I think the last meeting there
Well,
was
no, you
one or
always
two
have to look at a
PFDs that
PFD.
weren't contested at all, and we voted them right on through.
Yeah.
Right. You always have to look at a PFD because the board has to either adopt or not adopt.
Yeah.
So you're bound to look at every single PFD that crosses your desk. The question is, do you feel a need to change it? And like with the agreed orders, you know, if there's really nothing there, there's nothing there. If you sense that, hey, you know, this seems awfully much like the set of facts we had in this other case, why is there such a different sanction? In the agreed orders, my response would be, unless it jumps out at you, don't look at it like that. Because the only thing that's going to jump out at you is if it seems like it's inconsistent. Otherwise, you're trusting the staff to have looked at all those other variables, mitigating factors, aggravating factors, and you're taking it that your staff knows what it's doing when it negotiates these things.
So when I had that one answer, this is a second occurrence. That's why it's different. I go, oh, okay.
Could also be different because the negotiation by the other attorney changed that.
Right.
And it's okay because it's an agreed order. The other party's agreeing to it. And if the sanction is inconsistent with what somebody else agreed to, well, one of the factors that might have been considered in negotiation is the cost of litigation for the state. You know, okay, I'm going to accept $5,000 less because it's going to, this case is really sticky, iffy, or you know, the evidence, 70% I think we're good, but there's that 30%, is it worth spending the, you know, all those hours and all that time? And I'm getting pretty much the same result here, and this attorney that's negotiating beating on me, and yeah, I think that's a factor. So there's all kinds of things that could go into it that have that are different than what level does this fall into. And remember, in almost all of our agreed orders, they're not admitting or denying. So the other side would say, heck no, there's no level here. I'm not admitting or denying. So you have all of that comes into play.
But your rules, and I have handouts of the applicable rules, just in case you guys haven't memorized them yet, as well as the statutes. One other thing the board can do, and this is kind of sticky, I've never had a board do it, and I'm going to count on you guys not to ask me any questions about this. I'm not sure.
I would not recommend that.
I thought
about
long
thinking
and
of it.
hard about even mentioning it, but I'm duty bound to educate here, so here we go.
That's a really bad plan on your part.
Something you don't want us to know.
Can I say? Here it comes. You know, here it comes. The board has the ability to remand a case back to an ALJ for new evidence. I have never seen any board do it. I had one board discuss doing it, and then I think they tabled that case until 3 months down the road, and I don't remember what occurred. I've never seen a board do it. I'm not sure that they would be successful because it has to be something that wasn't available for whatever reason originally. It's not an easy burden. It's there. Try not to use it because, again, I don't have any answers for you at this point in time. Of course, if it came up, I guess I'd be duty bound to.
Well, and I would say that I have seen it remanded quite a few times.
You have?
Yeah, in some of the bigger agencies, and when you've got, millions of dollars at stake, there's a lot of times it's remanded because they know it's going to be appealed to the,
Well, sure, if you've
Yeah.
got that kind of.
Is that following a motion for rehearing now?
always.
Yeah, so
Not-
not
Well, no, I
Remand.
said that. I said that. It's not always that. It is not always that.
It'd be
That is,
before
there
the-
are times that it is remanded for that, but there are times that they have not because they don't want to have it all in the motions for rehearing to do it. They don't want it flattened out.
So they make that suggestion to send it back to the ALJ before they've adopted or rejected the PFD?
Right.
Yeah, that's what I'm talking about.
Sorry, but she was right too. That's where my brain went at first.
At the hearing, at the board meeting where the PFD is up for grabs by the board, whether they want to adopt or reject it, change their finding of fact, a conclusion law, whatever, the board can hear argument, and this board typically does, basically a statement, very short, I might add, although that too is at the board's pleasure, as long as it's the same for everybody, by staff counsel as well as by opposing counsel or opposing party. The one thing the board has to keep in mind when it's listening to everybody give their spiel about why the board should go their way is you can't allow either party to inject anything into their statement or argument that isn't already in the record. Sometimes that's difficult because these PFDs are a nice summary, but they don't get into every nitty-gritty detail. But you have to be aware enough of what's in the PFD, in the evidence, by reading the PFD and reading the ALJ's analysis, so that when they start talking about something that is completely out in left field, you have to stop it. Wait a minute, that's not in the record. And if it's not in the record, it cannot be brought into the record at the board meeting. That is totally outside the rules.
And it has happened on more than one occasion.
Well, it happens because we all can't. It's very difficult, I think, to do that. You read X number of PFDs, then you listen to X number of people, and we're all supposed to be alert enough and with a good enough memory to realize when something's being argued that wasn't in the record. And I think we all try to do that. I know I do, but I'm sure that I fail, just like I'm pretty sure everybody else does.
And I think that it's allowable for staff as counsel or respondents counsel to object.
Absolutely.
Absolutely,
Excuse me,
yes.
And actually, they should be doing it more than anybody because they know
they
their
know the
cases.
record.
They know the
They
record.
know the record. I object that it's not part of the record.
That's right.
That happened at the last meeting when that
But I
individual
don't
that
think you
worked
should
at
bring
the,
that up because it's on the agenda for this
Oh.
meeting.
never mind.
Oh, the actual case?
Yeah.
It's still an open case.
Is it still an open
Because
case?
that's going to be a motion for rehearing.
Oh,
So it's
okay.
not final.
Because I thought I finalized it at the last meeting, that's what I was going to say.
That was it. We cut that one off, but no, it's back up again.
Okay, moving on, Mark. So that's something to watch out for.
We'll talk about that in executive session tomorrow. Hold your question.
Okay.
Okay. Two other very short things I have to say, and then I'll shut up. One has to do with conflicts of interest. There can come a time when a board member has to recuse him or herself from being a part of anything. You can still sit up there on the dais, but you can't really participate in discussion, and you sure shouldn't be voting. You really shouldn't be discussing either. If you're going to recuse, and when you recuse, if you recuse, you must do it in open session. You must do it on the record. So if we're all back here in closed session on a particular enforcement case, and then a board member realizes, oh my God, wait a minute, I can't be involved in this case. This is my brother, you remember belatedly. You can't recuse yourself here. You have to go back into open session and do it on the record.
Could I stop you for a second?
I'm sorry?
Could I stop you for just a second, right there?
Yeah, but only if you speak louder and slower, please. I wear hearing aids. One of them is broken.
Okay, it's mostly for him, and they may already do this, but if in executive session one of the commissioners says I have a conflict with something while we're asking questions, I make a note on my agenda to say Commissioner so-and-so is recusing himself from this case when we're outside, or remind him or her to say that outside.
Remind him or her to do it themselves on the
Just a
record.
procedural
Right.
little note to chairman self.
That's a good idea. That way it doesn't get lost in the
So,
shuffle.
yeah. So I just put it on my agenda.
Can I ask for some clarification? When the,
About what?
about what you were
Clarification.
talking about. When we have a particular case that's up and we're talking about it, and let's say it is my brother, is the point at which somebody's supposed to recuse themselves right when that item is brought up, or right before the vote?
No, I would bring it up as soon as you know you got a conflict. You need to be recusing yourself.
I just didn't know when it went, when you're supposed to do it.
I would do it as soon as possible.
In the past, when involved in something where I needed to recuse myself, what I was taught was not only don't participate, but I actually left the table, so there wasn't any perception and no tendency to, oops, I'm not intending to talk about this, but it's hard to get to
Okay,
say
you're
out of
talking
the
about in closed
conversation.
session. In open session, you can sit in the dais, yeah, because everybody can see that you're not participating.
As long as you just simply
You just say, I'm recusing myself, I want it in the record, I'm recusing myself, or words to that effect, and then just be quiet, don't say a word.
As long as you
Everybody-
cannot say
you
a
know,
word, that's good, right?
Right, I mean, the bigger issue is when we were talking earlier about executive session, the perception. Do you have to leave the room just because you've recused yourself? Probably not. Is it
Well, I don't
the
mean
better
leave the room, I mean-
idea?
Sure, I don't mean leave the room either, I just mean.
Just another clarification, we bundle some of those agreed orders together, and
God, you just can't get off agreed orders, Laura.
if we bundle some of those agreed orders together, and one of them is one that we need to recuse ourselves from, as soon as it's brought up, do we just say, I want to recuse myself from number 18?
Exactly. And it's always helpful, just like the chairman said to the chairman, is if you will tell the chair ahead of time that you're going to do that or pass him a note, then he has the
He'll
note,
remember,
you've got
right.
the note.
Yeah, two
Even
people
to
remember,
general
yeah.
counsel to,
Okay,
But you have to do it yourself on the record in open session.
right.
You don't have to explain it, but
You
you
gotta-
just have to recuse yourself on the record.
Yeah, you've got to, step one, pull it off of the consent agenda so that there's no question, because you think it can be handled separately from everything else.
Ex parte communications. And books and cases have been written about this too, and I'm sure, I'm boiling it down to the
can we
nutshell.
take a restroom break per chance?
That's fine with me. Everybody need to take a quick break.
I do.
How much, Alan, how much time do you have left?
I don't know, but for ex parte communications, I can tell you 3 minutes or less, if you can.
I can wait 3 minutes.
Okay.
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 Here's what I have to say about them. Don't have them. All it means is, that's it in a nutshell. An ex parte communication is a communication between you as a board member and a party, any party, without the other party present. It'd be like Patrick, the lawyer, having a conversation in the middle of a trial with the judge, and opposing counsel wasn't there. And if the opposing party was pro se, he wasn't there. So it's like he's got a private line to the judge's ear, and that offends everybody. It's the same thing with the board. If you've got a license holder that's really upset about something, sees you in a restaurant, sees you at a board meeting during a break, and corners you because they're really upset and you know there's an open case, don't talk. Don't listen. Tell them you can't talk about it, apologize if you feel like saying that, and then just kind of walk away or change the subject. Ex parte communications are bad, so don't have them. And there you go. The potential pitfalls for that are you leave yourself open to being called as a witness somewhere, you leave yourself open to being deposed, you leave yourself open to, I don't know, possibly some unauthorized ultra-virus act for which you could be held personally liable if you're not careful. So
And if it does happen, and this happened recently, got a call from a commission member on this, where somebody, he was at an association meeting, somebody came up to him and complained about an order that had been issued. Well, what he didn't tell him is that that order's being appealed, okay? So, he has this conversation, so that's already ex parte. Then, this commission member was curious and was told the name of the attorney in SES handling the case, called up that attorney and said, what's going on? This guy just told me this, okay? So now what does he do? Well, very first thing is he's recusing himself from that issue going forward. And then, told that in the future, just say, even if you're not sure, it's not bad to say, is this matter still pending before the board in any way? Final order appeal, anyway. If the answer is yes, I cannot talk to you at this time. I am the judge. Or I act as the judge. That will make it clear, because they don't always understand that. It's not like they're doing this intentionally.
Right.
A lot of times they don't understand your role.
But Carrie's right. If you say, I am acting as the judge, they will understand that. And it's true, because you all have a vote. So you're all acting as judges. And they will understand that, because they wouldn't like it if they were in a real courtroom and the other side went and talked to the judge without them present. They would hate that. They'd be pissed off, and when they found out about it, they'd probably do something about it. So that's good language to use. They'll understand that.
Well, it's getting easier and easier for the other party to do that, because, our email addresses and our phone numbers are listed on the website. I've received both emails and calls from people saying, I need your help on my case or whatever.
Feel free to immediately forward that to me. Don't even read it. Just forward. That's what Shannon does. Just forward it immediately to me. You're done. You're good.
Yeah.
If you want cover, put I never read this.
I don't know how I did not do that.
Okay, does anybody have any questions before we go on break?
On the subject or the first, the first words, it's just
Dear
like,
board member.
exactly, Carrie, and then she'll take care of it or tell me, oh, this was fine, this was from your mom.
It was just an invitation to a party.
Any more questions of Ellen?
Any questions? Does anybody feel a need for any of these, their statutes or rules? They're not all of them, obviously. I just printed out a few that I cited in my little spiel.
Sure.
I knew you would say yes.
The two attorneys on it.
Yeah.
And of course, we're the ones who probably know how to find them. And the other ones who really want them really bad.
I know how to find them. You know what I'll do instead? Here's my bullet points.
Call Carrie.
And they cite anything I cited. So this is just my bullet points in there.
Is there more than one version right here that you?
Yeah, it's just one page. It's a one-page thing.
Are you
So
really
just
not giving us the law?
I have one. Oh, yes.
You don't want to waste all those state dollars. You don't want to waste those state dollars on your copy.
I am very short and sweet, Shannon.
Okay, if there's no further questions of Ellen, we will take a 5-minute break. It's 2:30 p.m.
Secretary without.
It is now 2:42 p.m. and the TALCB orientation and training session is back in session. And let's see, we were still on agenda item 7. And we finished that?
We finished 11, and we were on
11. 8. But we were doing staff.
7, and
We merged 7 and 11.
unless anybody had any specific questions right now on staff reports, I just want to say, feel free, especially new members, if there's something on the report, even if you think it's obvious, feel free to ask a question during the meeting of staff. That's what they're there for. They'll highlight things, they'll explain things.
Not to belabor it, but that would be my best thing. If I couldn't tell, then I'm just going to say, is this the first occurrence, second occurrence, third occurrence? I don't have that information.
Can I belabor one staff report that I always struggle with? And I've been looking at it for years now, and that's the enforcement committee's different little grids that they have. And I'm trying to get these numbers to coincide with each other, and it just...
This one up here?
Did you say enforcement committee?
He meant enforcement.
Okay.
Yeah,
Division.
Division. Excuse me.
Yeah.
Yeah. Shannon, can you please explain this one?
Yeah, okay.
The technical writer said.
Let me get my laser.
Walker, is that the one you're talking about?
Do all that.
Yeah, Mark.
Yes, that's,
Walker, listen to me.
well, it's all right. I'm a committee in my mind.
He's interchangeable.
Yes. Yeah, and then there's the other ones that they have. Well, yeah,
That one?
yeah.
You can't make those numbers add up?
I'm teasing.
I'll let the commissioner go through these. Ask a question of what you don't understand, and if it's everything, then
I was going to say, ask the question of what
Yeah.
you don't understand if you know.
Yeah, well, first of all, like, I don't keep whatever RFA means. I don't know.
Okay, that's a request for assistance that
Yeah.
came from the Mortgage Fraud Task Force. Okay, that's what that means.
and we have a statutory obligation for most of those to keep them confidential. And that's
Correct.
why they're a separate category. And ASC does not count those against us if they're over a year, because we can't act on those until we get word from the agency that gave it to us that we don't have to keep it a secret anymore.
And you can see, I mean, like here in this year, there was 2632 of them. I'm sorry, let's not do that right. This down here, we only have one in for
Last year.
FY 2013. That's kind of been falling off. They've gotten, some people are in jail already, so that's a good thing. What else do you want to know about this?
That one is pretty straightforward. But let's keep going on to the next one. Let's see.
The next report,
Yes.
oops,
Next report in our.
that one. Is that one?
Right. Right.
Cases at least 1 year old. Now, remember, so when you looked at the last one, that's all cases, all years that are not yet resolved. Okay? This is specifically, we have a report specifically for cases that are more than 1 year old, because that's our metric from ASC. That's the goal we're shooting for. So we track those separately. So with those, so for example, you'll see, what did I say before? We have 4, right? And you look at this report, which you'll see an update on this tomorrow, but it won't, the last meeting it was 63.
It's 47 now.
63. So it still says 47. So how did I get to 4?
Yeah.
How did I get to 4? That's what's confusing. Well, let me start with, this number is on your agenda today. Okay? That are agreed orders that are just waiting for you to, we already have them. They're received.
Now remember, this is last meeting's.
Correct. Correct. Pretend it was last meeting. Pretend we're today's last meeting. We've had a hearing, but we're waiting for, none. There's no outstanding PFDs. We don't have any unresolved hearings where we're waiting for the judge to give us a PFD. Set for hearing, we have 2 scheduled at SOA. Okay? Hearing required being processed for SOA. That means we're going to SOA, but it isn't set yet. There's no date set yet for those. But we have not yet, the negotiations have broken up. We're going to SOA. Okay? These ones are still in negotiation. This number is RFAs, so those are the covert reviews that we may not be doing anything on. Not a darn thing. We did an initial review of a report, we gave it back to law enforcement, and then they just said, okay. And so we follow up with them about once every 4 months, say, any movement? Any movement? And then out of the blue, they can call us and say, we got a plea agreement on this particular deal. We're done. Call it resolved. Or we're going to trial and we're going to need some more work from you, or whatever. When the indictment, if an indictment comes down, then generally we're released from that confidentiality. Now it's public record. Regulatory reviews in investigation. This is normal complaints that we get in. So they're regulatory as opposed to RFAs. And in investigation, that means these are currently with the investigator. So they've made it through the initial triage. We didn't dismiss them. We're doing a full investigation. Okay? And then sent to the peer review committee. At this point, we didn't have any. So of the total of 63 last meeting, 1 year, at least 1 year old, we had 0 out to peers. Only 3, so total of 60 of these, not these 21, had already been investigated. So it was only 3 that remained with the investigators. 19, we were in active, 21, we can't do anything until the law enforcement releases us. 19, we're in active negotiations. 11, negotiations have broken off and we're headed towards SOA. Doesn't mean they won't come back, because that happens way too many times. We start preparing for SOA, and then they realize how much it's going to cost to go to SOA, or their attorney gives them the bad news and says, you know, I need a brand new retainer for $20,000, and it's like, excuse me. Set for hearing, those are already scheduled, and then these ones, these 7 right here, we already have agreed orders back in hand, and they'll be on the agenda today. So that's how that breaks out.
So if we were talking,
But that's for cases at least a year old.
This is only for the ones a year old.
and that's, so out of that, we only have 3. That would be the equivalent of the 4 we're going to say tomorrow. We only have 4. So here we only have 3 that are not, that we would be out of compliance with.
No, the only where those 3 end up tomorrow is right here. We are going to SOA or are set already. So 1 is already set at SOA and 2 are headed for SOA. Everything else on here, so it'll be 0 in negotiations, 0 in investigation, 0 in peers. There may still be 20 or 21 in that are RFAs. And then there'll be like 12 or 13 that are on the agenda
You are
tomorrow.
so good and accurate.
Oh, did I get that right? We had a dress rehearsal yesterday.
So where does the ASC, when they say at least a year old, I mean, they want them all resolved in a year, not just in negotiations or anything?
That's
I mean,
correct.
That's their threshold, right?
There's 2 areas that they call specially documented circumstances. Okay? This has always clearly been that. If a law enforcement, we have a law enforcement hold, if you will, on that case, we can't do anything. There's nothing we can do. So they give us a pass. Doesn't matter if it's 3 years old or 4 years old or 5 years old, they don't count it against us. We still track it in the category, but they don't count it against us. It qualifies for specially documented circumstances. The one other area that we have argued for the last 2 visits, and they finally acquiesced on, is once we have it scheduled at SOA, it's completely out of our hands how many continuances and the whole SOA process and the appeals and motion for rehearing and all those things. It could still take another 18 months to get this thing resolved. But once we have it scheduled, they say it's resolved for their purposes. Everything after that is specially documented circumstances, if it's taking longer. But we got to have it scheduled. So we have only 3 in that category. 2. One's already scheduled. That's right. Okay, so does that help explain this particular report? And the other one, if we just back up to that bigger one, there we go, this one. This is total open cases. Okay, so today we have a total of 161, or at last meeting, we had 161 open cases, unresolved. One of them had been filed in 2007. Okay? And then we started breaking these down. So in 2008, we have 1, because 4 of them are on law enforcement hold. We had 3 from 2009, 9 from out of these 15, So if you add all these RFAs up, you'll get to that 21 number. But the other ones are still working, and it just lets you know how old they are. So in 2012, this doesn't break it out. For 1 year old, when we started working on this, I said, well, March 1st, 2013, everything back of that is 1 year old. Why? Because ASC is coming in February of 2014. So it will be 1 year old by the time they get here. So it needs to be resolved. Track it on the 1 year old case. Okay? But, so we'll still have, once all those are resolved, we'll still have this, all of the rest of the 2013 cases, but everything in 2012 is already considered over 1 year old.
So the 195, or the 161 on that form minus the 63 on this form equals the amount of cases that...
Less than 1 year old.
Less than 1 year old.
Absolutely right. Absolutely right. Now, one of the curious things that you may see on this is that the reports will not be run on the exact same date. Okay? So, depending on like this was, our meeting was August the 6th, I think it was early in August this year?
16.
Was it 16th? You're right, it was August the 16th. So we had run this case report to send to the ASC. Okay, they want monthly updates from us, and so we had sent them this report, and so we used that same report rather than 3 weeks later running a whole another one for you and having it up to 1 week before. Most of the reports that you get are month end. Okay, not necessarily for enforcement, but for all others, it's month-end statistics, because we routinely run those reports. And then anything that's financial, there'll be another 2 or 3 weeks. So if we meet early in a month, like in October, for example, if we met the first week of October, you might not be getting even August data yet, the end of month for August. You should, but sometimes it takes, 6 weeks to get all the banking stuff resolved. Anyway, so we try to give you the most current full month that we have, as soon as we have it. And that is back up from your meeting date, another 10 days, which is the day we publish the book. So whatever we have at that date is the one that we plan to include in the materials. Okay? Any other questions on reports? You want to flip through them?
When you go to report case resolutions for FY 2014, which of course would be your March thing, we had 100% dismissal from September.
It won't show yet because this is 2014. That's tomorrow.
But so there's 19 cases that came in and we dismissed all of them.
No, all the ones.
From September the 1st to November the 4th.
All of the ones that have been resolved. Does that say resolved?
Yeah. 19 total complaints resolved.
Okay. Every
Between
single one was
September the
dismissed.
4th, September the 1st and November
Yeah,
the 4th.
that's
Every
for
one of
tomorrow.
them was dismissed.
Okay,
Yes.
now let me point this out. You have 13 agreed orders before you. Remember, nothing's going to happen on any discipline until a quarterly meeting.
Until you ask.
So you're always going to have the only ones that are going to show between meetings for the first quarter, because now the second quarter you're going to have stuff that has come in from the November meeting. It wouldn't show. Now, do you understand?
Yes.
Okay. So
But you're absolutely right to answer that particular question.
the
You
first
bet.
quarter's always going to show no discipline because the board hasn't approved any yet.
Right.
Okay, and then here's the other case status report.
I think, going back to the chart that she's talking about, I think that some of the questions that, at least some of the questions I have for this one, I think are better brought up in the meeting for all the board members to hear.
Right, and that's
Tomorrow.
why I didn't use
This
this
month.
meeting's numbers. I used the last meeting's.
For this
for this
Yes.
purpose.
That was just for me to understand how the chart was working, because I have notes for tomorrow's meeting.
Okay, good.
Okay,
Particulars.
perfect.
Good.
Perfect time is to ask
And that's
those
the,
questions
and
at
it
the
is
meeting.
that's the thing that we wanted to encourage by bringing this up is two things. One is, please encourage you to ask any questions about anything that you don't understand. Because if it's misleading or obtuse, then perhaps we can find a way to fix it. Okay? Not only answer your question, but find a way to fix it. If there's a report, and this has happened before, where it's like, well, what I would really like to see is a report that shows X, Y, or Z. That it's nice to make that comment at that point and then write it down and remember to bring it up under new agenda items so we can get that to the appropriate party. And very often, this kind of bleeds over into the next one, if it's something that we track anyway, that we track at least the data, we don't have to go back and write a special report to present it, but we don't have to, we already collect it. Okay? That's really easy. Those are really easy requests to comply with.
Okay, and now at this chart, I mean, I know what an agreed order is, but what's without auto revocation clause and surrenders?
Okay, so this is agreed orders without auto revocation clause or surrenders. Okay, so in there it says, here's the things you're going to do. They agreed to do it, pay some money, take some education. Those are generally the two things, right? And they have a certain amount of time to do that. Okay? There was a point at which, and pretty soon that won't be in there at all. We only have 3 left, where in a previous process that we used, we would include, if you fail to meet these criteria, you lose your license. Okay? Not you're automatically suspended, where you hold the key to the jail. You're suspended and then you comply and now you're unsuspended, if you will. But it would say you lose your license. And that's what they agreed to, but we don't do that anymore. Okay? Except in the most egregious kinds of cases that would have been a huge revocation anyway. But so far, I don't think we've done any in 2 years. Pretty close to 2 years. The work, essentially, since the work of the enforcement committee has really, sharpened a lot of those fuzzy areas. But in any case, that's what that says. So instead of having automatic surrender and revocation, they are now either suspended. That's kind of the worst thing that we put in an agreed order, is you're suspended, but you have the keys to the jail. Okay? You miss the date on taking your class, you don't pay your fine, you're suspended, but as soon as you make good on that obligation, you're unsuspended. Okay? That's what that's for. And then these are kind of default revocations. We sent out a NOA, notice of alleged violation, NOAV. That's what that means. Sorry. We sent out the notice of alleged violation, and they simply ignored us. So they revoked by default.
And so in that case, and then the other pie is just taking that same pie and putting it into repeat offenders and.
Right.
Correct.
And then.
The same 70.
Yeah.
Same 70, this is the disposition type, and then, set 19 out of the 70 were repeat offenders. Okay, had previous discipline is what that means. Had previous discipline.
Now, Laurie, is that kind of you're looking for that 19 number there? If they're repeat offenders, you kind of were looking to look at that a little more in more detail. Maybe that's the 19 you're wanting to get the information on.
Yes. However, that 19 is not going to show up in our quarterly agreed orders. They're going to be spread out all over the place.
I know, but I'm wondering if that's the way I wonder if that's how you'd like. I mean, I don't know if that is something you could tweak that just for that one meeting or not.
Well, I think the request was, because of the confidentiality concern that Ms. McClendon appropriately raised, is that general counsel is going to have some of that statistical data on, for these agreed orders, this is first offense, these 18 are first offense and these 2 are second offense.
And honestly,
Kind of a
I don't
thing.
need that published, but if I
Right.
have the question, I'd like the answer to be readily available.
Exactly.
Right.
My point being that we'll hold it, it'll be attorney-client, if you will, kind of privilege thing. And then if you ask the question, we'll have the
That
answer.
would be awesome.
And I can't promise I'll have it for tomorrow's meeting.
Right.
But the next one
But the
will.
next, well, not me, but.
Oh!
It's your turn.
I'm out of here.
Easily.
That,
Isn't it?
that new general
Matching your
counsel.
tone.
Yeah. Man.
But somebody will.
right.
And we might be able to get it for tomorrow, just depends if I can get it.
There's only 12, so we may
You're not
need
gonna
it.
make them handle their first meeting by themselves, are you?
No, hopefully we'll have somebody in
But you can
place.
apply yourself with us.
Would it be out of line as I'm reviewing my material for the 7 days that I have it? If I have that question, can I call staff and just ask them?
Call general
Call me.
counsel.
Because calling
I've
staff
pointed
would
at
be
staff.
Yeah, sorry.
ex parte.
Yeah,
Call general counsel.
okay, that'd be great. General counsel.
Yeah.
Because you switch your, and it's been a reminder, and it's a very important reminder, that you have, you know, the staff represents the board in its investigation and all that kind of stuff. But when you meet, you become the judge. You got to take off that hat, and then you have all that ex parte stuff that you have to be concerned with. Okay?
Thank you.
All right. Are there any more reports? Let me just flip
Well, only
through.
if they have questions, Anna.
All right.
Are we?
So, I would just mention that I'm glad I'm not colorblind because these are real helpful for me, and I know that runs generally more in men as in baldness as well. But while we're
I don't have a color printer in my office, so when I download it for the board meetings, it's in shades of gray.
you probably could ask them to send you one too.
Oh, it's getting late.
Careful.
So if
Careful.
when we run across charts, particularly like the one that I had requested, which I'm glad to see.
That one?
No, that one's easy for me to determine, but where there's like light, just barely different shades of blues and that kind of thing, I haven't seen it. Do I have that? Where did that one come
We're
from?
looking at the new.
Oh, yeah.
Yeah, that's right, you got it.
This was for the full year 2013. It should also be in there.
So
I think.
do things like, right.
This was a 10-year snapshot.
So-
What you have there is probably a 1-year snapshot.
So
Actually,
that's
it's
like
quarter.
3 different shades of purple?
Yeah.
Okay.
But the important thing is that they're numbers. And so it's so
Yes,
you
I
can,
was able to do that. I was
yeah,
quick.
you can just correspond the numbers, and the colors are. Some people
I was
like
quick that way.
colors, but we could just put it on a chart with numbers. It, you know that the
No,
pie
it
chart
worked.
thing
I
people
was just
like.
glad that I wasn't.
Question,
Colorblind
on the,
or
we usually get a report on number of phone calls and answers.
Yes.
And how did we come to, why is that interesting to us? Is that just showing staff requirements and?
Well, if you are not interested in having it, or more importantly, and this is, and I think, was staff reports included in your general motion last time? I don't recall.
No, I think the last time it was if anybody has any questions,
Yeah.
we'll call that person.
Kind of the expedite. Everybody has all the reports, and so we don't have to get up and talk about them, okay? Every time and highlight the important things. If you have a question,
That person's available.
address it to the chair. I have a question about the communications report, and then Lori will come up and be happy to answer your question.
I thought we had decided to do it that way.
Didn't we do it that way last week?
We
did
did
it
it
last time.
at the last meeting,
That
and
worked well.
it's one of those efficiency things that
Yeah.
we're welcome to continue.
Mr. Commissioner,
I do need to give you a news update, I think, unless you don't want.
well, you already gave it to us in the email.
Part of it, though, I think, is getting it on the public record.
Oh, you're talking about the
too,
staff email?
Because,
Where I copy you on the staff monthly email?
because the public people in the audience might want to know, the people watching at home, isn't that funny? People watching at home on our live stream might want to know that information.
Some of it is, depending on what time of the month, you're absolutely right. If I just did a staff email that I copy all the board members and the commission members and the committee members on, you may be hearing some of the same things. But it's 3 months worth. Everything since the last meeting, but I just try to
So
highlight
that
it.
may be why, if we were just through the quarter, that I heard the most recent. I just convinced myself of something I don't think was true, but that's okay.
Okay, so if you don't, you don't need.
It's good for you
If
guys.
you don't want to hear it at any particular point, you certainly can make that same, either adopt it as a practice, that, the staff reports, you have them. So the chair could say something like, everybody has a copy of the staff reports and has an opportunity to review them. Does anyone have any questions? And if not,
And if we want to
agenda
do-
item 4.
If we want to do just enforcement, we can say, yeah, we want to hear enforcement, but unless anybody wants to hear the others, we'll skip all those staff reports. You can pick and choose.
Completely up to, that's the will of the board.
Uh,
It's the will of the board at
But
each
yes,
meeting.
Mr. Chair,
Yes.
that would work lovely, I think. I mean, you're still going to get people that have probably questions.
Somewhat
but-
specific reports. Great.
There's a few things that we love to point out because they're counterintuitive, like there are no trainees. Well, actually, in the last year, we went up 100 trainees. There are people coming into the profession. You hear all the time, where are the new people coming from? I don't know, but we got 100 of them in Texas in the last year. Pointing things out like that.
But that's your report, right?
I could do that, but it's actually on the count. And so Gwen would give that report. And the tests, if the tests, if we have spiked in the number of people taking tests or the pass rate or anything like that, she highlights those things in her report. But if you would prefer,
Well, we may not
could hit the
realize that's
highlights.
because we may not realize that's a nuance. I mean,
Right.
on trainees, obviously I do, but somebody else might not because I've been focused on the trainee issue.
If we do that, if the board adopts that as a regular practice, if that's something you want to do as an efficiency measure, then when we go through the reports, when we do our, quote, dress rehearsal before the meeting, I will write all those things down and include them in your report. They're highlights, if I think it's something that you might be interested in hearing.
Yeah, I think if there's specific changes in the industry that we may not pick up on, that call our attention to, I think that's a great idea.
Well, those generally I will call out, but the statistical things sometimes reveal either counterintuitive trends or, we're worse off than you thought. We're going the wrong direction on something.
Well, again, what would be the difference, because this becomes public knowledge, right, all these materials?
is.
What would be the difference with them just narrating their report and putting that as part of the materials? And then they wouldn't need to take that forward in public time, and, coming to the microphone and submitting it, unless we had and.
Oh, that's a good idea.
You mean a written summary?
Yeah, maybe just
Include a written summary, highlights.
highlights.
The same thing they would audibly be speaking into the
Yeah.
record, just put it into this record by paper. And then if as we read this, if we had a question about that report, we could just ask.
Come up and-
Yeah.
That's perfectly acceptable as well.
That's it.
Really?
We could have like.
Because it would still be in public record.
Yes.
Okay.
Oh, absolutely. Absolutely. So I'll let you disappoint them tomorrow. Okay?
Well, I am thinking we're
No,
going to get
no.
away with our.
I don't mean you need to talk about exactly how you want to talk.
Well, and I don't know if we want to name it after, that grade school magazine highlights that we find the birds in the tree kind of thing, but, focus points.
We were gonna miss you.
I've
Can you
got-
add- Can you add creative on the list of things that they have to be able to do?
Oh, that the new
But
general
I do
counsel has
think
to
we need
be.
an audience, don't we? No, I'm just kidding. I'd rather them be at their desk doing what they want to be doing than having to sit there wondering if we're gonna call them up to the podium.
It'll also save them money in wardrobe costs.
You're always the thinker.
All right. Anything else on reports?
Staff reports. Agenda item, so we've covered agenda item 7 and we combined that with 11. So we're on to agenda item 8, discussion regarding board requests to staff. I think Carrie has a handout that we prepared, that the executive committee prepared, and I guess we distributed.
And do you want me to give a brief history on this and kind of let everybody know where we are and what we?
Yep.
Martha, you get one?
Just especially for the new members, the history on this is this has been an item that's been on board agendas, executive committee agendas, and last was on a board agenda about guidelines for board requests for staff. At the last meeting, this was developed at the executive committee meeting right before the board meeting. It was agenda item on the board. There was some discussion on it, some meeting and executive session on some of the legal issues regarding some of the items, and then came out of executive session, and it was tabled to get more information from staff. I believe that was the motion that Jamie made. So it is on this agenda. It's not on this agenda as an action item. I think at this point it's more on this agenda. Well, it's on this agenda for two reasons. One, at that same executive committee meeting, they wanted this topic of board communications with staff to be an item. I think at the time, they were anticipating that this would have been something that was passed in some way or in some form. It wasn't. So I don't know where we are in this, with this item, except to say that everybody needs to be aware that this is a tabled item of discussion. If the board wants to hear any information staff has gathered on this, and I can't quite remember, Doug, specifically, it might have been what are our processes currently, or if the board wants to give any input, even in terms of, this is not on the next agenda, on the agenda tomorrow, but in terms of for a future item, a future agenda item, is this something somebody might want to discuss, that it needs to go on a future board agenda item, it needs to go back as a future item at the executive committee level, it doesn't need to go anywhere, that's
Mr. Chair, can I address something at the executive committee level?
Yep.
It was my recollection, I don't know, do we audio tape our
We do.
executive? I would like to know if I'm thinking right. I am almost positive, not only did we table this at the board meeting, but then we also decided at executive level that it was a moot point. No?
Yeah.
Well, have we had a meeting since then? So I'm wondering.
No,
No.
there were two, and I can help you on this
me.
because I listened to it just the other day to get information on.
Help me recall how that process worked.
Okay,
Or
2
played out.
meetings ago, we had an executive committee meeting that had a different proposal than this, much more detailed, and that was brought up in a report. You gave the report.
Right.
Said that the executive committee has, and it might have been an agenda item too, but during your report, the executive committee is looking for input. This is what we're thinking. It's just a proposal. putting it out there.
Discussion.
Discussion, it was a discussion item. And at that point, it was decided that because it came directly from the executive committee, straight, because you met right before, straight to the board, that members didn't feel that they had time to really analyze it and look at it, right? So some conversation happened where there was some input, but the conversation ended with, goes back to the executive committee, right, to consider, right? Moved to August. August, we started the meeting with some of those suggestions incorporated into what had been the sheet before. And during that executive committee meeting, the executive committee decided, you know what, we don't like the wording or the constraints or the length of this. We really just want to get out the concepts. And as you recall, I had my laptop there and I said, go. And so y'all were just telling me, what are the concepts? Let's get them down. We typed that out and we had this ready at the beginning of the board meeting. When we got to the discussion item on this, there were still some concerns. And I can't remember, Ellen decided the way the conversation was going, we needed to go into executive session. I think it dealt with job duties of the
No,
commission.
it actually, we went in, I knew we shouldn't go into this. I really still think it's inappropriate to go into this.
All right, well then,
We're being recorded right now.
Okay.
And we can talk about personnel issues all we want, and that's how this got on the table, and why it shouldn't be on the table. And I really wish our other new board member were here, because I know he has questions for what the issue is with this. But we went into executive session illegally. Now it's out in the open on that, and we can get it out in the open about the chair writing a certain letter that he wrote, or signed a letter that he didn't write.
Well-
I don't think we want to go into that.
well then let's just, finishing the history, it was her question
Well,
how
no,
we got
but you
here.
didn't start the history. You didn't start with why this came to be in the first place. There has not been an issue yet about staff being overwhelmed with board requests. It initially started out that you didn't want us to make, not you personally, but it was not that boards shouldn't be making requests of staff. That's how this started out.
What my recollection is, and I understand.
I have it
what your
all in
recollection-
writing.
I understand, but there was a meeting in November of last year, when we were at the Capitol, where the discussion was happening, we need a process for board requests. And that was because people had been asking for things one time, two times. So.
Okay, and in that November meeting, I was the one who raised that request, and this was at our last board meeting as well, that we wanted the commissioner to take on the responsibility of finding and tracking where our requests were. Because, for instance, Lori had asked for 3 meetings in a row to have the matrix, and it wasn't there. She wanted to know why. That's just one of many examples.
Right.
So it started out with what would have been a simple policy is the commissioner shall develop and maintain a mechanism to track board members' requests to ensure that such requests are noted and timely fulfilled. That's all it was about. It wasn't about the commissioner trying to delegate a bunch of work back to the board. That's how that started. Then what happened is we had a discipline problem, a personnel issue that came up, and all shit hit the fan. And I don't think we want to go into that. And this is, I thought we had grown up and decided we might not want to go down that path.
And that's what we can decide. This is tabled right now. If it doesn't get put back on the agenda, and that's where I was going, but I answered Lori's question, this was tabled. If it doesn't get back on the agenda, it's dead unless somebody makes a motion to bring it back up.
That would be my recommendation, Mr. Chair. Let's move on. Unless there's somebody that has strong feelings about this, I think I don't think we have an outstanding issue about board requests for staff, unless staff feels like we do.
And for my clarification, where I guess my discussion, I thought we had decided at the executive level, that committee level, that was a moot point due to the fact that we decided anybody on the board could make a request of staff if they wanted to, period. I thought that's what when you were
Which is what the
typing and
first thing
everything,
said.
and I thought that was just a period, done.
I think
So
the
I don't know
first,
that we've had any formal action, I guess, is the issue. I think the question got circled all the way back around through our board and the staff that maybe the right way to handle it is if a staff member receives a request from the board that's either going to be voluminous in terms of time or an issue that it needed to be a training thing, that they would know to go to the commissioner and the commissioner would then address the issue.
Yeah, just listening to what y'all are saying, I think we have the same issue, and it's just in two areas, because this was tabled because it was an agenda item, and it's still tabled, it's just hanging out there. Subsequent to that time, the issue circled back around to the executive committee, and y'all made a decision about it. That's basically what
No,
what's
they
happened
haven't
here.
had a subsequent
haven't
meeting,
had a
that's what
meeting
she was
since
saying.
That's my point.
And that's where I'm confused.
Oh,
Yeah.
okay, I thought,
Yeah.
I thought that's what you said.
At this point, no action needs to be taken. If somebody on the board wants to pursue this, they're going to have to, in a future meeting, either ask the chair for an agenda item or ask that it be brought forward. If nobody does that, it's a moot point.
Yeah, I think
And
the
so
idea.
we understand the history of it. Trying to put this together as one agenda item is not what happened. It was an issue of, we don't even get into the names of it or whatever else, but it was wanting the November meeting at the Capitol was wanting the commissioner to track where our requests were. That's what it was. Why is this not getting done? Then it became, oh my gosh, what are you doing asking staff to do something out of an explosion in the enforcement committee? And then it became, well, who gets to ask what of who? So it's morphed into a staff issue where we are appointees by the governor. We are, as individuals, have different interests that go, and we were brought on and requested to be brought on for different interests that we have. And it doesn't have to go through the chair on our request.
And that's what we said here, too. Board members may make requests for any
Then it gives you some extra
information.
little power in here that says if you feel like it's not appropriate, all that other stuff.
We were trying to structure a procedure that just was protocol. We thought that was answering the question that had been raised, and that was how the executive committee came up with these seemingly pretty broad in general. I don't think it had anything to do with personnel or human resource stuff that you're talking about.
These words verbatim come out of the letter that you signed.
Mr. Chairman,
Verbatim.
I would recommend that this is a moot point. Unless someone feels differently, we've already addressed it, it's already been verbalized about 4 times. Why don't we move on?
I think that's fine. I was going to say, you could bring it up for a vote in a meeting, vote it down.
No.
But
No,
if we
I
don't
said
have
that
to do
it
that,
doesn't even
then we
need to
don't
do
even
that.
have to do
I think
that.
this
That's
needs to
fine.
be
It's on the table,
It's
so
tabled.
it doesn't
Yeah,
need to be
yeah, that's-
brought off the table.
That is fine.
So,
All right, next agenda item is discussion number 9, discussion regarding strategic planning process and input.
Okay, so I'm going to pass around, this is a little history of the strategic planning since it was instituted by by government back in the 90s, about the same time we were born. I'm sorry, no, all of us were born, but when this agency,
I'm looking around the table.
when the agency was born. There's 4 pages, sorry, 4 pages. 1, 2, 3, 4 pages.
I have the back too.
okay, it's 4 pages.
Here, you can have the back.
It heads with Appendix A,
Page 36, what page?
and it's page 35 through 38.
But he doesn't have any.
35 through 38.
Give me yours and now.
Sorry,
Now we've all got the.
I said that ahead of time.
Clayton's favorite, right?
So, and this is just to tell you that there's not one way to do strategic planning. Okay? If you read through the history of the way the board has done it, there have been years when the board met in workshop and did it essentially with staff. There have been years, and this is kind of although it didn't go linearly this way, it wasn't like more and more open. It was like more open and then less open, and then more open and then even less open. I will tell you how we've done it since I have been acting as the commissioner. And that is, we schedule it kind of starts in January. We do an internal staff poll, and we've been kind of following it along of what are the issues? What industry issues, board, issues where the board has had concerns, limitations in the statute. I know there is an issue, for example, that came up that kind of blew up not blew up, but it came to a head at where there was a request from a trade association for someone to come from the board and speak, but they wanted ACE credit for it. Okay, and unfortunately, there's a Ethics Commission opinion that basically says unless it's in your statute, you can't do that, unless you have specific authority to do that in your statute. In general, it's a conflict of interest to be giving credit for things that you're doing where you get to evaluate whether or not it's worthy of credit. Okay? So you're both the presenter and the grader, essentially. Well, that issue, we have had, there are a lot of issues surrounding at least that piece of education and a lot of other education issues that we would like to ask the question. I think staff is certainly willing to kind of put it on the table and ask the board and the public and the trade associations their opinion about that. Is that something that we should attempt to remedy? There are several professions in this state that have it, that have specific approval in their statutes, in their licensing act that allow them to do that. And the Ethics Commission opinion clearly only says, it says, unless there is specific authority in the statute, here's the general rule, we consider it a conflict of interest. And we've been back and forth since probably '95, I think, with the Ethics Commission about that, and we asked again in 2010, after I started with the commission. We asked again, say, well, we've actually restructured some things that they're not like they were in '95. We're going to, and so does that change the formula for you? And essentially they gave us the exact same answer. Unless it specifically says it in your statute, it's a conflict of interest. So, is that something that you think, this part of the strategic planning process, is something that you think needs to be addressed in the statute? Should we ask to have the statute changed? Many of the questions that come up, we will then...
Bless you.
God bless you.
Wow.
Bless you.
We'll develop a series of topics and questions and then bring them, and you will have involvement in that as well. And then we will bring them in February along with a proposed calendar for a series of public open sessions where we ask those questions of the public. And anyone who's interested can come, and we record it all, and we bring it back, and we slice it and dice it and put it all, try to gather all of that data together to come back to you and say, okay, here is in general the tone, the public tone out there, and if there's significant differences between consumers and practitioners, or one professional association versus another professional association, we let you know all of that stuff. And then do some analysis and then bring forth some proposals for what the strategic plan needs to look like. These are some suggested areas based on all of this research that we have done and the hearings, that process, which we encourage when a hearing is in your area. In fact, we really do, is to have board members and commission members and committee members, show up there and be available to listen directly to those comments from folks, and also, answer questions and offer your opinion as well. You're welcome.
Yes.
I participated in the roadshow last time, and we had an appraiser or two at every place that I went. And they didn't stand up and cry or anything, but they did make their presence known. And I think it's a good process from the commission side, just to go out into the field and hear. from the people. Not a whole lot of just public members, just humans, you know, but industry people.
I encourage us at a staff level that if you're going to be in our neighborhoods, that it can't be that much difficulty to pick up the phone and say, hey, I'm going to be in Lubbock, do you want to come on over? You know, because sometimes we get busy, and of course you probably put it out in a newsletter or something like that, but I think it is important for us to be at those meetings. We've gotten some feedback sitting in the ones we've been in, and I think it's helpful if the road show's in your neighborhood anyway.
And I went places way out of my neighborhood, but it was fun. Road trip.
It's a good idea.
Did you go to Odessa, Midland?
It did, as a matter of fact.
Well, and for some of ours, even if it's a conference or something, you can get feedback from the appraisers that they're not realizing they're actually giving us. They're just kind of belly aching or confused or whatever else, that we know that there's a problem out there, so.
It's good input.
And that's a very good point. Is, you know, it's the accumulated input that you have that has helped you to start, you know, to be more informed about the things that are happening, that may lead you to conclude that yes, in fact, something needs to be done about this particular thing. And if it's a statutory bar, if it's a rule, we're undergoing rule review as well. You'll hear tomorrow we're opening rule review. We're doing our quadrennial rule review. Not many agencies do it, but the statute requires it, and we do it. Or not enough agencies do it. Let me say it that way. But we're also going into the strategic planning period, and so that accumulated input. This is a good time before we do it. You know, we do it in the even numbered years, so that if in fact something comes out of there this board believes as a policy perspective really needs to be addressed in the statute, that message gets out to the professional associations, and we begin to build the coalitions to go to the legislature and have it addressed.
Yeah.
Is part of your strategic plan modeled or reflective of what's required from the LB or some legislature? You know how every agency has to have some form of a strategic plan that you're addressing objective.
Absolutely.
Okay.
Yeah, we use the same. We adhere to the same requirements that the governor publishes every February of or at least by 1st March of the even numbered year, and we follow that report. We're not required to now as SDSI, but everything we continue to do all of that stuff because we want to be measured by the same yardstick. Okay, we have more control over our financial future, but the rest we're still a state agency, and so we want to be measured by those yardsticks. We follow all those processes, file all those reports. Any other questions on strategic planning?
So when are you going to start something like this?
Next year.
It'll be in early January. We'll have the first, internal meetings, and we will also send out the request to you guys for topics. Anything that you think needs to be, in fact, before the staff, we'd actually like to have your stuff before the staff sits down to work on it, because you may say, we need some research on this particular thing to help us, determine. So, and then what our goal in all of that is to come up with a series of questions. That's really our goal, is questions on topics that you think needs to be addressed, so that when we go out to do our road show, if you will, we're asking those questions of the public, and it's always on our website, and people can go in and just type in answers, but they want to come. A lot of times they want to come and let you know how passionate they are about a particular thing, and that's great.
So when are you going to reach out to us to ask us for those questions?
You already know. You didn't get that email?
It will be. Let me say, January the 1st is a Wednesday. You'll have it by January 3rd.
Yeah, I'm just saying you will do that because I'm not going to remember.
No, I will do that. Well, absolutely do
Christmas
that.
Eve, you'll get it on Christmas Eve.
No, it won't be Christmas Eve.
I like
I'm gonna let you get through the holidays.
And then it actually might be nice to, at the future board meeting, to be able to hear what the other board members have thoughts about as well, before you do the strategic plan, or before you have staff do it, so we can.
So at the February meeting, we'll bring the questions that we're proposing to pose in the open meet, in the hearings, if you will, the road show. I need to come up with a good name for that, because it's not a hearing. There's not a quorum, but it's a listening tour is what we've called it in the past. On the listening tour, okay, the questions that we're going to ask. So we're going to propose those based on the input that you have and what we work on internally. But you're the ones that approve those questions as regard to the appraiser stuff at your February meeting. So it will not be put on the website until after you've approved them. And then the draft, so then we go do the roadshow, the listening tour.
Your public forums, you've already called them.
Public forums.
You have it, right?
They are public forums. Yes, public forums.
It's a great.
Very good. Thank you.
Question. Are these questions, you're asking for us to come up with questions,
Topics.
you think topics that are hot topics for appraisers, or people interested in becoming appraisers, or roadblocks they're finding to becoming appraisers? And how do we solve that how do we grow the numbers or increase the professionalism, or, I mean, it's just a broad range of questions?
Well, it needs to be things that, one, are within our jurisdiction, okay, and then something that's within our ability to expend resources to make a difference on. So, doing a lecture series in colleges on the benefits of choosing appraisal as a profession, okay, probably better for the professional associations. It's not something that, we're regulatory. I don't have a problem making all the information available to colleges, and maybe that's, one of the part that we can play is to let colleges know this information is available on our website. Things like that might be helpful. But there's a lot of, and you do as well when you're out there, hear things, and people will come to the meetings and say, you need to do more about diversity or people coming in the industry or whatever, and it's like kind of not really our job.
Yeah.
It's not really
To
part of our
complain
job.
about mortgage people.
ask
Yes.
a question about, I think I'm combining two topics that don't need to be combined. When one of our staff members went to go and speak and then it was retracted because he's not allowed to go speak, or because he was seeking credit for it?
No. That the invitation, the association that extended the invitation, after he accepted the invitation, then submitted a request for all of the attendees to get ACE credit,
From his speech.
including the 2 hours he was going to speak. So they had a full day, whatever it was, 6 hours, 8 hours, but including those two, which is why we most often go and speak at lunch. Speak over lunch because, we get to be a lunch speaker and they just subtract that 1 hour from the rest of the day.
That's important for me to know, because one of the topics that came up at the enforcement meeting yesterday was it possible maybe sending enforcement staff out to speak on hot topics.
And we do it all the time.
So, but they need to do that like at lunch. They need to, there's guidelines and.
Well, and there are a lot of associations that say, look, I got people here for 2 full days, okay? And so we're going to give you 2 hours. I want the commissioner to come and talk at lunch, but then I want people from 1 to 3 today to talk about enforcement stuff. And we'll send an attorney and an investigator typically to do that and answer questions. And as long as they don't ask for ACE credit for it, we go every place we're asked.
Okay.
Yeah.
The only problem is when after we've agreed, there's a follow-up request to education that says, we want ACE credit for the whole time, including those 2 hours they're speaking. and we gotta say, I'm sorry, we can't do it.
Is it just staff?
No,
No, board members as well.
board members too.
We've had that. Luis has went several times when ATA was forming up, and he would be invited to come. And so he went to Corpus Christi and he went to the Valley, some other places, and spoke about board matters. People wanted to fire questions, about enforcement and licensing and education and various things. And he's gone and done that, and we can't give credit for that either. So board members do that, but we also can't give credit for it. And that's part of it's covered in if we get authorization in our statute, I think it's a great positive, but that's just me. I think it's a great positive for board members, commission members, and staff to be able to go out and respond to all of these things. And it really is useful information for them, and it probably really warrants ACE credit, but that's...
I know, really, to have to sit there and listen to us, you'd think they'd get something for it.
So to do that, you're saying it's not possible unless it's
Not now.
In the
statute.
Not
Not
given
now.
credit, correct,
Not now.
unless
But-
statute says we have the authority to do it.
So are we talking about changing that, or are we saying it's out of the question, you can't change it?
No, that's at the wish of the board, it's at the pleasure of the legislature.
I know, but we'd have to take it up to the legislature and run it through that way. And we're not talking about doing that, or we are talking about doing that.
I think it's a topic that should be on strategic planning
Next
next year,
strategic planning.
and then you decide whether or not we should go to the legislature.
Okay, okay. Well, I think that, I agree with you. I think that would be very worthwhile.
But if you went out and everybody else in the world hated the idea, then you might decide, it's not worth going to the legislature for.
So we're kind of on
10.
Sorry.
10.
10 is slightly different, but are we done with 9, and then Doug, you can introduce 10?
Yes, and 10 is a very simple thing, because this exists today, okay? This exists today. For ACE credit, the state can adopt a policy that gives every certified appraiser, not licensed appraiser, sorry, this is an AQB rule, okay? That gives every certified appraiser up to, gives them credit for attending a board meeting. Not any board meeting, but a board meeting.
Every, including board members?
No, board members as well, but it would have to be a designated board meeting, okay? And it cannot exceed 7 hours.
That's okay with me. 7 hours, but I...
It cannot exceed 7 hours. But anyone else, so for that meeting, all of the appraisers who were at the meeting, including the board members and anyone else, but you have to have adequate controls for sign in and sign out and make sure they're there and all that, because you're giving ACE credit. But they get credit for being interested in participating in what the board does.
For example, Bobby Chris probably has accumulated 7 hours.
No, you can't accumulate. It's not accumulate. It's
Identify
one
a
meeting,
specific meeting that you're
and
talking
it's
about.
the specific
Okay,
amount of
so he has to
time
be there for 7 hours in one meeting.
up to.
Up to.
Bless his heart, he has.
If we said it's the February meeting of 2014.
Oh, we
Okay.
designate
Oh, yeah.
one meeting.
Designate a meeting.
Oh, we do.
Pick a long agenda.
Designate a meeting.
Or in one that's mostly associated with strategic planning, or.
Yeah, maybe the
Are you
May
trying to
meeting
have them-
or something where the strategic plan is going to get rolled out, and this is the point where we're talking about the draft and the stuff needs to be changed and emphasis and all that kind of stuff. Maybe it'll be a little longer. There'll maybe some input where people have been to the public forums and then now they're coming to see if their idea got into the plan kind of thing, or they don't see it in there and they want to complain or whatever, those kinds of things.
So since we're discussing this, if we like that idea, then we can put it on an agenda to be took action on later.
Correct. And because it meets the AQB criteria, and this is for a question for general counsel, I think we would want to safely put it into a rule, but I think we could probably do it initially by policy.
Who is on the education committee except Louise?
Walker.
And Keith Kidd.
And Keith, who's at Fort Knox.
So two of our guys are gone, so, yeah. Okay.
And,
I'm just thinking, if you had that in the agreed order, then they probably would never make another mistake again if they had to sit through one of our board meetings.
and as further punishment,
Yeah,
you
have
will
to come back
attend
to the February.
3 hours of
February
mentoring.
meeting.
3 hours of mentoring and the May meeting.
Oh, my God.
I was straightening them up real quick.
But anyway, I wanted to let you know that that was available, that AQB has that policy, and if you would like to consider it and adopt it, I think that's something you should debate the wisdom of and and decide.
Any discussion?
Yeah, well, you talked about Bobby Crisp. I mean, even Joe Waller is here all the time.
But they only can come to one meeting. I didn't realize it was just we identify a specific meeting, so.
Well, it's not accumulation of time.
It's
That's
not-
what-
You only get credit for one. I was very excited when I first saw it. It's like, no, you only get credit for a meeting and not more than 7 hours. It's like, wait a minute, if you come to 4, you've got the 7 hours taken care of. It's like, no, a meeting.
Could you work on
But the
getting
board-
CLE in there too, if you don't mind? Continuing legal education would be nice.
Is there, for our meetings?
Yeah.
I don't know. You have to talk to the state bar about
Yeah,
that.
I think it's.
So we, though, pick the meeting that is the one that, okay, so.
That's where I think you would want to establish a policy and maybe even put it into a rule so people knew. And then we would have a lot of people show up for that particular meeting.
yeah.
We advertise that. And especially if it became the kind of the same meeting every year.
And then it'd be on that master calendar I'm talking about.
There you
too,
go.
So we wouldn't miss it.
There you go. And on the new website, there'll be a master calendar that you can look down.
All right. So agenda item 12, discussion regarding motions for rehearing rehearings.
Yeah, motion for rehearing / rehearings. Okay, so I just handed out the portion from the OAG's 2014, they've got their 2014 handbook up. This is their administrative handbook. I'll go through some of the basics of this, but I wanted everybody to have this because on our agenda tomorrow, we do have a motion for rehearing. I'm going to go through the basics of it, and Ellen and Shannon and Patrick, if you've done this, can share any war stories if they care to. I know it's the end of the day. But I wanted to make sure, especially for people who don't deal with this, that you understand, first of all, the distinction between a hearing on a motion for rehearing and an actual rehearing. If you take nothing else away from today, it's that they are two separate events, okay? They can happen the same day. They don't always happen the same day. In fact, most of the time, well, it just depends on circumstances, but they are two separate hearings, okay? The board holds the hearing on the motion for rehearing, and they can grant it, they can deny it, or it can be denied. They cannot hold a hearing. It can be denied by operation of law by taking no action. If a motion for rehearing is granted, then there is an actual rehearing. That could take place at SOA, like we were talking earlier. If there's an evidentiary issue, then it gets remanded to SOA. If it's dealing strictly with a sanctions issue, then the rehearing will take place in front of the board. If it deals with the conclusion of law, it generally would go to SOA, but it could go before the board if it's on an issue where the board actually changed it.
If it's on a conclusion of law, the board, it really
Right.
does, it normally does not go back to SOA. Ever.
Unless it's evidentiary.
Unless it needs to be remanded.
Right.
For something like that.
Right.
But
So-
normally the board, and I don't mean to
No, that's what I
interrupt
said,
you,
it
but
really depends, but I
the
have
board-
seen one that went back that was concluded.
Right, and the board this would not be an evidentiary hearing before the board. Don't think that you're going to have a 2 or 3 day
Right.
hearing or even a 2 or 3 hour hearing with testimony and evidence and all that stuff. No. It literally, like Carrie said, the board decides whether to grant the motion for the rehearing. And then my understanding of this, the few times it's occurred, is if the board grants the rehearing, the board either hears basically argument of counsel at that point, or they set it for the next agenda. But it's not an evidentiary hearing with witnesses.
Yeah. Okay. So, for the most part, the procedures that agencies follow, I'm going to focus first on the motion for a hearing. So I just wanted to give the distinction between the two different parts of this. But the agencies, for the most part, follow the Administrative Procedures Act. If there's specific statutory authority or requirements that differ from the APA that went into effect after the APA, then those are followed. And we do have one of those, and I will get to that. But first, I wanted to go over, because the case that we have before us tomorrow is one where by our statute we are required to follow the APA in full, okay?
Excuse me, I know it's getting late today. What's the APA?
I'm sorry, Administrative Procedures Act.
Okay, thank you.
Okay, so what I've taken here, up here, in case you didn't want to read this whole thing, I just picked some highlights that I think it's important for you to keep in mind, okay? A party who wishes to challenge a final decision in district court, I put that because to make it clear to the people who aren't dealing with this a lot, if you want to get out of the administrative law process and go to district court, you must file a motion for rehearing with the agency.
Correct.
Which the agency can grant or deny either by action or by operation of law. If you don't, that is a final order, completely final, non-appealable. So you may think, you know what, we just said this is what it is, you know, this is our order that was just last time. What are they doing coming back talking to us? They have to. They have to if they feel that they want to take it beyond the administrative procedure hearing process, okay? So it's nothing, they're not saying, well, they may be saying if they keep going that you don't know what you're doing, but they have to if they want to appeal it, okay? And it doesn't happen that often. I don't know how many times this is the first time we've had one at the board level since I've been general counsel of the board. I think we're going to have one at the commission level in February as well. Okay.
Does that put us at different levels, the board level versus the commission level?
No.
Mm.
It depends on your perspective. I'm a glass half full kind of person. So, okay. A party has 20 days from the date of notification of the agency's decision or order to file a motion for a hearing. Unless acted upon by the agency, the motion for a hearing is overruled by law. 45 days, the APA says 45 days after the date of notification. And we'll talk about this later. I put this parenthetical in here. This is an exception that we have in our statute. We'll talk about it later. It's kind of a squirrely thing. I can postulate as to why that was done in our statute, but we do have that to deal with, not on the case we're going to be dealing with tomorrow. So just kind of put that to the side. I'm trying to keep it clean for now. The agency has no authority to rehear a case on its own motion after overruling a motion for rehearing. Once you overrule it, we have no jurisdiction. The district court has jurisdiction. Okay?
If anyone.
If anyone.
But you're saying we have no authority. Why would they bring it back to us then?
They have to.
Oh, they have to. You just said that. They have to bring it back. We have to
that's
deny
part
it.
Of the process.
And then they can go
You know
back.
why
Okay.
that probably developed, and this is just a total guess, but the courts wanted to make sure that the agencies cleaned up whatever mistakes they may or may have or not have that they would have done rather than wasting the district court's time and expense. And I really think that's what it is.
That is what it is. That's just like a motion for new trial in district court. But if someone knows that after they have an order by the board, like it or not, they're not taking it further, they don't care anymore, they can't afford a lawyer, they don't want to do it themselves, then they don't have to do a motion for rehearing. But if they decide later that they made a mistake, well, that the board made a mistake, and they want to go to district court, they will, and my office will go in and say, sorry, the court you have no jurisdiction because they didn't do a motion for rehearing.
Yeah, and they
Because
have to
that
do it
is
timely.
required by law.
I got you. Okay.
Okay?
So what you're saying again, if we approve a rehearing and it's over a decision we made last time, it just goes on over to district court then, right?
No.
No.
We deny it. Again.
Oh, we deny it.
We're not
We
making a
could.
decision on a rehearing. We're making a decision on a motion to have a rehearing. Think of it like that. The motion before you tomorrow is on a motion to have a rehearing. You can grant the rehearing or you can deny the rehearing. If you grant the rehearing, then the rehearing will take place either at that meeting or next meeting, depending on notice and all the other types of things, either before the board, or if it's an evidentiary issue that's allowed to go back to SOA, then it goes back to SOA. But what you're deciding right now, tomorrow, or anytime you get a motion for rehearing, is whether to grant the right for them to have a rehearing, or deny them the right to have a rehearing.
Right.
If you deny it, they have future rights in district court.
Okay.
Okay, that's important to remember. It's not like, go away, it's final, too bad, we're tired of looking at you. They still have rights. They can, and that's how they get to district court. Okay? And an agency's refusal, and this is a perfect segue, it's my next item, to grant a rehearing, it doesn't constitute arbitrary and capricious action unless there was a clear abuse of discretion, which y'all never have. I've been watching it. Even if the motion for rehearing is denied by operation of law, in other words, the agency gets a motion for rehearing and the board doesn't put it on its agenda, the board does nothing. 45 days later, it is automatically denied, okay? Even if you do that, that is not considered an arbitrary or capricious action by the board, okay? Then the one thing I want to say before I go into some of the more specific processes is generally the commission and the board have always wanted to hear the motions for rehearing. So we get them scheduled on the agenda when we can. There's some time frames in here we'll talk about in a second. There are some boards, and Ellen was telling me some stories about this, that they haven't even notified the board that a motion for a hearing came in, and they've just been lapsing by operation of law, and then they can go to district court. But really, the board at some level needs to be made aware of them. The policy has been notify the commission chair, get them on the agenda. There are times when time frames don't quite work, and then there have to be other things that go on, and we'll talk about that later in my presentation, because you got a taste of that when I sent you the email about doing it by vote, and there were some special circumstances in that. The board can decide to have a policy that they'll let the executive committee meet and deal with motions for a hearing, so the time frame doesn't lapse, or they always want them, as we do right now, just because we don't have any other direction, always try and get them on the agenda for the full board to hear. And that's something y'all can decide.
If I can ask some, are we going to be able to discuss this tomorrow?
The actual case,
Yes.
if you have any questions on that, will be tomorrow in executive session.
All right, well then maybe,
This
if
is an
you
overview.
can't answer this, okay, but it was my understanding that we voted on this the last meeting, and then it came up again in an email, and it seems like it was voted on then too. Is that not right?
I'll talk about that. We canceled the vote on an email, from the email.
Okay.
And I'll tell you why, yeah. And
Well,
that's a
I
procedure
remember
thing, and
this.
that's a good question. But yeah, so I'll get to that part. Okay, so the motion for a hearing must notify the agency of the error that is claimed, so that the agency can either correct or defend the error. So when we look at the cases that are going to come before you tomorrow, keep that in mind. Did the motion notify the agency of an error? Okay, that's step number one. If you can't get past that step, you have to deny it. Okay, and we'll go through, and there's a lot more detail in here. I'm just trying to break this down, but let me switch from those basic tenets of motions for a hearing and talk about the two different processes that you follow. The way the board's statute is written, we have two paths on motions for a hearing, depending on whether it's a denial of an application, an order denying an application, or whether it's an order for a contested case. So, in our statute, and I'll put these up here and I highlighted them, if the board denies a certificate or a license, then that is governed by Chapter 2001 Government Code, that's the APA, okay? That is where it says you have 45 days to act on it or it's overturned by law. There are, and now I'll address the email question. The problem when you have a situation where the board, and I think rightly so, wants to be the ones looking at it and not letting it just lapse by operation of law or be denied by operation of law, there are other time frames that are in effect. One is 90 days, okay? A state agency may extend the time to file a reply or to take action on a motion for rehearing as long as it's within 90 days. Unfortunately, from the 90 days from the time, and the APA does this all the time, it's always from the time the party or the attorney of record was notified of the order. So you're always coming backwards. And they'll say 20 days from this, 30 days from this. Well, then you realize this is just 10 more days, 90 days from this. So in this particular case, the 90th day was prior to the scheduled board meeting. So what do you do? So we did think about, since we have members who do not reside in Travis County, the board can rule on a motion for a hearing through mail, telephone, telegraph, or other suitable means. And that's what we initially were going to try to do. It was the first time we were doing this. There was a lot of confusion. Some questions were raised on some other issues, and then we decided there is one other provision in the APA, which if the parties agree, and with state agency approval, you can modify the times, this 90-day time, to take action on it. And that's what was done. So if you'll recall, or may not recall, we withdrew the email process. Hadn't really received, I think, but 1 or 2 responses to it anyway. And everybody agreed, put it on the agenda. So that's how it got on the agenda. So that's.
And when she says everybody agreed, she means the two parties.
The two parties and the state agency. So we actually had to get, and this is where it gets interesting with the various hats, okay? The board's the party, the board's the judge. So SES is representing the board as a party, and the board as the judge with the state agency approval, so we got both signatures on there. There's argument that you don't need both because the client is the board, but just to be clean and safe, just everybody sign it, it's better. So that's what we did, and you don't want to hear.
So this for tomorrow will just be for rehearing?
Just for to grant or deny whether there is going to be a rehearing. Think of it that way, to grant or deny whether in the future there is going to be a rehearing.
Which was what the email was also for.
Exactly.
Are y'all going to be able to advise, give us y'all's
Yes.
advice on this? Okay.
Yes.
Because I will listen.
And you're not now, huh? You shut it off?
This is the wife.
I'd like to talk about it now, but we can't.
It's only going to get a little more dry. So okay. So that's the what we're talking about there. Now, the difference in the process when you have an order on a contested case, and again, this may be something that we may or may not want to address when the statute is open, because technically, under the APA, contested case could include an order denying an application. But a distinction was made in our statute specifically for the application denial being governed by APA or 45 days, and a contested case Under our chapter dealing with contested cases and applicability on contested cases, we have something that says, except as otherwise provided in this chapter, a proceeding in this chapter, which is our statute, is subject to the APA. Well, in 519, it specifically says an application for a hearing, think motion for a hearing. Okay, the words are not great, but that's what they're meaning. It still has to be filed in the same time frame, but it's denied by the board. If you look at B under here, it's denied by the board if the board does not grant it before the 20th day after the commissioner is served with the motion for rehearing. So it's a little bit different time frame. That complicates things tremendously in terms of meeting that requirement to have action. So again, if something come in and it's a contested case, which we don't have right now, we're going to have to count days. When our 20 days are up, we're going to have to go forward to see, okay, is our meeting, because the 90-day provision for making a change to it would still apply because it's not addressed here, so that still applies. Do we fit within that 90 days? Normally we would. The reason we didn't this time is because, remember, we moved our meeting. We moved our meeting because of the Formula One. But normally we should always be within that. But because of the shorter 20-day time frame to act on it, it could be a problem. It's really complicated. So we'll walk you through this part again. I just wanted to make aware of it. That's not what's before us right now.
That's why you get the big bucks.
Yeah.
I'm sorry, but if we ever did have that, the application is denied if the board does not grant it. Can we not do that time provision too?
We could take advantage of either of those, but what I'm saying is the general counsel, more than y'all, needs to be aware of this and give direction and say what do we do, how do we do this?
And we may want to consider bringing them into conformance if we open the statute.
That's what I was saying.
So we don't have two standards, we just have one standard.
The other thing that I would say is the Enforcement Committee worked on a rule for motions for rehearing and finality of decisions. They go together, just not in my tongue. But it mimics a lot or borrows a lot from the APA and sets a procedure. Again, the only caution here I will say is this was written with the contested case in mind. So the part down here that said a board action on a motion, if not taken within the 20-day period, is overruled by operation of law, that doesn't apply to this case. We might want to amend this rule to make it clear that the procedures we've set out in here apply to application denials as well. I think we can still follow this as a procedure for how we deal with the motion for rehearing. I think it's very instructive. And I think the only part that really differs is this subsection C here. So in looking at the rule, and this was adopted about a year ago in December, it went into effect, a motion for rehearing, and this is again, when you're looking at the motion and making your decision, shall set forth the particular finding of fact, the conclusion of law, ruling, or other action that the complaining party is asserting causes substantial injustice and was in error. Okay? All of those words mean something, and they all come together in how you make a decision on a motion for rehearing. So that's the first standard. They've got to address something very specifically, and they have to assert that it caused substantial injustice and what that was. And then there's some examples are in this rule, such as violation of a constitutional or statutory provision, lack of authority, an unlawful procedure was followed, lack of substantial evidence, abuse of discretion. So all of these are examples the most likely examples. And the reason, for those of you that weren't involved when we were doing the rulemaking, the reason that so much specificity was put in is so that the transparency, so that people know. People who are filing motions for hearing, not all of them are going to have counsel. Usually, though, if you get to that level, you do have counsel. They know what is expected and what the board's standards are. So does anybody have any questions on that part yet? Okay? I'm just pointing out this last sentence here because this is your rule, and you need to make your decisions in accordance with your rule. In the absence of specific grounds in the motion, the board shall presume that the motion should be overruled. Okay? Any questions on that?
And just, can I interject something?
Sure.
To try to give that last sentence that Carrie just read some common sense, if the purpose of the motion for rehearing is to give the board, excuse me, the opportunity to correct any errors it may have made in its order, it can't do that unless it knows specifically what's being, what the problem is.
Yes.
So if the license holder doesn't let the board know that in its motion, what's the board supposed to do? If a license holder says, I deserve a rehearing because there's no substantial evidence and your order was arbitrary and capricious. Yeah? Hello? What am I supposed to do about that unless I know more? That's really the common sense way to look at that.
Yeah.
Okay.
So in absence of specific grounds in the motion, we should deny the motion.
Yes.
For hearing.
Unless we hear something different than what we heard last time, we better stick with what we did. Is that fair to say?
We can answer that today. Can't
Yeah,
talk about that
can't
today.
talk about that. But if
Can't
you
talk
have,
about it,
if you
yeah.
have a case and a motion for rehearing comes forward and they don't bring you anything new in that random case, then
Well, that's the way I feel.
then yes. And that's in
Ask
there.
that question in closed session tomorrow.
That's in there so that it doesn't become a free-for-all.
Have to do it again.
You have to understand, too, that the motion, the purpose of the motion for a hearing, another way of stating what Ellen said, is not to let them have yet another chance to bring you new evidence or convince you that, no, the arguments that you heard last time, I think I can restate them better this time. That's not the purpose. The purpose is there was some error that caused them, or some error or unlawful procedure or something in that laundry list of stuff that is causing them substantial injustice.
And omission is not in that laundry list.
Omission of what? Evidence?
A specific ground.
Right. But remember, this is such as, so.
Yeah, no.
Now, we will get to the new evidence stuff down here, okay? And that's what I would say, an omission. I didn't tell you this, okay? We're going to get to that. We do have in these rules procedures that were put in place. So a party may request oral arguments before the board. That is going to happen. Usually does happen, especially if it's represented, prior to the final disposition of the motion for rehearing. Okay, not the rehearing. We're not talking, we're just the motion for a hearing. We can have oral arguments that comply with numbers 1 through 5. And the first thing I want to note is the chairperson can designate someone to preside over that hearing on the motion for a hearing. So if you feel more comfortable handing it to chair of the enforcement committee or an attorney, you may do so.
Warn them in advance, though.
Yes.
Wake up. That's always
If
helpful.
you're planning on doing that, give them at least a heads up so they can study numbers 1 through 5.
Welcome to the board, Mr. Carlson.
If you see the gavel play at you.
So, okay. Number 2 is very important. Again, the first step is, did they even specify a ground? Second step when you get to the actual hearing is, it's limited to consideration of the grounds set forth in the motion. Okay, that's, if you get past step 1, then you don't get to open up everything on the case again. It's limited to what, the specific grounds in your motion.
Which is usually, you have to designate specifically under case law, and then probably also under the APA, I don't remember anymore, but you have to specifically designate by number which finding of fact or conclusion of law is in error. If you want the board to do something about it.
Okay? So, they can, at the hearing, on the motion for rehearing, you can take testimony by affidavit, documentary evidence, such as excerpts from the record. In other words, it's something in the record. It's not new. We'll talk about new evidence in a minute. Can be offered in support of or in opposition to the motion. Provided, however, a party who offers any type of documentation or an affidavit has to provide it to the other party in advance. So in other words, the other party in this case would be staff attorney. Okay? It wouldn't be the board. It wouldn't be me as general counsel. It would be staff attorney. They're the other party in this case. New evidence may not be presented on the substance of the case unless the party submitting the evidence can establish that the new evidence was not reasonably available at the time of the original hearing, okay? Or that the party was misled by another party about the necessity of offering that evidence. I'm not going to talk any more about this specifically, but remember this, we will talk about this very soon. Okay? Then, in presenting the oral arguments, whoever filed the motion, and this is general law room stuff, courtroom stuff, whoever filed the motion has the burden of proof and shall open and close. The party responding to the motion can offer rebuttal arguments. Parties can request, and this is mainly for whoever's running it, you need to know this. So whether it's Walker or somebody he asked to do it for him, you kind of need to know the process. They can ask for additional time, and it's at the discretion of the presiding member. I mean, if there's nothing new and you're just hearing it and they're going back and forth, you can say, heard enough, thank you very much. After being recognized by whoever's running the hearing, members of the board may ask questions of the parties. Okay? You're allowed to do that. Questions must be limited to the grounds asserted in the motion. So not only are the parties limited to the grounds asserted in the motion, board members are limited to the grounds asserted in the motion, because that's all we're talking about. Otherwise, think about this, every final order, if they think it's just a free-for-all to come back, no order will ever be final. They'll say, let's have another hearing. It's not a rehearing, it's another hearing, okay? And that, y'all will have more than 7-hour meetings all the time. And that's why this process is in place in your rules and in the APA. Upon conclusion of the oral arguments, you can have discussion, and the presiding member shall call for a vote on the motion. Here's something that's a little different, okay? Because remember, we're really acting like a courtroom right now. A member of the board need not make a separate motion or second a motion filed by the party, okay? The presiding member, when all discussion is done, will say, I'm calling for a vote on the motion for rehearing. And the presiding member may vote on the motion. That's specifically in our rules.
Perry, can I ask you a question?
Sure.
You said we call for a vote on the motion for rehearing. And so after you hear from both parties, someone makes a motion?
No.
No.
Motion's already made.
The motion's made by virtue of their
filing it.
making them, I got you.
Right. So it's a little bit different than all the stuff that we just went over and over about making the motion in the second and then having the decision. This is an exception to that, just to confuse you a little bit there, sorry. Okay. Motion will be granted only if a majority of the members present and voting vote in favor. In the event of a tie vote, the Presiding member shall announce that the motion is overruled. So those are similar voting procedures. Okay. Everybody clear on that? That's the main thing I wanted to go over was the procedure. There are other ancillary issues dealing with motions for rehearing and then rehearing and substantial evidence review, but I think we'll save that for executive session if and when we get to an actual rehearing, because I think that this is enough to digest right now unless anybody wants more. Gluttons for punishment.
I think that
This is very beneficial that
Please,
just get it framed that way, so tomorrow when it's presented
we still being recorded.
as detail,
Right.
like we're really
It's
doing
Miller
this
time.
now.
Right.
At least we have a frame of
Right.
what it looks like.
And it's complicated, and this doesn't come up very often, and it's a little bit different than your normal procedures. Now, when a motion for a hearing is actually before you, we will always go into executive session first so that you can ask legal questions on any of the, is this substantial ground? You're not expected to necessarily make that judgment call. You will eventually vote on it, but if you have questions about it,
Executive session.
executive session is where you would ask
So
those
before
questions.
the motion for rehearing, we will go into executive session.
Yes.
That's right.
If it's any consolation, every single board I've ever worked with gets confused about all this stuff because it is complicated and because it doesn't happen very often. So between one board meeting where it comes up and 12 years later where it comes up again, nobody remembers anything.
Well, this was very timely then.
Yeah.
I'm glad that that this is.
Yes.
But as a recap, if we grant the motion for rehearing, it can go different directions. It could be remanded back to SOA if there's evidentiary issues, or we could even hear it that day or a future meeting.
The hearing, you want the notice, this is the notice issue.
Okay, this Open Meetings Act, it'd have to be for the next meeting.
Well,
It doesn't
it's-
have to be, but.
Yeah, it's not just that, it's that under the APA, there's certain notice that has to happen.
Okay.
So the other party is ready to they might be ready just to say, okay, great, we're going to give you a hearing. I want some time to
Okay.
get my case
I
together.
got it.
And so likely, in this particular case tomorrow, it's not set on the agenda.
And then if it's denied, then they can appeal
Right.
to district court.
Right.
saying
But if
we
it's
need to-
granted and it's going before the board, you would see it at your February meeting. And that would be an actual hearing, and we would probably do a briefing sort of like this. Maybe I'd send an email, or Ellen would send an email.
Yeah, you can do it, Carrie.
Breaking
Though
it
you won't
out.
be with us anymore by then.
And then again, we'd go into executive session so you could ask specific questions. But if I go into that now, it'll just confuse the
It's
issue.
too much. and-
Yes. So that's all I really wanted you to get set in your head today. Any other questions?
Yeah, I have one for the chair. Are you planning on punting this or not, or do you know yet? I mean, don't punt it to me 5 minutes beforehand.
If I'm understanding, all we're going to
I
do
mean,
is
I'll take it, but not 5 minutes before.
and I was just looking in here, the executive session is agenda item 5 right before
The motion.
It's always before any of our enforcement actions, so that if there's questions on anything. Dealing
and
with
so
this
then
pending
agenda
litigation.
item 7,
Right.
would we have 2 executive sessions or just one?
No, we'd talk about
Everything
any
in
of
that
those
executive
things.
session.
Right.
And then, so then, if I'm understanding this right, I just say call for a vote on the motion for rehearing. And somebody,
No, because they have a right to have a hearing.
no, I mean, after we say, okay, the agenda item is a discussion of possible action on a motion for a rehearing, would you come
say
forward
representing
with
the
your
party.
legal counsel and make
Right.
your case? And we hear that, and I suppose our investigators
It would be the attorney,
give their part of the
yes.
puzzle, and then we just call for a motion for the rehearing.
You can have discussion. They may ask for a rebuttal argument. The presiding officer has to decide whether that's appropriate or not.
Yeah, you've got a little mini trial going on here is what you really have.
Okay, Shannon,
Well,
you're on.
but it's not going to take.
I think that's smart.
Well, before you turn and run in terror. When Mark inflamed matters by saying you have a little trial going on,
Transaction.
this typically does not take hours.
Yeah.
No.
It's again, this is typically
It's
just, it's
5
just.
minutes, 5 minutes.
Yeah, that's what I'm thinking, 5 minutes, and then motion for a rehearing. Well, I don't know how everybody's going to vote, but I'm assuming we know how they would vote, and you're done, but you
Right.
don't, okay.
It's just argument by each party
Yeah,
for
yeah.
5 or 10
Keep
minutes,
it to,
whatever
you get
you
5 minutes, you
give.
get 5 minutes, and then we're done, we're going to call for a
But-
motion. And
Unless they want a rebuttal.
Did I hear that? Yeah, that's right. The rebuttals and all that, but isn't the presiding officer also?
You can say no.
Yeah, you can say no. You can say that's not
Yeah, that's not
applicable to this.
germane to the motion.
Yeah.
That was not stated in your motion, and so that's an important role that the
Right.
presiding officer would play
Mhm.
in this.
And at
'Cause
the
you would-
same time,
you would be
the chair
deciding what's
can do it
admissible
with
or
your
not.
guidance.
Yeah, yeah,
too.
and so if it's
He
not
won't
in the
share
motion they
secret on
presented,
this.
well, I've got all this new stuff I
we
want to
can play
present.
role-
Can't
yeah,
do
play it
it,
out
folks.
for 'em.
Yeah, but sometimes the first time, maybe sitting and watching is a good thing if you're not familiar with the courtroom.
Because in 12 years, he doesn't plan on being here for the second time.
And always keep in mind, the board is never limited to just one executive session. That's right.
Right.
Yeah,
That's right.
yeah. But hopefully we'll cover everything we need to cover in the one executive session.
Hopefully,
That means
our
but
brains
sometimes
have to
stuff
remember
comes
all
up.
that. That's
I was
a
gonna
lot.
say, but what if something comes up and it just
You
bumps
can,
us off?
you can ask for it.
You
or
can call for executive ask to session. see if executive session is called for a second time.
You can just say,
Just do it.
Mr. Chair, I have a legal question for counsel. Okay. And then please can you call an executive session?
Yep. Done that one.
And that is not used for a bathroom break.
For what?
However, I could take one.
Yes, you could.
During that time.
I said that could not be used as a bathroom break, for which you can't just call for a legal question.
Well, not to
Because she
come
needs
full
it.
circle, but part of the abstaining thing is sometimes, or in that particular time that I did, it was because I wasn't clear. I'm not going to hold up the whole process because I had questions, I wasn't clear about something. So especially on something like this, I'm going to want to be clear.
Sure.
Okay. So is that it? Well, everybody as clear as mud on hearing and rehearing? Agenda item 13, discussion regarding action items from today to bring forward to future board meetings. And I think you made a note of a couple items.
Let me just verify, and some of these you might want, just to see what we've got on here. These might be things that somebody might want to bring up tomorrow under the board meeting thing, or
I mean, under
you
new
can just-
business.
Under new business, or you can just take it as recommended and make a note, and I'll make a note, and we'll put it on future agenda. But what I have is, the executive committee is going to be, on their next agenda, is going to look at the mentorship issue and the annual orientation / board workshop issue, and develop a plan to bring forward to the full board. The other things were more procedural, with the general counsel introducing cases and then having 2 advocates, if appropriate, giving their sides. Another procedural thing that's not really a board item is the staff reports, maybe having focus points on reports and just asking questions in the future. And that is all I had made note of. If there's anything else that anybody wants to talk about today, or they can do it tomorrow.
Number 10,
I have-
item 10.
Item 10.
Yeah, that was the discussion regarding ACE
Oh,
credit
right.
for attending
Right.
residents.
Right.
Education?
Right.
board or committee ready to look at?
And that might be something, since, well, you're on the education committee.
Oh, okay.
Sure.
So
Okay.
just make sure that that gets on the next agenda.
Sure.
Just kind of.
It's not something we need to put on our agenda for, we just put it on the agenda for the education meeting. We don't have to put it on tomorrow's meeting for the next quarterly meeting.
Correct.
No,
Because we're going to have another educational committee
right,
before the next meeting to talk more about the,
right. So just,
The other
I'll make
questions.
a note, you make a note,
Yeah,
and
yeah,
and
okay.
we'll get with Louise.
so that's
and
going to be
make sure
this,
it's on
that
there.
would be the same process then as the executive committee as it pertains to this mentorship/workshop.
Right,
We'll just make a note of telling the executive committee before the next meeting, we will have that on our agenda.
right.
So really, so bottom line is, off of today's discussions, we don't have anything necessarily, other than we're going to put these on subcommittees' agendas for
Right.
future subcommittee meetings
Right.
that we'll then bring back to the full board for action.
That's what I have.
Well, all right, so does anybody have anything else? Oh, you do, Doug.
I had two other research issues, just to, that I wrote them down, just to remind you that there's questions that came up, and that was to research and see if we can find Robert's Rules classes or other materials to expand the binder. And I know Ms. McLennan has a recommendation for some other things to put in the new binder.
I'm actually already working with Tony on that. He
Okay.
was kind enough to tell me that he's already put together a product, and I can compare my list with his list.
Great.
And not to sound partisan, it's just my knowledge of, there are different Republican organizations that provide free Robert Rules training courses. Probably some Democrats out there, I just don't know of them. And
We were all
and
appointed
they
by
may
the
not
same
be right.
governor. Come on.
But I'm just kidding. But there are some folks that really want you to understand the process. So
And the last thing was a procedural thing that we did agree to today, and that is that the general counsel will have, not for tomorrow's meeting, well, maybe for tomorrow's meeting, but certainly future general counsel for future meetings will have the information on, for agreed orders, whether the respondent, what level of, whether this is a first, second, or third offense.
Thank you.
But none of, I'm not hearing that this needs to be on an agenda.
No, that's procedural, we've already agreed to.
Can I, may I ask one more, just, I'm curious question?
You bet.
How is the procedure to fill Carrie's, that position right there? What's that gonna look like, and what input are we gonna have, like, as, are we gonna have anything?
The, when we do the interview, okay, the position is open right now until December the 2nd or until filled. So the first time we're going to look at all the applicants is December the 2nd, okay? Then both Carrie and I, and we will invite the chair or a designee. If, I mean, I don't expect him to fly in from El Paso if he wants to have someone else sit in. And that's just always a courtesy to the board, have a board representative for the very high level. We did this for the general counsel for the commission position, and Ms. Wukash came for that as the chair and sat through the interviews. Participated in the interviews, not just sat there, not an observer.
Actually, we need arm wrestle.
Not an observer, but a participant. So there will be the chair or designee invited to be a participant in the process. Yes.
I had asked Carrie that question, I just wanted to get, like,
Yeah.
because I was curious.
I was curious.
So.
And there was one other, where did I write it down? Of course, I already forgot it. Sorry. It may come to me. There was one thing I needed to say before you guys left today. Sorry. Thank you for coming. Yes, we really, really, really appreciate all of your time. No, we do. We do.
And I'd like to say,
We're
if this is
adjourned? Is that
appropriate.
what you'd like to say?
I think
Yeah,
I think
we're adjourned.